Hadn't been.
It hadn't been?
No, this would have been his first hearing.
Okay.
This is a new case.
SMU, can I get somebody from SMU, please? Good morning. It's my understanding that Mr. Rivera is now housed in your institution. It's my understanding that also that the judge will be signing an order transferring the case to that county. So we won't be hearing Mr. Rivera's case today.
Okay, so you don't need him.
No, ma'am. Thank you.
Okay, that'll be fine. Thank you.
Thank you. Good morning, Mr. Burnett. Can you hear me?
Good morning. Can you hear me?
Yes, I can.
All right, excellent.
Do you have a preference on the order that we proceed in?
Yes. And is Mr. Crowder in yet? No, not yet. Okay.
No, I don't see him.
Okay. We wanted to go. Let me see. Take Mr. Zell's cases first. I believe we want to do. One second. Let me pull that up real quick.
Whose case first? I'm sorry.
Raymond Baker.
Baker. Let's see which thing that is. I didn't get the whole thing.
He's at Smith State Prison.
Okay.
Item number 8.
All right. Any other preferences?
Yeah, we'd like to go ahead and get the cases that Mr. Zell, the attorney, has first. So that'd be Baker, then Lawson, and then Marie.
Lawson being item number 4. That's not. We'll do that one second, and Marie, item number 6. That'll be 3rd. Any others?
And then I guess then we go to the witness cases. We do Rivera for next.
Rivera.
Or is he?
It's the one that we want.
Yeah, Rivera. It's my understanding that he's been transferred, so
Okay.
that case is going to be transferred.
Okay. Mark that. And then Bell, Highsmith, and Weaver.
Bell.
Item 15.
Item 15. Let's see.
He's on page 6.
Page 6.
The bottom.
Bell.
That'd be number 1.
Bell's 15.
Okay, this is master.
Yeah, number 5.
My glasses fogged up. Crazy. Let's see. That's number 4, I think. Number 6. Number 4. Okay. Highsmith.
Smith's on page 4. 5.
Yeah. 5. I don't see that.
Smith's on page 6.
Highsmith, item number 9.
Yeah, and
Weaver is item 13.
item 13. Okay. So that will be item number 6, right?
Yep.
Okay. All right. Well, I'll get with the judge and see if that's okay with him, and we will get started.
Thank
you.
you. Okay, sounds good.
Make sure.
Sir. It's Hector? Hector.
Yes, ma'am.
Inmate, Roderick Bell, that is, here at Smith State Prison, he's saying that he spoke to his attorney yesterday and his is gonna be continued because his attorney's not gonna be present. Are
Roderick,
you-
yeah, pull that one up, see what we got on that. But let me pull up the file and we'll let you know, okay?
Okay, thank you.
All right.
They don't have attorney.
You don't have an attorney?
He's pro se.
Okay. Ms. Cece,
Yes.
he doesn't show an attorney of record, in the file, so we'll just, if he wants to ask for continuous, he can ask, and the judge that'll be up to the judge.
Oh, okay, well, I just noticed that he was on down in the line and he was just sitting up there and he was saying that, he's like, he was wanting to go back and I'm like, no, and he said, well, I talked to my attorney, Mark, your check, and he said he wasn't gonna be there, so that's the reason I was asking, but that's fine, you just sit and wait.
All right, yes, ma'am.
Thank you.
There is an attorney that's your check,
Oh.
but I don't think it's for him. I hadn't gotten a notice of appearance or anything, so I don't know.
So the
Mark
last two,
Yuracek is
9,
his name, I think.
Okay.
last two is 9 and 10, right? Is that?
I think so, yes.
Okay, all right. Judge,
There was transfers at
this
9.
pay process
Well,
is
it comes
proceed
from-
in a certain order.
Yeah.
Where did you get 9 and 10 from?
I'm sorry?
9 and 10?
Those are the last two, the items.
There were 9 transfers, was there?
Yes.
So it'd be just 9.
9, yep.
Oh, okay.
That is right. I didn't want that.
Hey, I wanted to know that he's your attorney. Your check is your attorney? Represent yourself.
All right, so we'll be doing, Mr. Baker, item 8 on the calendar first. Was not on yet.
Is Mr. Zell in yet? He's Mr. Baker's attorney.
We don't have him on yet.
Seriously.
Oh, yes, sir. Thank you. Yeah, I don't see Mr. Zell, and I don't see the witnesses for that one either.
I believe Mr. Rowe is witness for Mr. Weaver, but we don't have Mr. Zell. The one I do see that we do have a witness for that is pro se is Josh Weaver, number 13.
Okay. The GSP. We can do that one. GSP, can you have Josh Weaver ready, please?
He's a lockdown offender, sir, and they're actually bringing him down right now as we speak, but I don't have him available right now.
Okay, all right. Okay.
I know Burnick is the AG's office.
Correct.
And what about Crowder?
He's a witness on
He's with.
I think the Weaver case.
The, oh, okay. Well,
And
I believe. Pretty sure.
I may have given the judge the wrong phone.
And just for your information to handle the witnesses, Mr. Richmond Winkle is our intern. So he's not a witness, but he's an intern watching the proceedings.
Okay.
We have somebody from Rogers. So do we know who this is? Well, we've got somebody from Rogers and somebody from Smith.
Okay, who do we have ready at Rogers?
Maury, sir.
Maury. That's Mr. Zell, I think represents him.
But we don't have Zell.
We don't have Zell. Zell's not connected. Number 6.
Do we have a number to get in touch with Mr. Zell?
Let me
I think
call the
there
number
is.
on the bar website.
I've signed a lot of continuance orders, and my next date is June 23rd. Is that right?
That's correct.
Okay, I can fill those in.
I thought I was giving you the wrong file, Judge Rose.
That's
Yes, Mr. Zell? Yes, this is Hector from the 11th Circuit on Judge Rose's law firm. Okay, let me pull up the, how are you trying to log in, sir?
these are a bunch of orders, continuance orders, et cetera, that I was given yesterday.
Okay, and the event number that you have is, just to confirm, it's 142-933-2854. Okay. All right, what's your email address? I'll send you an invite to your email address. Let's do it that way. Zell. Yeah, Rachel's no. Oh, okay. Yes, sir, thank you. Okay. He's having problems connecting, Judge.
Is he?
Weaver.
Good morning. Excuse me. I have offender Weaver from Georgia State Prison.
You want to go ahead and do that one, Judge?
Yeah, it doesn't matter, anything they're ready on.
Go ahead, Weaver, let me lower the witness. Weaver is 11:30. All right, we're proceeding with Joshua Weaver, item 13 on the calendar.
Mr. Crowder is not the witness in that case?
No, Mr. Crowder's AG. Mr. Crowder and Mr. Burton.
Oh, they're both the agents.
Ms. Herring's a witness.
And I'm on, Hector.
Yes, sir. Ms. Herring, can you enable your camera so we can do a video check with you? Ms. Herring, do you hear me? There you are. Let me unmute you. Hold on.
Okay, there you are. It wouldn't let me unmute or start the video.
All right, there you go. We got you. So we got everybody. You ready?
All right, I'll go ahead and call the case. This is case number 2020 HC 32. Joshua Weaver is the petitioner versus Provanza Bobbitt Warden. I believe we have everybody here ready to proceed. Mr. Weaver, are you ready to proceed this morning?
Yes, sir.
All right, then, Mr. Weaver, the first thing I'm going to do is administer the oath. Please raise your right hand. Do you swear or affirm that the evidence and testimony you give this morning will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
All right, I'm going to let Mr. Burnick outline the case before we begin. Mr. Burnick, if you would, please.
Yes, Your Honor. This petition was originally filed on July 20th, 2020 in Tattnall County. This is the first thing in the case. Mr. Weaver is challenging his 2016 Fulton County negotiated plea convictions for theft by taking, robbery, possession of a firearm during commission of a crime, and willful obstruction of a law enforcement officer, which was a misdemeanor. He pled guilty to 3 different indictments at a November 9th, 2016 guilty plea hearing. At that hearing, he was represented by Ms. Kenya Hearing, out here as a witness. And I'll go through his grounds. In his original petition, his first ground was that he claimed ineffective assistance of counsel and that guilty plea counsel did not provide him discovery in the case, and thus prevents him from knowing of his identification. Ground 2, he claims that the evidence was insufficient. Ground 3, he claims the misidentification of the victim never identified anyone as a gunman or participant in the robbery. Part 3, on the misidentification, the lawyer and I never had a chance to discuss my case. I was not present during the preliminary hearing, so I knew nothing about the case. Insufficient evidence that never stated discovery, and which will let me know my case entirely. He submitted amendments to his petition, and his first amendment ground, or his first ground amendment, is ineffective assistance, and that guilty plea counsel failed to object to the error of the district attorney and notify him of the grand jury proceedings in which he was indicted. Amended ground 2 was ineffective assistance that guilty plea counsel entered his habeas corpus approach by not filing a motion to give back the plea within the proper statute of limitations. The lower courts also failed to notify him. His third ground amended petition was that ineffective assistance in that guilty plea counsel failed to contest the prosecutorial error of the district attorney in not including the lesser offense of hijacking a motor vehicle and armed robbery, yet charging with theft by receiving stolen property, which are contrary to each other. Amended ground 4 in that guilty plea counsel failed to file a motion discovering providing with copy discovery so that could have known the evidence against him before taking the plea. His fifth amendment ground, guilty plea counsel failed to advise him of first offender status and allow him to plead guilty 3 times without it. In ground 6, he again claims that the evidence was insufficient. Ground 7 of the amendment petition, he claims misidentification, that the victim never identified anyone as a gunman or participant in the robbery. And those are the grounds that he has submitted before the court, as we understand them.
All right, thank you. And Mr. Delgado, had a little trouble with his audio. Do you know what the issue?
Not sure, sir. Mr. Burdick, we've had trouble in the past. Is there any way you can call in and, I mean, with your,
I can call in if that helps. Yeah, I'm having a little trouble with my computer audio, so I'm trying to use headphones.
If you would, do you know how to do that? Do you need me to walk you through it, or?
Can you give me the phone number?
Okay. If you click down, there's.
Wait. You're right. There's someone here.
Yeah. If you click under your mute button, if you see mute, unmute button, there's a little arrow pointing down. You click it, and then you click switch audio.
Okay.
And then.
Let me try that.
And then you click on call in. It'll give you the phone number, your access code, and attendee number.
Can you hear me? Hello?
Yes. Yeah, that sounds better already.
All right, you can hear me? All right. I'm going to put this on. Okay, I don't know this phone number, so I'll just go ahead and do it this way. All right. Go ahead.
All right, and do you have guilty plea counsel here as a witness?
Yes, Your Honor. We have Ms. Kenya Herring here as the witness.
All right, Miss, do you want to go ahead and call her?
Yes, we'll call her as a witness.
All right, Miss Herring, please raise your right hand. Do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may proceed, counsel.
Yes. Good morning, Ms. Herring. Could you please state your name and business address for the record?
Kenya Herring. My current business address is 3200 Windy Hill Road, Suite 925 East, Atlanta, Georgia 30339.
And how are you currently employed?
I am a senior trial attorney with the Law Office of Nancy Phillips at Allstate Insurance.
Okay. And what year were you admitted to the Georgia Bar?
1996.
And since becoming a member of the bar, how have you been employed?
I've been with Allstate now since July of 2019. Prior to that, I was an assistant district attorney in the Coweta Judicial Circuit. Before that, I was a senior trial attorney at the Public Defender's Office in Fulton County, which has since been renamed the Office of the Public Defender, Georgia Public Defender Standards Council.
Okay.
Actually, I think they changed it again to Georgia Public Defender Council.
Okay. And did you recall representing a petitioner on these criminal charges around 2016?
Generally, yes.
General. Okay. And at that time, you were employed with the Public Defender's Office or Public Defender's Council in Fulton.
Yes.
And so, would you say 100% of your practice was devoted to criminal work?
Yes.
And at that time, about how many trials had you handled?
Oh gosh. I don't know. Dozens.
Dozens. Okay. And those would be felony trials?
Yes, they were all felonies, murders, armed robberies, aggravated assaults, things like that.
Okay. And at the time, about how many guilty pleas had you handled?
Thousands, more than I could count.
And do you recall what point in the proceedings you had entered into the case?
No. I mean, the case was existing when I came along. I think I got the case from, I think Brian Hobbs might have been the attorney before me. I'm not entirely sure. But the case had been going on for some time before I entered it.
Okay. And do you recall the nature of the charges against the petitioner, Mr. Weaver?
Well, I wouldn't be telling the truth if I said I had independent recollection. I did look over the transcript and see there were 3 cases. Also looked back over little notes I used to keep from court back then. He had 3 cases, and apparently I had negotiated something with Han Chung, who was the DA back then, to handle all 3 with parolable offenses, I believe, because there was some non-parolables like hijacking and armed robbery, and I think we negotiated them down to something that was parolable. I think.
Okay. And if you remember, do you recall preparing or investigating this case at all?
I don't remember specifically preparing the investigation part. I think that part had been done before I got the case. Because this was when I was in Judge Downs' courtroom, and I think I was only in there for about 6 months. So I believe the bulk of the work had been done on the cases before I took them over.
Okay. And did you at all receive discovery in this case?
Yes, there was discovery in the files.
And did you review that discovery?
Yes.
And did you meet with a petitioner at all during this case?
Yes.
And what did you meet with petitioner, and what did you discuss during those meetings?
That we were trying to, that I was trying to negotiate something for all three of the cases. And I look back at my notes. I remember him saying he had certain things he could raise for defenses for certain charges. And we talked about it. And I said, well, unless you have defenses for all of the charges, you could win on every charge, lose one of the hijacking charges, and still go to prison for life. So that I believe that was the crux of the discussion. The specifics beyond that, I can't recall.
And you would have discussed the evidence with him and the discovery with him?
Yes.
Okay. And do you recall any evidence about the identification in this case?
I remember his mom telling me that there was a case of mistaken identity, but beyond that, I don't remember what the evidence of mistaken ID was.
Okay. Second. And you discussed the weight of the evidence with Mr. Weaver?
Yes.
Okay. And so you would have discussed the possibility of trial with him?
Yes.
And you discussed the possible range of sentences with Mr. Weaver?
Yes.
And you said you negotiated this plea offer. Were there any other plea offers made by the state in this case?
So there might have been, but if there were, I don't remember.
And would you have communicated the plea offers to Mr. Weaver?
Yes, we're required to communicate offers, good, bad, or ugly. So yeah, I would have told him.
And do you think he understood the plea offer that you communicated to him?
At the time, he indicated he did. And he was young. I think he was a teenager still. So he indicated he understood.
Okay.
So as far as I know, he did.
And whose decision was it ultimately to enter the guilty plea?
So ultimately, it was his decision, and Judge Downs was really a stickler for that because we would end up doing the colloquy twice. The DA would do the colloquy, and then she would do her own colloquy because she was really concerned about the defendants, especially the young ones. She would take an active role, kind of, in sometimes even in the work negotiation, she would kind of take a sideline role, but in a plea, she was always active to make sure they understood. She always answered any questions they had. So yes, I guess long answer to a short question. Yes.
And prior to the plea hearing, did you inform and explain to Mr. Weaver all of his constitutional rights he'd be waiving by entering a guilty plea?
Yes.
And did that include that he had the right to a trial by jury?
Yes.
And did he understand and agree to waive that right?
He indicated he did, yes.
Okay. And did you inform and explain to him that he had the right to confront witnesses?
Yes.
And did he understand and agree to waive that right?
Yes.
And then did you inform and explain to him that he had the right not to incriminate himself?
Yes.
And then did he understand that right and agree to waive it?
Yes.
And prior to the guilty plea hearing, did he have an opportunity to ask you any questions about his rights?
Yes.
And did you recall any questions he might have asked you or concerns?
I don't remember specifically. I think, if I'm not mistaken, the biggest thing was something that could be parole, but I can't be certain that.
And at the time of the guilty plea hearing, were you satisfied that he entered his guilty plea knowing and voluntarily?
Yes.
And were you satisfied that he knew and understand what he was doing?
Yes.
And were you satisfied that he knew and understood the consequences of what he was doing?
Yes, I guess as well as any teenager could. Yes.
And then following the guilty plea hearing, did he ever inform you that he wanted to withdraw his guilty plea?
Not that I'm aware of. Although, to be fair, I did go out on medical leave maybe I think the day or two after his plea, I went out on
Okay.
medical leave for 3 months.
And would someone else have been assigned to that case when you were out on medical leave?
Yes.
Okay. I'm just going to go a little bit back over the grounds a little bit, and then I'm going to go a little bit to the misidentification or the identification. And you had stated that you reviewed this issue with petitioner.
I'm sorry, did you repeat the question?
Did you review the identification issues in this case with petitioner?
I believe so, yes. I think one problem we had was when he was arrested, he was driving the car that had been stolen. So it's kind of hard to argue mistaken ID when they actually take you from the scene.
And you would have discussed that with Mr. Weaver?
Yes.
Okay. And do you know of any in Fulton County any problems with any issues with the grand jury system that would have made it void, the indictment void, such as being closed?
No.
Proceeding? Okay.
No, the grand jury proceedings in Georgia are closed as a matter of law. That wouldn't have been anything specific to him. No.
And then would you have reviewed first offender status with petitioner?
Yes, we would have talked about that, especially for someone his age, and Judge Downs too. But I think I asked for it, and she said no. I have to take a little look at the transcript, but I believe I asked about consolidating him into one plea and letting him do first offender. Let me look at the transcript and make sure I'm not wrong about that. But we definitely would have talked about it. Yes.
Okay. And that's the questions I have for right now. Thank you, Ms.
And I know
Herring.
you can't see me, but I'm flipping through the transcript, so
Okay.
you need to know what I'm referring to.
Okay.
Ms. Herring, I'm going to give you a chance to review the transcript and then finalize your answer with regard to that question.
Okay, just 1 second.
I'll be able to pull it up.
Excuse me, Mr. Alex.
All right. Hold on just a moment, sir.
Let's see.
I believe page 18 and 19 might be, and I can pull
Yeah,
that
I'm
up.
just getting there now.
I can pull that up for the court, just so that everyone sees what I'm looking at also.
Yes, I asked her to aggregate the 3 for purposes of trial so he wouldn't be a recidivist, because 3 convictions would make him a recidivist in Georgia. The DA objected to that, and the court refused to grant that. She said she was just going to let him plead to all 3.
Okay.
And then she explained to him that he would be a recidivist after these convictions.
Okay.
All right, Mr. Weaver, you now have a chance under the law to ask questions of Ms. Herring. Those questions have to be relevant to the claims in your petition. You may proceed.
Yes, sir. I had spoke with a paid attorney, and he told me that it was like a good deal not to proceed only because I would be paroling in September. So he told me it wasn't a good idea to proceed, like all the evidence that we reviewed.
Do you have any questions of Ms. Herring?
No, I don't have any questions for her. I just read this on.
All right, well, you just heard her testimony, correct?
Yes, I just heard her testimony.
All right, and you don't have any questions?
No, I don't have any questions for her.
All right, then Ms. Herring, Mr. Burdick, unless you have an issue with that, I'm going to excuse Ms. Herring.
She can be excused, Your Honor.
Ms. Herring, thank you very much. Have a good day.
Thanks. Good
Thank
to
you.
see you, Alex. Take care.
Good to see you.
Bye.
All right, Mr. Burnick, do you have any documents you wish to introduce at this time?
Yes, we have documents, and as we said, there are three different cases in this in these convictions. So we have 7 documents. Just bear with me.
Right.
The first is the indictment R1 of case number 16 SC 142882, and R2 will be the disposition sheet and the sentence sheet. I can flash those up on the screen if that helps.
And Mr. Weaver, we're really flashing these up so that you can see them. These are all documents in your case, and they're going to become a part of the record. Do you understand?
Yes, sir.
Okay. All right, so please take a look at them as they are placed up on the screen.
And I believe your staff trainer let me share my screen, so I could do that. That might be easier.
Mr. Burdick, you can proceed. We made you a presenter.
Okay, I'll just keep doing it. And then R3 and R4 are going to be the indictment and the sentence sheet, respectively, of case number 16 SC 143260. And this is the indictment, and this is the sentence sheet. And then R5 and R6 are the indictment and sentence sheet for 16 SC 143441. Here's the indictment, that's R5, and R6 is the sentence sheet. And finally, R7 is a transcript of the guilty plea of the 3 cases altogether.
All right, so respondents exhibits 1 through 7, those are all the documents?
Yeah, that's all the documents. Sorry. Yes, Your Honor.
Okay, Mr. Weaver, do you understand that?
Yes, sir, I do.
All right, I'm going to admit those into the record. You'll receive a copy of all of that along with the transcript of today's proceeding. You understand?
Yes, sir.
All right, before we close, do you have any, do you want to testify or introduce any evidence?
No, sir. I do want to say that like if you do look at my indictment, you would see that like she represented me and my co-defendant. I don't know what she was saying when she said that it was somebody before her because she was the first person I met, and like she said, she didn't give me the discovery herself. She just just told me about it. Like she didn't give me the discovery. I was only 17 years old at the time, like really just turning 17. So I didn't know anything about it at all. And like, if you read the transcript, he said that he didn't identify me at all. He said that the people who robbed him were like masked up, like, so he doesn't know who robbed him. And then at the time, I was not the driver. I was in the passenger seat of the car. I was not the driver. I was somebody who got picked up, and like then all of this happened and it occurred, and I was trying to explain to her that, and I didn't want, and I wanted to go to trial in that case, but she explained to me like that they wanted to go to trial on all 3, and like the only one that I had a participant in, it was like with my sister's boyfriend, but like if you look at the transcript, it was like a juvenile fight, like that's what really occurred, and like that's what she was trying to tell the judge, like there was no longer, and all my co-defendants were like, the case was dismissed on everyone but me because of the other charges that I had. So that's why I was scared and really enter these pleas on things that I didn't even do. But I'm parolable like in September, so that's why when I talked to my lawyer, he told me like it would just be a good idea to just back out. And I was like, I didn't want the convictions to become permanent after 4 years, but I would go ahead and back out because I didn't want to do any more time that I didn't have to do. But that's ultimately what I came to a decision as.
All right, Mr. Burnick, do you have any questions of the petitioner?
No, Your Honor.
All right, well, at this time, Mr. Weaver, the record is going to close, but I'm not sure I understand. You keep saying you want to back out. Are you saying you want to dismiss this petition? What are you
Yes,
trying?
sir.
Okay,
Yes, sir. I'm trying to dismiss the petition.
you do want to dismiss the petition.
Yes, sir.
All right, I assume there's no objection from the respondent, Mr. Burnick.
No, Your Honor.
All right, would you like to prepare an order that
We could just, yeah, we can prepare an order.
All right, well, Mr. Weaver, Mr. Burnick is going to prepare an order that dismisses your petition. This is with your consent and with your approval. And are you sure that's what you want to do at this point?
Yes, sir.
All right, then the case will be dismissed, and Mr. Burnick, if you'll prepare the order, we'll perfect the record.
Okay, sounds good. Thank you.
All right, the hearing closes.
All right, bye.
Next, we'll do Raymond Baker, number 8 on the calendar. All right, Giselle, can we do a mic check with you, sir?
Yes. Okay, I just unmuted me. Can everyone hear me?
We can, sir. Mr. Rowe, can you enable your camera and can you say something to make sure your mic is working? Mr. Rowe, can you hear me?
Yes.
He's not responding.
You're breaking up, sir. I could hear something. Let me see. Can you enable your camera, please? Maybe your connection, sir.
Hello?
Yes. Can you say something, sir?
Mr. Bill.
It's his connection. Yeah.
Hey, Mr. Baker.
Can you try to reconnect, sir? Because it's your connection that we're having a problem with. Hear me, Mr. Rowe? Yep. Okay, let's see which other one.
Oh, I do have it.
Mr. Rowe right there, but. Yeah, let me see which other one we could do while he reconnects. Mr. Zell is the attorney. Let's see, it's item 8.
Okay, when I take it off. The other one is the camera. When you turn it on, it comes up. Yeah, when I turn the camera on.
It's muted. It's Mr. Zell. Just trying to see who. And let's see which one was number 3. We'll just move on while Mr. Rowe resolves his issues. Number 3, that is item 4. Yeah, GSP. No, they haven't brought him in. Herman Lawson, GSP. Latoya, can you please bring Mr. Herman Lawson?
Yes, sir.
Thank you.
Lawson.
Yeah, because Mr. Rowe cannot connect.
They have somebody there at the prison that can work on that?
Well, he's a witness, sir. He's a witness, Mr. Rowe. No, I'll message.
Good.
I have offender Lawson, sir.
Thank you very much.
He's GSP.
Yes, sir.
It's item number 4.
Ms. Collins, can we do a sound and video check with you?
Yes, sir.
Can you enable your camera, please, ma'am?
Yes, sir.
There
Got
you
me?
go. I see you now. All right. We'll proceed with, I don't have him here. Showed up yet. All right. We'll proceed with, Mr. Lawson, item 4 on the calendar.
All right, I'll go ahead and call the case. This is case number 2018 HC 72. Herman Lawson is the petitioner. This is James Deal, the warden. Petitioner. Crowder is who's representing the respondent?
I am, Your Honor.
Mr. Crowder represents the respondent. I believe we also have a witness in this case. Is that correct?
Yes, sir, I'm here.
All right, Mr. Zell, any problem with having the witness testify first?
Let me unmute him.
Appellate counsel are under subpoena, and as far as I know, available. Both said they would be here. I know Ms. Collins is here. I've just notified Mr. Oden, who is the trial counsel. He's a public defender in Fulton County that we're starting, so I don't know if he hasn't checked. It doesn't look like he's checked in.
Well, do you want to go ahead and proceed with the testimony of Ms. Collins?
Yes, Judge, that would be fine.
All right, Ms. Collins, please raise your right hand. Do you swear or affirm that the testimony and evidence you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
All right, counsel.
I'm sorry, I didn't hear that.
So you may proceed. Mr. Crowder, is this your witness?
Yes.
It's actually Mr. Zell's witness, technically, so.
All right. Go ahead, Mr. Zell.
Okay, thank you, Your Honor. Ms. Collins,
Good morning.
Good morning.
Yes, sir.
Okay, thank you. Can you tell us what your occupation is?
Well, right now I'm a retired attorney.
At some point, we're practicing live attorney.
I retired from the City of Atlanta Municipal Court after 20 years in 2008. Subsequent to that, I took some contracts with the Georgia Public Defender Standards Council. Those cases included Mr. Lawson's case.
Okay. Do you recall at what point you were appointed to represent Mr. Lawson during the proceedings of his case?
Well, it was subsequent to his trial and conviction. I assume that because it was a conflict case, which almost all appeals these days are because of the ineffective assistance of counsel claims that are almost always raised. The case was assigned to me after it became part of the Public Defender Standards Council case.
Let me ask, did you handle the motion? You actually handle the motion for new trial?
I did handle the motion. I filed a brief. The original motion for new trial was filed in a skeleton form in a timely manner shortly after his conviction. And then I filed an amended motion for new trial subsequent to that.
And prior to Mr. Lawson's case, or during its pendency, do you recall how many felony appeals you had handled?
I received a group of 10 felony appeal cases from the Public Defender Standards Council. Prior to that, my appellate practice experience was with the municipal court for the city of Atlanta.
Do you recall, had you had any prior appeals involving murder cases before Mr. Lawson?
Only in as much as I did the other cases from the Public Defender Standards Council.
Prior to your taking the contract with the Georgia Public Defenders Council, was your entire legal career with the Atlanta, I guess it would be the traffic court, what not officially known as the traffic court, but the traffic court?
The traffic court and the municipal court.
Now, do you recall kind of any of the steps you took to prepare for his motion for new trial?
Of course. Mr. Lawson, his case was unusual in that he had co-defendants who were all tried separately. There was, one man, Christopher James, who was tried, and then another man, Bruce Roberts, who was tried. So in preparing for Mr. Lawson's appeal, I had not only the transcript from his trial, but also transcripts from Mr. James's trial as well as Mr. Roberts' trial. And so I studied all three transcripts, specifically looking for issues regarding the sole witness in the case that convicted Mr. Lawson. His name was Carrington Sims. And so my concern at the time was that in looking at Mr. Sims's testimony between the three trials was that he was not consistent in what he said. So in addition to reviewing the three transcripts, of course, I've reviewed the rest of the file, the indictment, had conversations with the other appellate attorney that was handling Mr. James's case. I'm sure I spoke with Mr. Lawson's trial attorney as well.
Now, in reviewing these numerous transcripts, you said that you did see some differences in the testimony with Mr. Sims from Mr. Lawson?
Yes, and that was one of the issues that I raised on appeal, was that his testimony, given the fact that his testimony changed from trial to trial, that it was less than credible.
Do you remember any substantial differences in his testimony?
I actually pulled up my brief and put basically the differences that I remember were his recitation of the facts. Specifically, there was one issue that was raised at all times, or in every trial, and that was the issue of why Mr. Sims failed to contact the police or notify the police about what was happening at the time, because he claimed to be a victim. And in one of the trials, he said that he didn't do it because he didn't have his phone, and another time he said he didn't do it because it would have been stupid. Things like that. There were just discrepancies in his testimony that I found to be problematic.
Now, you also testified just a few moments ago, you mentioned Mr. Sims being I don't want to mischaracterize your testimony, you said sole witness. Can you elaborate on that? What you mean by that?
Well, his testimony was the only testimony that was presented. My recollection is that his testimony was the only eyewitness testimony that the state presented. There was, however, another witness that was available that the trial attorney and the state failed to call. That witness's name was Altricia Hood. And I'll be honest with you, I can't remember what she would have testified to, but hold on, let's see here. But my recollection is that her testimony, okay, hold on. Her testimony would have gone towards showing that Mr. Sims's testimony was not credible, and that he probably participated in the killings. That I'm looking at my brief now, and that's what I've got in there. So, and that's my recollection, although it's been a number of years.
Did you consider presenting Ms. Hood at the motion for new trial as a witness?
I was not able to find Ms. Hood, so no.
Okay. Now, when you represented Mr. Lawson, there was actually more than one appeal in this case. Is that correct?
Meaning Mr. James's case as well? Is that what you're talking about?
Well, no, I'm talking about Mr. Lawson specifically. What happened to Mr. Lawson's?
Yeah, I understand. Okay, so after the motion for new trial, one of the issues that we raised was a Brady violation. There was a medical examiner's report that was introduced by the state, was not objected to by the defense, that was missing a page. And so when that became apparent, we raised that issue on trial as a violation of Brady, and Judge Arrington actually granted a new trial on that basis. The state subsequently appealed that ruling, and the Georgia Supreme Court overturned the judge's granting of the motion for new trial.
When at that first motion for new trial, how did you become aware of that issue? Do you recall?
I do not recall. Just basically reading the transcript, going through the file, looking at everything.
So when you testified, you read Mr. Roberts' trial as well before you handled the appeal. Is that correct?
I did.
Do you recall if that was an issue in Mr. Roberts' trial?
It probably was. I really don't remember.
Okay. You don't recall whether or not that was something that had been, do you recall, let me back up. In what stage or what order Mr. Lawson's trial was with regards to Mr. James and Mr. Roberts? Do you know? Do you remember?
I do not remember. I think Mr. Lawson was tried first.
Okay. Do you recall what happened to Mr. Roberts in his trial?
Mr. Roberts was acquitted.
Okay. And you did review did you review his trial transcript?
Yes, I did.
How did that come to be? Since he was acquitted, you certainly wouldn't be something that would have been normally prepared because of an acquittal.
I requested it.
Okay, so you requested it and you read through it?
Yes, sir.
Do you remember any evidence do you remember anything that sticks out in your mind that was different from Mr. Roberts' trial as far as the evidence against Mr. Roberts as opposed to Mr. Lawson?
In looking at my brief, I am seeing that Ms. Hood did testify in Mr. Roberts' trial.
Do you know if you reached out to Mr. Roberts' attorney to see if he could help you locate Ms. Hood?
I do not recall whether I did or not.
Okay. Let me move on to some of these specific issues in the case. You talked about Mr. Sims. How would you characterize his testimony as importance to the state's case in chief?
Without Mr. Sims's testimony, Mr. Lawson would not have been convicted. In my opinion.
What was did Mr. Sims have a role in this case other than as a witness? I mean, with regard to Mr. Lawson, Mr. James, did you have a way of characterizing his role with these other defendants?
Well, he was the circumstances that led up to the killings of the victims in this case were there was a group of people who were together that evening, and Mr. Sims was a part of that group. My recollection is that he testified that they went to a club and that they were together, that some drugs came up missing that belonged to Mr. Roberts, that one of the victims was suspected of having taken the drugs. But it appeared to me that Mr. Sims was just a part of this whole group and was not necessarily there against his will.
And when we spoke the other day, did you refer to Mr. Sims as some? Did you give him some title, or did you characterize him in some certain way?
I did. I characterized him as the unindicted co-conspirator.
Now, I know a lot of your experience, or majority of your experience, was in city court, traffic court, but that as a prosecutor, is that correct?
Yes, sir.
Did you have many cases in which there were multiple defendants involved in the crimes they were accused of in that capacity?
A few.
Was the majority of it solo, single defendants?
Yes, I think so. There were certainly co-defendants, but nothing of this magnitude.
Did you ever consider, since you did consider Mr. Roberts as an unindicted co-conspirator, did you ever consider any issues involving accomplice testimony and accomplice cooperation as issues that could have been raised at trial or on appeal?
Well, I did raise the issue that his testimony varied from trial to trial, but I did not raise the issue of a corroborating witness jury instruction, as I did read your petition, and I know that this is an issue you've raised.
Okay, so there were no other witnesses testified regarding against Mr. Lawson as far as being present at the scene of the crime. Is that correct?
That is my recollection.
Are you familiar with the rule in Georgia law regarding accomplice cooperation?
No.
Okay. All right then. Do you know if you spoke with Mr. Oden about anything dealing with accomplice law or accomplice cooperation? The motion for new trial?
I do not remember.
Okay. Right. Did you consider any jury charges on accomplice testimony when you were handling the appeal?
I did not.
Are you familiar with the accomplice cooperation jury charge?
I'm not.
Okay. All right then. That's all the questions I have then.
All right, Mr. Crowder.
Ms. Collins, if we could just, I know Mr. Zell's already gone through a little bit of your background, and I guess I should preface this, if anybody has trouble hearing me with my audio, just let me know. We can see what's going on, but otherwise I'll proceed.
All right.
In terms of your background, I don't know if this was covered by Mr. Zell, but what year were you admitted to the Georgia bar?
I was admitted to the Georgia bar in 1986.
Okay. And I think we've already established that you only handled the post-trial phase for Mr. Lawson.
I'm sorry, can you repeat the question?
You only handled the post-trial phase for Mr. Lawson?
That is correct.
And while you were preparing the motion for new trial and the appeal, did you have a chance to discuss anything about the case with Mr. Lawson's trial attorney?
I did speak with his trial attorney, and I only say that because I always spoke with the trial attorney in every appeal that I did. But I don't have an independent recollection of what we discussed.
Okay, or anything that he might have suggested that he thought could be raised on appeal.
Right.
Okay. Did you have contact with Mr. Lawson while the motion for new trial and appeal were pending?
Many times.
Did Mr. Lawson advise anything that he wanted to raise?
No, he did not. Now, I spoke with Mr. Lawson on several occasions, and my practice always was to be hands-on with the defendants and my clients, and to make sure that they understood everything that I was doing, and always give them an opportunity to work any issues that they felt were significant. And so, yes, Mr. Lawson had definitely had the opportunity to raise issues with me. And my recollection is that he did. And I definitely would have investigated any issue that he wanted me to raise.
Okay, and I think Mr. Zell went into this a little bit, but in terms of the issues you raised in the direct appeal, do you recall what all those were?
Yes, I do. I raised 4 issues on appeal. If you'll just give me a second. Okay. I raised the issue of the trial attorney's ineffective assistance for failing to object to the medical examiner's report, which was missing a page. I raised the issue of the state's failure to provide the missing page of the medical examiner's report, constituting a Brady violation. I raised the issue of the trial counsel's ineffective assistance, for failing to interview and call Altrisa Hood to testify. And I raised the issue that he should get a new trial because the witness's testimony was inconsistent between the 3 trials of the co-defendants.
Okay, and I guess I should further parse this out a little bit because as Mr. Zell brought up, there were 2 different appeals in this case. And I think we've established that the first one, if you recall, was reversed or a new trial was granted rather, based on that medical examiner's report. Is that correct?
Yes.
Okay, and so when it went up on appeal the first time, that would have been the state's appeal, and I'm assuming that was the only issue that was brought up in that appeal?
Yes.
Okay, so then once the Supreme Court reversed in that case and it went back down, the motion for new trial was then denied?
Yes.
Okay, so it's at that point that you raised the issues that you just spelled out for us?
Yes.
Okay. Talk just briefly about the issue with Altrisa Hood. You raised that as counsel ineffectiveness for failing to interview her. Is that what I'm seeing here?
Yes, for failing to interview and to call her as a witness.
And that was based on you reviewing Mr. Roberts' trial where he got acquitted and she actually testified?
Yes.
Okay. Do you recall how the Supreme Court disposed of that issue on your appeal?
I do not recall specifically what the court's opinion was, but they denied my appeal, so.
Okay. But in terms of specifically why they denied that ineffectiveness ground, you don't remember?
I don't remember. I should have reread the decision, but I did not.
Okay. And I believe you testified that you made an attempt to try to find her for the motion for new trial hearing, but were unable to?
Yes.
Okay, and obviously that hearing was after Mr. Roberts' trial was over, correct?
Yes.
Okay. On the issue of Mr. Sims, and I believe your testimony was that your opinion after reviewing the record was that it seemed like Mr. Sims was actually, in your words, an unindicted co-conspirator.
Yes, his claim to be a victim and his claim to be there unwillingly just didn't ring true.
Okay. Do you recall him testifying that at one point he tried to leave the apartment to get something out of a vehicle and that Mr. Lawson pointed a gun at him and told him not to leave?
I do remember he testified to that.
Okay. Do you recall him testifying that he felt threatened because he did not know anything?
Yes, I believe he testified to that as well.
Okay. And you recall him testifying that he felt that if he told police the truth about what happened, that they'd kill him also?
I don't specifically remember that, but I don't doubt it.
Okay. But at this point, you don't recall whether you considered raising an issue about accomplice corroboration in the appeal?
I don't remember considering that issue.
All right. Do you recall considering any issue regarding a detective improperly commenting on Mr. Lawson's right to remain silent?
I do not recall considering that an issue.
Okay. And if you've covered this already, I apologize, but just if you could explain how you decided what issues to raise in the direct appeal.
In the same way that I do every case, I reviewed the transcript. In this case, there were 3 transcripts to review. Reviewed the case file, the indictment, any motions or objections that were made, spoke with the trial attorney, consulted with Mr. Lawson about the issues that I had identified as viable issues on appeal, and asked if he had anything he wanted me to address. That's pretty much it.
Okay. And at the time you submitted the appeal, did you raise the issues you felt were the most meritorious?
I did. I certainly would have raised every issue that I consider to be of merit.
Okay, and just one last thing, and just to further on this accomplice corroboration issue, you don't recall if you considered raising that either from a standpoint of there not being sufficient corroboration or from a standpoint of trial counsel being ineffective for not requesting a jury charge on accomplice corroboration?
I did not consider that to be an issue.
Okay, when you say you did not consider that to be an issue, do you mean that you actually looked at it, or do you just recall, or that you just don't recall?
No, I don't recall looking at it. It wasn't something that jumped out to me as an issue.
All right, no further questions at this time.
Any redirect, Mr. Bell?
Mr. Crowder asked you some specific instances about Mr. Sims' testimony. In the converse, you characterized Mr. Sims as an unindicted co-conspirator. What do you recall about his testimony led you to that conclusion?
Well, my recollection was that in reading Mr. Roberts' testimony, his trial transcript, and the testimony of Altresa Hood, that Mr. Sims came to Altresa Hood after the incident, and this is all from my recollection. Forgive me for not being exactly precise, but that his conversation with Ms. Hood after the murders was suggesting that he had participated in the incident, in the murders. I don't think it was ever alleged that he pulled the trigger or anything like that, but that he was not there as as a victim. He was part of the crowd that went out partying that night, doing the drugs. That he was not just an innocent bystander.
Was Mr. Sims with the, let's see, that would be, there were at least, how many defendants were there? Four defendants total, do you recall?
I believe there were 4. One pled guilty to manslaughter. Mr. Roberts was acquitted. Mr. James and Mr. Lawson were convicted.
So was Mr. Sims with all of these other 4 co-defendants during the entire pendency of this alleged incident?
My recollection is that he was with them the whole time.
And were they all dealing drugs together?
I believe so, yes.
Was this murder allegedly about drugs?
Absolutely.
Okay. Did Mr. Sims also testify that that the victims were stealing drugs from him, or the victim was stealing drugs from him?
My recollection is that the victims were stealing or allegedly stealing drugs from Mr. Roberts.
Do you recall?
Enough was acquitted.
Do you recall Mr. Sims testifying that the victim was also stealing about $1,000 worth of drugs from him a week?
I don't remember that.
Now, do you also recall that Mr. Sims was initially asked by the police about what happened and lied to the police?
I don't remember that either.
Do you recall Mr. Sims denying he was even present?
No, because he was testifying about what happened. I don't remember that he denied being present.
I mean to the police, not at his trial testimony.
Oh, no, I don't recall that. I'm sorry.
Let's see. Do you recall whether or not Mr. Sims testified that during the time after this incident occurred that he continually acquainted himself with not only the co-defendants but their families and spent a lot of time with them together?
I do not recall that.
Do you believe that any of these would be factors in support of him being part of this?
Certainly, those would all be factors, yes.
And now, lastly about Mr. Sims, when he testifies whether or not he was threatened, would you consider this a self-serving statement to get out of being prosecuted for murder?
Objection, speculation.
All right. I'll withdraw that. Are you familiar with self-serving statements?
Yes.
Are self-serving statements generally admissible against defendants?
No.
Not that Mr. Sims was a defendant, but just in general. Now, moving on to the last point, last issue about Detective Cooper, whether or not he commented on Mr. Lawson's right to remain silent. Is that an issue you ever had while a prosecutor in Atlanta City Court and Atlanta Municipal Court?
From time to time, but rarely.
Okay. Are you familiar with the old rule under this, since this trial was prior to the new evidence code, the old, what we call the Mallory rule regarding commenting on the defendant's failure to come forward or right to remain silent?
Not specifically, no.
Do you recall during the trial if there was a time, and you said you read the petition, is that correct? You read my petition?
Oh, yes. Okay.
So in that, it raised that there was a time when the lead detective said he contacted Mr. Lawson several times, and Mr. Lawson would never cooperate and never come forward and give his side of the story. Do you recall that during the trial?
I do not.
Do you know if you ever considered that as an issue?
I did not.
Okay. All right. That's all the questions I have.
All right, anything else, Mr. Crowder?
Yes, Your Honor. Ms. Collins, on Mr. Sims, just to touch on a couple of things that Mr. Zell brought up. And some of this, I don't know if you recall, if you don't recall, just say so. Do you recall Mr. Sims giving two different statements to law enforcement?
I recall that Mr. Sims's testimony changed from trial to trial. I don't specifically recall his statements to law enforcement and whether they differed.
All right, and the conversation between Mr. Sims and Ms. Hood that you referenced on redirect, do you recall when that took place in relation to the date of the incidents in this case?
Only that it occurred after. I don't know how much time passed between the time of the murders and the time that he spoke to Ms. Hood.
Okay. Do you recall Mr. Sims testifying that everyone came up with a story to tell the police in case they were questioned right after the incident?
I don't recall that.
Okay. Do you recall Mr. Sims testifying that he did not find out that the victims had been stealing from him specifically until after the murders?
I do not recall that.
Okay. That's all, Your Honor.
All right, gentlemen, do either of you have an objection to excusing the witness at this time?
I do not.
No, Your Honor.
All right, Ms. Collins, thank you very much and have a good day.
Thank you, sir.
All right, with Ms. Collins excused, did we have any luck in connecting with trial counsel, Mr. Oden?
I've emailed him, Judge, didn't receive a response. Rachel's called him and hasn't gotten a response either.
All right, no response on Mr. Oden. How do you gentlemen propose we proceed? We could suspend the hearing at this point and reschedule for a later date where we can have Mr. Oden available.
Judge, I've texted him and I've called him and emailed him as well. He said he had a doctor's appointment, but he was going to reschedule it. So that's what he told me, he would be available for the hearing. We can go on with maybe I have 2 other hearings scheduled, Judge, if we want to just hold off until we reschedule, until we see if he responds.
That's fine. I mean, I'm going to be here probably looks like most of the day. So why don't we push the pause button on this hearing? In fact, I need to take about a 10-minute recess, and then we'll come back and start some of the other cases. Any problem with that?
No, Your Honor.
Okay.
No, Your Honor.
Mr. Rowe, can we do an audio and video check with you?
Hello, testing,
Yeah.
1, 2.
I can hear you perfectly. Can you enable your camera, sir?
All right. Okay, I should be enabled now.
I still don't see you. It's the button at the bottom. It says start video. Should
Yeah. You see me now?
See you now, sir.
Okay.
Coming in way better than before, so we should be good this time.
Oh, okay. So he took a 10-minute break?
Yes, sir.
Okay.
Yes, sir.
Okay. How many more we have?
100. We're only on number 2.
Do we know who will be next?
Baker?
Baker.
Okay.
Yeah, Raymond Baker at Smith.
Okay.
What about at GSP?
GSP, we'll just leave them there and see if the other guy will connect, and if it does connect, we'll just, that way we don't have to.
Okay. So I guess we're gonna hold for a minute now, Latoya. How many,
Well,
how many more,
she changed, okay.
how many more do you have, Latoya?
I have 4 more.
Have GSP having 5, and then we did one, and then we lost on this. She should got 4 more now.
Did Grissom get continued?
Grissom, let me see what
Yes.
item.
Yes. Right here. Item number 5.
Yes, he did get continued.
Okay, I'm gonna send him back.
So then you'll have a total of 3 left, right?
Correct.
Okay.
Okay.
All right. Yeah, let's. No, yeah, I'm sorry. Go ahead. And then that one was that one. And then Lawson, number 4. It's number 5. This one, Maury, and Maury is Rogers. So we have.
So that's the only one we haven't touched Roger yet.
We have not. Did you want to? Do you have a preference? They wanted to do Mr. Zell
Oh, yeah,
first.
go ahead. You gotta do this. Take care of your witnesses, I guess.
Yeah.
Uh-huh.
All right, to the next one.
Which case are we gonna go
All
to?
right, we're gonna proceed to item A, Raymond Baker.
All right, we've been trying to handle Raymond Baker all morning.
We have, but we got Mr. Rowe on now, and we did a sound and video check with him, and he's good. You handling this one, Mr. Burnick?
Mr. Burnick is handling this, Your Honor. Can you hear me?
This is item number 8.
Yes, sir. And Mr. Baker's at Smith.
At this time, the court calls case number 2019 HC 59, Raymond Baker, petitioner versus Terrence Kilpatrick. Gordon, the petitioner is represented by Mr. Zell, and the respondent is represented by Mr. Burnick. Mr. Zell, are you ready to proceed?
Yes, Judge Swordsman, and I will ask that I also have trial counsel. However, trial counsel is Michael Garner out of Columbus. He is a very high-risk person. And today, he is scheduled for his second COVID vaccine, so he is unavailable today. So I would ask that we, since Mr. Rowe was ready, I thought we would just be able to do this one have to do this one in a second part, because I did not want to. There's no way that Mr. Garner should give up his opportunity to be fully vaccinated because of today's hearing.
I didn't hear everything you said, so how do you want to proceed? How do you want to go forward then?
I would ask that we go ahead and go forward with Mr. Rowe since he's available, and that we suspend and come back for Mr. Garner on Your Honor's next hearing, because he's getting the second COVID vaccine today, and he's not available today because of that.
All right, I'm fine with that. Any objection from the warden?
No objection from the warden, Your Honor.
All right, then you may proceed, counsel.
Okay, thank you, Your Honor. Mr. Rowe, do you mind? Let's see. There we go. Let's see. Where's Mr. Rowe? Mr. Rowe, can you hear me?
I can hear you. I can hear you.
Okay. Mr. Rowe, if you could raise your right hand, please. I don't know if you've already been sworn in or not, but do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Anybody else have an echo with Mr. Rowe?
Yes, we're working on that.
Did you, Mr. Rowe, did you call in as well?
Yeah, because I had lost you all, but I put it on hold, so it should be no echo now.
Okay, all right, well, I could show you how to do it, so we'll do it just with one line and we don't have that background noise. In the event that we lose your video connection, we don't also lose audio. If you we'll hang up on the call-in line, and then if you look at if you look at the screen, there's a unmute button. There's a little arrow beside that button. It's a down arrow. If you click it and then you click switch audio, there should be a window that pops up that says call in. If you click right there, it says view, and it'll give you a phone number, an access code, and an ID where you can call in, and that way we don't have that background reverb.
Okay, so you want me to go ahead and do that now?
Yes, sir, if you could. He's coming in, and I'm afraid that window. So I'll just. That way we'll.
Okay. I just got clicked in.
Okay, all right. We should be good then.
All right, thank you.
All right.
Mr. Rowe, can you tell us your occupation?
I'm an attorney.
And are you licensed in the state of Georgia?
Yes, sir.
How long have you been licensed?
Since 1997.
And since 1997, what has been the nature of your practice?
4 years as a prosecutor. Actually worked with Miss Collins, the previous witness, for about 4 years in the City of Atlanta Solicitor office with her. And then the rest of the time I've been in private practice as a defense attorney mainly. And now defense attorney and criminal defense attorney, as well as personal injury and medical malpractice.
Now, going to Mr. Baker, did you represent him for an appeal?
For an appeal, yes, sir.
Did you have a lot of appellate experience before representing Mr. Baker?
I did do a number of appeals before Mr. Baker, but my main practice was trial.
Do you recall how many criminal appeals you had done before Mr. Baker?
I think at that time, I think I had done maybe like from 5 to 10 appeals at the time that I did Mr. Baker's, before I did Mr. Baker's appeal.
You're saying criminal appeals?
Yes, sir.
And how many of those were published?
I think maybe two were published.
And that 2 published before Mr. Baker?
I believe so.
And both of those appeals were they both dismissed for failure to follow the proper procedures?
I don't remember. I don't quite remember both of those. I'm not sure. I didn't really follow the appeals.
You didn't follow the appeals. Did you have a couple of appeals that were dismissed for failure to follow proper procedures?
I don't recall. I'm not sure.
Okay. All right then. Let me move on to this case. Do you recall how you came to represent Mr. Baker? Well, let me back up. You practice out of DeKalb County?
Yes, sir.
And Mr. Baker's case was in Muskogee County?
Yes, sir.
Had you ever handled a case in Muskogee County prior to Mr. Baker?
I don't quite remember. I believe I have. I'm not sure.
Okay. Do you recall how you came to represent Mr. Baker? I'm sorry.
I think he's referred.
Okay. And did you handle the motion for new trial as well as the direct appeal?
I handled the motion for new trial, yes, and the appeal, yes.
Do you did you obtain the transcript?
Yes.
And you reviewed the transcript?
Yes.
Do you remember anything else you did to prepare for the motion for new trial and appeal?
I interviewed the client.
Okay.
I interviewed the client and I reviewed the transcript.
Okay.
As well as interviewing the trial attorney as well.
And that would be Mr. Garner?
Yes, sir.
Okay. Now, do you recall the issues that you raised on appeal?
Ineffective assistance of counsel, violation of the defendant's right to confront his accusers under the Constitution, I believe the Sixth Amendment. I think I did. Yeah, I know I did ineffective assistance of counsel and then a violation of his right to confront his accusers.
And the issue you're talking about with the right to the failure or violation of due process for not being allowed to confront the accuser, who are you referring to that was not, that Mr. Baker was not allowed to confront?
Casanova Houston, I believe his name.
How would you characterize Casanova Houston's importance in the state's prosecution?
They relied on him heavily because he was really a co-defendant that testified against Mr. Baker.
Do you recall if he was the only co-defendant that testified against Mr. Baker?
That I don't recall, but I knew he was their main witness against Mr. Baker.
Okay, he was the main witness. And the issue about not being able to confront Mr. Houston, what was that about?
That was about the cross-examination of Mr. Garner's attempted cross-examination of Mr. Houston. He was not given the opportunity to a sifting and thorough cross-examination of the state's star witness, who happens to be a co-defendant. So he was not able to, either he was not able to effectively cross-examine, which he's entitled to, or either he was ineffective in his questioning or cross-examining of the state's witness.
Now, regarding the issue about not being able to properly cross-examine Casanova Houston, is that something that you developed on your own, or do you recall if Mr. Garner was this was something he was very upset about?
Couple of things. It's something I saw in the transcript, so I picked up on it in the transcript. It was pretty obvious in the transcript. And then when I interviewed Mr. Gardner, he was upset about. He felt like that Mr. Baker did not get a fair trial because of that. At the time I interviewed him, but I saw it. It was glaring out to me, it was glaring in the transcript.
And your second issue involved also involved Mr. Houston, and the trial counsel was ineffective for failing to properly, I guess, properly cross-examine him?
Yes, sir.
Did you have anything specific regarding that issue, regarding what Mr. Garner did not do?
I can't recall what it was, but I believe I did have some specific, but I just don't remember what it was. But
in looking at the Supreme Court decision, they wrote that there was nothing specific alleged, and that's why I was wondering, was there something that you just maybe neglected to put in there, or something you omitted by mistake, something that Mr. Garner didn't do in cross-examining Mr. Houston?
No, I don't quite, I don't recall,
okay.
To be honest. I just don't recall.
Okay. All right, then. Let me move on to some of these specific issues then. Now, okay. I'm going to keep it in line with Casanova Houston, because as you testified, he was an extremely important witness. Do you recall whether or not he took a plea deal?
I don't recall if he took a plea. Yeah, I'm not sure if he took a plea, but no, I'm not sure. I don't recall.
Okay. You did say he was a co-defendant who testified against Mr. Baker. Is that right?
Yeah, that's correct.
Okay. Do you recall if he was pled to lesser charges than Mr. Baker?
I'm not sure, but if he did, then I would have brought that up on appeal, because I would have. They've been required, obviously, to share that negotiation or that deal with the defense counsel.
Okay. I'm sorry. Go ahead and finish.
Yeah, I was going to say, if that would have been, if I would have been aware of that, then I would have brought that up as another ground. But I wasn't aware of a plea deal. I don't quite recall.
Is it then, based on your answer, it sounds like it is important to bring up plea deals with a testifying co-defendant?
Oh yeah, okay. Yeah, very important. Yeah.
What about in situations in which a defendant is facing, a witness, I apologize, a witness is facing a much harsher sentence than the defendant based on this plea deal? Is it also important to bring up what he's avoiding by testifying?
Yes.
Okay.
It is.
Okay. Have you had felony trials yourself?
Oh, yeah. Yes.
And have you ever had felony trials in which a co-defendant has taken a deal and testified against your client?
Yes, I've had some that have taken a deal, and I've had some that weren't even prosecuted. So that was something that I brought up during cross-examination of that particular defendant. Yeah.
And when you have cases like this, do you generally bring up the sentence a witness is avoiding by testifying? And if that's not clear, let me say, for instance, if a person is facing a death penalty and pleads guilty to a lesser charge and is avoiding the death penalty, is that something you would bring up in cross-examination?
Yes, sir.
Okay. Do you believe that's important to do?
Yes, sir.
Do you recall whether or not Mr. Garner did that in this case?
I can't remember if he did it or not. Yeah.
Okay. Now, you did raise that he was ineffective for failing to cross-examine Mr. Houston. Is that right?
Yes, that's correct.
So do you believe that if failing to cross-examine Mr. Houston regarding his potential sentence would be an appropriate issue to raise on appeal?
Oh, yeah. Yes. Yes.
Okay. Let's see. And the last issue I want to ask you about is something that was also referenced in your in your appellate decision. And it mentioned, because I think one of the issues you did raise involved whether or not there was a reference to Mr. Baker being in jail. And the Supreme Court said, well, the jury already knew this because there was a similar transaction for a prior armed robbery. Do you recall that?
Yes.
Okay. Do you recall if you considered whether or not that similar transaction should have been admitted or whether or not it should have been objected to?
I think I may have. I'm not sure. If I can recall, it was a similar. I know they admitted it, and I think Mr. Gardner said something like, "If it's a conviction, I gotta let it in." I think he said something. I'm not sure if he really objected to it or not, but he kind of gave up on it when it was introduced. But the reason why I didn't really go into that, I didn't bring that up, was because I'm not sure if that would have that was an error on his part, but I'm not sure if that would have been an error that would have produced a reversible error compared to the other errors that I saw, because it was a similar transaction argument that I think ultimately that transaction, that similar transaction would have, I believe it still would have came in even if he had objected under the statute. But it is something that I could have raised because he did not object and he gave in to it when he really should have objected to it.
Okay.
But I didn't raise it because I didn't think it was one that would overturn the decision, and it was a very harmless. To me, I think it would probably been a harmless error in light of the fact that it would have probably gotten admitted anyway. But I do believe it was an error in regards to him not objecting to it.
Well, let's see if I'm a little confused. If it would have been let in, then it wouldn't be error in the first place if it was admissible. Would that be fair to say?
Right.
Okay. Would it also be fair to say that the jury's knowledge of a defendant of a prior felony conviction is certainly pretty strong? It's pretty damaging to a defendant's trial, to his case?
Yes.
Is it something normally, do you want the jury to know if your clients have been convicted of prior felonies?
No, but we know how the similar transaction, especially the new statute is. I mean, it's not favorable for defendants, to be honest with you. Usually is the standard regarding similar transactions is not a huge standard that the state has to meet. So I guess what I'm trying to say is that we don't like it to come in. We hate similar transactions, but based on the factors, bent mind, motive, and all that, those factors, I'm not sure if under those circumstances with this case, a home invasion, I'm not sure if Mr. Gardner would have been able to keep that from coming in. I guess that's my point.
Okay. So now, of course, there is no similar transactions 404B. Is that correct?
Right. That's correct.
But you've been practicing under both rules of evidence. Is that right?
That's right.
Do you normally object to similar? Did you normally object to similar transactions, and do you continue now to object to 404B evidence because it's so damaging?
I do every time. Yes.
Okay. Every time. All right. So now under the old similar transaction, because now it's been almost 10 years now since similar transactions have been gone. Time flies. In addition to the appropriate purpose, like you said, like you testified, motive or course of conduct or what have you, does it not also have to be similar?
Well, I mean, I'm not. It has to be similar, but it's still. I mean, if they satisfy one of those other factors, it doesn't have to be similar to that extent, because once they establish that transaction establish a defendant's bent of mind, intent, motive. Once those factors are satisfied, then that transaction is coming in. The similar part of it, I think that was probably the prior rule. It was more on a similar side of it, but now since the latest one, you have these other factors that you can satisfy, as well. So I'm not sure if it has to necessarily. To me, I'm not sure if it necessarily have to be similar in that sense.
Well, when was Mr. Baker's trial? Was it before the 404B evidence, before the 2013 evidence code took effect?
I believe so.
So it would have to be similar then, wouldn't it? It would have to be coming under similar transaction?
Yes.
Okay. And bent of mind, is that something that you still maintain as something important in a similar transaction?
At that time or now?
Always at Mr. Baker's trial, during the time of Mr. Baker.
Oh, Mr. Baker. No, not if it was before the 404B.
And you did mention that this current case was a home invasion. Do you recall whether or not the other case was a home invasion, the similar transaction?
No, I don't recall.
Okay.
You said it was a robbery. I don't recall though.
Do you recall whether or not you researched or you looked at any cases to determine whether or not it met the facts of similarity, as opposed to just, I'm not saying, course of conduct or motive or something, or identity are not issues that can be used. That has to be for the proper purpose. But does it not also have to be factually, I'm not saying exactly, but something similar to be admissible?
Yes.
Do you recall whether or not you did any research, found any cases which might have helped you in that issue?
I don't recall, because I was just focusing on the two issues that I thought was the bigger issues at the time. So no, I didn't put as much investment in that issue as I did the other two.
Okay. That's all the questions I have. Thank you.
All right.
All right, Mr. Burnick.
Very shortly. Good morning, Mr. Rowe.
Morning.
And just generally, when you evaluate the claims to raise on appeal, are you the one who makes the choice as to what to raise?
Yes, yes, sir.
And I want to make sure that you research these claims.
I did.
Okay, and both factually and legally.
Yes, sir.
And then when you speak with, and then you said you had spoken with Mr. Garner.
Yes, sir.
And when he brought up the issues that he thought, did you evaluate those issues? As to
I
whether
did.
Okay. I got nothing further, Your Honor. Thank you.
All right, gentlemen, any objection to Mr. Rowe being excused at this time?
No, Your Honor.
No, Your Honor.
All right, thank you, Mr. Rowe. You're excused. Have a good day.
All right, thank you. Y'all have a good one.
All right, and Mr. Zell, in light of the unavailability of trial counsel, do you want to suspend the hearing at this point?
Yes, Your Honor.
All right, then at this point, we'll suspend the hearing and we'll reconvene at the next hearing date, which I believe will be in June.
Okay. Sounds
All
good.
right.
Thank you.
All right. Mr. Zell, is there anything else you have? I guess we're trying to circle back and
I do.
Find Mr. Oden from the previous case.
We do have Mr. Oden on.
Oh, we do have Mr. Oden on.
Let me transfer him. Let me make sure that we got a good connection with him. Mr. Oden, can we do a sound and video check with you, sir? Mr. Oden, can you hear me?
I can hear you. Can you hear me?
I can. Can you enable your camera, sir? It's the second button on the bottom. It should say start video.
Okay.
So this is back on the Lawson case, correct?
Lawson, yes. Miss Ellis, can we get Mr. Lawson?
Yes, sir. Yes, sir. Lawson. Yeah, take him right in there. I'm coming for him. Come here, Lawson.
Mr. Roden, I'm still not getting any video feed from you, sir.
I am clicking on start video, but it doesn't seem to have any effect.
What color is the button? Is it red?
It's white with the little camera crossed out.
The little camera, what color is it? Is it red?
Red.
Okay. Let's see. We could do video. Let's see, audio, video, speaker, microphone setting. Do you see the audio and video menu at the top? It's beside view.
Okay, yes, uh-huh.
Go to, no, this audio is good. It's the camera. Go to camera right there.
Is
camera?
that at the,
Yeah.
is that at the top?
Yes, sir. If you go to audio and video, there should be one of the options, it's camera. If you click on there, have you clicked on there, sir?
I'm trying to find the camera. Is it?
It's audio and video. It's the 1, 2, 3, 4, 5th.
I see audio, video.
Okay, and then
okay, go to camera.
Yes, sir.
And
can you see yourself once you click camera?
Yes, I can see myself.
Okay. All right, let's see. If you click the Okay, click the down arrow beside advanced settings. Can you do that for me?
Okay.
Is it set on auto?
Yes.
Video capture? Okay. Okay, it should be letting you do it then. So what happens when you click start video?
Okay, let's see.
There you go. There you go. We got you.
Oh,
Okay. Well, we just lost you. Can you click it again? Something happened in the. Yeah. Yeah, there you go. We got you, sir. For some reason, it keeps.
Yeah, he's double clicking.
One more time, just one time. I think you may be double clicking. There you go.
There you go.
We got you. All right.
All right, we're back on the record in case number 2018 HC 72, Herman Lawson versus James Deal. I believe Mr. Oden was trial counsel for Mr. Lawson. Mr. Zell, you may proceed with your examination.
Thank you, Your Honor.
Mr. Oden, please raise your right hand. Do you swear or affirm the evidence and testimony you give will be the truth, the whole truth, and nothing but the truth? Thank you, God.
I do.
Thank you, sir.
Good morning, Mr. Oden. How you doing?
Good morning. I'm fine. Thank you for asking.
Can you tell us what your occupation is?
I am a criminal defense attorney.
And are you licensed to practice in the state of Georgia?
Yes.
And what is your current occupation?
I'm working with Metro Conflict Defender, which is a division of Georgia Public Defenders Council.
Okay, and how long have you been employed with the Metro Conflict Defender?
13 years.
And prior to that, what was your position?
Prior to that, I had been a prosecutor in the Clayton County DA's office.
And at the time you, at some point you were appointed to represent Mr. Lawson?
That's correct.
And do you remember how long before the trial that you became his attorney?
I cannot remember. I can tell you the date I was hired to work with the Metro Conflict Defender, but I do not remember the date of the trial. I can't tell you when I picked up Mr. Lawson as a client. Are you having trouble hearing me?
No, I can hear you, if everyone else can. Did you have an opportunity to review discovery?
Yes.
Did you confer at all with any of Mr. Lawson's co-defendants?
No, because they actually had they had their own attorneys.
Okay, maybe I didn't ask that correctly. Did you confer with any of the co-defendants' attorneys?
If I remember, yeah, because there were similar issues.
And was everyone tried together or separately?
I'm trying to think. There were 4, if I recall. There were 3 in addition to Mr. Lawson that were tried together. Then I think there was a 5th guy that was tried separately.
Okay. Do you believe Mr. Lawson's case was tried individually, separately?
Let me see. But that's been so long ago, and I haven't had an opportunity to review the case file. When I think about it, I think there were different trials with different co-defendants. So I think Mr. Lawson may have been tried together. Been tried by himself.
So this trial was in 2008. Were you with the Metro? You said 13 years. So is this about? Were you with the Metro Conflict Defender when you represented Mr. Lawson?
Yes, I was hired with Metro January 31st, 2008.
Okay. And if the trial was in April of 2008, it would be fair to say you were appointed sometime between January and April of that year?
In fact, it may have been There was the young lady who had my position before I'm saying it wrong. I took over her caseload. So Mr. Lawson's case may have been one of those that.
Okay. Was this one of your first cases as a defense attorney?
Oh, no, by the time I had been practicing, by the time I was hired with conflict, I may have been practicing probably over, I was sworn in 79, so I would have been practicing almost 30 years at that time.
Yes. Were you a defense attorney prior to the Metro Conflict Defenders Office?
Yeah, I had done defense work then, before then.
All right. So was Mr. Lawson one of your, I guess it would be one of your first cases as a trial with the Metro Conflict Defenders Office?
Yes, I'm sure it would have been one of the first that I tried with Metro.
Do you remember if Mr. Lawson's case was, what order it was tried in relation to the other co-defendants?
No, I would be guessing if I would. I'm thinking he was the first out, but I could be wrong.
Do you remember your defense strategy?
Well, the defense strategy was simply to, if I'm not mistaken, the case pretty much turned on the testimony of one of the people who claimed that he was with Mr. Lawson at the time of the incident. And my strategy was to basically do my best to discredit that young man's testimony.
Okay. And do you recall whether or not you said this young man, did the name Carrington Sims sound familiar?
I mean, that could be his name, yes.
How important was Mr. Sims to the state's prosecution?
He was if I'm not mistaken, Sims was the person that, I mean, he was the key witness. I think there may not have been any other evidence that put any of the co-defendants there except Sims.
Do you remember whether or not part of your defense, I mean, this was not a self-defense case, right? There's no doubt about that, right?
No, it was not self-defense that I was aware of.
Do you recall whether or not part of your defense strategy was actually to blame Mr. Sims as being the actual shooter?
I don't think it was so much to try to flip the script and say that Mr. Sims, as so much as it was that that it could have been I'm trying to think.
Well, let me ask you, you wouldn't have any reason to dispute your closing argument that if you allege that Sims was the guilty party, you wouldn't dispute that if it's in the transcript, would you?
No.
Okay. But sitting here today, you don't recall whether or not that was part of your strategy?
To say that Sims had been the shooter?
Yes, that Sims was the...
I don't think that, no, I don't know if that had been part of my strategy going in.
Would it be fair to say that your strategy was anything against Mr. Sims? That would mean impeach him, call into question his credibility, anything you could do to discredit him?
Exactly, yes. The strategy was to discredit Mr. Sims.
Do you recall if Mr. Sims had been to the police and lied to the police about even being present at the scene before he said he was?
I seem to recall that there was something about Mr. Sims's testimony that was that leaned toward that nature? I don't specifically remember at this time what it was.
Now, I'm going to start with my last issue first and ask you about, there was a detective named Cooper that was the lead detective. Do you recall anything about do you recall that name or his role in the trial as lead investigator?
Not at this time, no.
All right. At some point, do you recall whether or notwithstanding was it a person named Cooper, but one of the police officers in the case, about their representation that they did not charge Mr. Sims, and you were calling into question whether or not it's just solely based on Mr. Sims telling the police he wasn't involved?
I don't have any memory of that, no.
Okay.
I do, let me see, seems like I do recall questioning why, if Mr. Sims was there as he said he was, why was it that he was not charged as the others had been?
I would like to, listen, I probably need help with this. I would like to share this page of the transcript to see if this helps refresh Mr. Oden's memory. Let's see, how do I just...
All right, we've made you a presenter, Mr. Zell.
Okay, okay, share, let's see. Can people see that?
It's cut off for me. It looks like I don't see the end of the sentences.
Okay. Oh, okay. I got to change it then. How about?
Oh, okay. Now I can see it.
Okay. All right. Okay. So I guess if I move this, does it move with everybody else? Is that how it works?
Yes, sir.
I can see it moving. Yes.
So this is, I know obviously we can't. This is volume 5 of the trial transcript, which I know the Attorney General has a copy of it. Page 180. Let me go to here to 183, line 9. Let's see. Let's just go to the top of the page, line 3, and if you could read that page and see if that refreshes your memory. And I will scroll down as you need me to.
Okay, doke. Okay, I've read to the bottom.
Okay. Now this is your direct examination. Do you recall what your purpose of this examination of the lead detective was?
Yeah, that would have been my cross, right?
Yeah. Yes, your cross of the lead detective.
Well,
so this was the very last witness of the trial.
Apparently, from reading the transcript, Sims had apparently changed his story to police officers during their investigation.
Now, this is the questioning they call him. I know they're calling him JIT, which is, I think, JITT. That is Mr. Sims, the testifying witness. The testifying witness for the state that you've mentioned was so important. Was there a purpose to why you were calling into question dual statements? This changing of a statement?
To discredit Sims's testimony and to show the arbitrary nature of the police officers not charging him.
Okay. And at the bottom of the page where your question is, what if my client had said I was involved? Would he have not been charged as well? What was the purpose of that?
To again demonstrate the arbitrary nature of the police officers charging the parties involved.
Okay. So going into the next page, if you read that answer of the detective, where I guess he diverged from your question. If you read lines 1 through 3, do you recall the detective making a comment on whether or not Mr. Lawson failed to come forward and cooperate?
Apparently, from reading the answer 1 through 3, apparently he did say that he gave Mr. Lawson the opportunity to cooperate.
Did you consider whether or not objecting as non-responsive and that was a comment on Mr. Lawson's right to remain silent or his failure to come forward?
I did not at the time.
Okay. Have you had that issues in trials before where police officers have made similar types of statements or testimony and you've objected?
Yes.
What's normally the reason why you would object?
Because basically it is a comment on his failure to remain it's a comment on him availing himself of his Fifth Amendment rights.
Have you ever requested a limiting instruction or curative instruction from trial judges to tell the jury after something like that has happened?
I think so, yes. I've not had that to happen very often, but I think I have addressed that at times in trial.
Okay. Now, I know it's been a long time since this trial, but do you recall any reason why you did or did not object?
I can't really recall at this time specifically why I didn't object, but from looking at this, it looks like I was more focused on the demonstrating to the jury that how arbitrary the officer's behavior was.
Okay. Is it something that you want the jury to know that your client was not uncooperative after being given that opportunity several times?
Oh, no, I wouldn't. It's not something I would want the jury to know.
Okay. All right. Do you have any reason to believe the jury wasn't paying attention?
No, I have no reason to believe the jury wasn't paying attention.
Okay. Okay. I'm going to let's see. I can stop sharing now. All right, I can go back to this now, I believe. Okay, so let me go back to now, sticking with Mr. Sims, as you testified, he's a very important witness. When you saw that testimony or that, does it refresh your memory as to whether or not you thought Mr. Sims was involved in this at all, as more than just a witness?
I can't presently remember what I thought of Mr. Sims' involvement now.
Okay. Let's see. Do you recall whether or not you cross-examined Mr. Sims regarding whether or not the victim was stealing drugs and or money from him?
Not personally. I remember that seems like the allegation was the victim was somehow or another taking drugs. Now, who it was from at this point, I can't tell you.
Okay. Do you recall impeaching Mr. Sims with a prior conviction for making a false statement to police?
No, I don't.
Do you remember whether or not in your opening or closing, your opening statement or closing argument or your cross-examination, you at any point alleged or argued that Mr. Sims was involved in this more than just as a witness?
I don't have any specific memory of my opening or closing arguments regarding Mr. Sims.
Now, did you ever consider requesting a jury charge on accomplice cooperation?
No, I don't recall.
Now, are you familiar with the rule on accomplice cooperation?
Yes, yes.
I think your earlier testimony, you said you do not recall there being anything other than Mr. Sims' testimony. Is that correct?
That's the only testimony that I recall that placed the co-defendants at the scene, or even with the victims.
Okay. Do you remember whether or not you moved for a directed verdict based on the failure to request or the failure to have cooperation of the testimony?
I don't recall.
Do you consider whether I know you've testified you don't really recall whether or not you argued Mr. Sims was a part of this, but did you consider there were, what you said, Mr. Roberts, Mr. James, there were several co-defendants. Did you consider Mr. Sims an accomplice in this case? At least as to the other defendants, perhaps, maybe not Mr. Lawson, but at least to some of the co-defendants?
Did I consider Mr. Sims to be an accomplice to the other co-defendants?
To anybody, to any of them. There were several co-defendants, right?
But 3 other co-defendants. No, I don't know if I consider them accomplice to any of them.
Now,
if anything, I'm trying to recall if I considered Mr.
Let me ask you, while you're thinking about that, now, do you recall what precipitated the murder, according to the state's theory, under the state's theory, what it was that led to it?
Seems like I recall that the allegation was that the deceased had stolen drugs or stolen money from somebody.
Okay. And was this somebody not Mr. Lawson?
I believe that I think it was somebody not Mr. Lawson.
Now, with that in mind, do you recall what happened after this allegation of drug stealing, what the sequence of events was that resulted in the death of the victim, or victims in this case?
I recall that apparently both deceased showed up at an apartment, seems like somewhere and they were basically tied, put in two separate vehicles, and taken to the place where they were killed. And I'm trying to think, because somewhere in there, it seems like the parties had to stop. I don't know whether it was before, to get maybe a tire repaired or something to that effect.
Okay. So under that, then you have the co-defendants along with Mr. Sims, the testifying witness, all together at the time of the murder?
Seems like they were all together at the time of the murder.
Okay. Now, did you consider, I mean, it was clear Mr. Sims testified against Mr. Lawson. Is that right? There's no doubt about that, isn't there?
No, it's no doubt about it.
So did you ever consider raising as a defense that, you know, hey, to the jury, you know, Mr. Sims is, you know, you heard him. He's lied before. He lied to the police here. He lied to the police in another case. Even if you have some belief in his testimony, the guy was there. He was involved. He lied to the police. You can't convict him just on his testimony. He's part of this. Georgia law doesn't allow that. Did you ever consider that?
I don't recall considering it, no.
Okay.
But I must say, I don't really recall very much of my closing argument period in the case.
Have you made arguments like that before in cases in which in which a testifying co-defendant or unindicted co-defendant has been the key witness?
That may have been the first time I encountered that. I think, I'm trying to think. That may have been the first time that I encountered a murder case of the nature of this one.
Okay. As a defense attorney or somebody employed with a public a type of public defender's office, do you believe it is part of your responsibility to preserve the record for appeal?
Yes, yes.
Do you try to do that wherever you can?
I'm sorry, you kind of cut out.
Do you try and do that wherever you can? Is that a reasonable trial strategy to preserve the record for appeal?
Yes.
Okay, that's all the questions I have.
All right, Mr.
Morning, Mr. Oden. Just looping back real quick on your background, I believe you testified on direct that you were sworn in 1979. Is that referring to the Georgia bar?
That's correct.
Okay. And you testified that you reviewed the discovery. Did you discuss the discovery with Mr. Lawson?
Yes, yes. Because if I'm not mistaken, Mr. Lawson had already been given the discovery by his prior counsel.
Okay. And I'll go in the order that Mr. Zell went in terms of the issues. On the questioning of the detective, the transcript excerpt that Mr. Zell showed you, and if you need me to bring this up, I can do that as well. When you just reviewed that part of the transcript. And just in reading that line of questioning, it's a fair assessment that you were trying to initially show that Sims changed his story to law enforcement, and then that you, at the bottom of that page 183, that the question you asked of the detective was basically pointed at if Mr. Lawson had come in and done the same thing that Mr. Sims did, that he could have been considered a victim. That was part of your strategy to discredit Mr. Sims?
Yes.
Okay, and that, so would you say that that question fit into that strategic decision, or part of the strategic decision to discredit Mr. Sims's testimony?
Was it
Well, you were kind of freezing up. I guess was that question the one at the bottom of page 183 that Mr. Zell showed you? Was that question part of that strategy to discredit Mr. Sims?
Yes, and to show the arbitrary manner in which the detective had decided to charge the co-defendants.
Okay, and in terms of the answer that Mr. Cooper gave, which was the top of that next page that Mr. Zell showed you, so I understand your testimony, you don't really recall at this point why you didn't object, and that you maybe were focused on trying to just continue to show that, as you said, the arbitrary nature of the state's decision-making in terms of who they were charging?
That's correct.
Okay. And in fact, and if you need me to pull this up, I can. Do you recall then if you just continued on with the questioning to continue to try to show how Mr. Sims had lied?
From what I read earlier when Mr. Zell showed me the transcript, if I'm not mistaken, that's how I continued the cross-examination of the officer.
Okay, I'm going to bring it up to page 184 here. If you can just review that and see if you agree with that. Lines 8 and 9, 8, 9, and 10.
Again, I think that the police officer, how Sims had lied and how the police officer was willing to believe him for the purpose of making the case.
Okay, and I'm trying to stop sharing on this and it's not showing me that option right now.
I got it.
Okay, there we go. All right, and then in terms of Mr. Sims's involvement, I believe your testimony was that you cannot remember what you thought about Mr. Sims's involvement. Are you, when you say that, do you mean at the time of trial?
That's correct. I can't, because what I do recall now is the fact that Sims, if I'm not mistaken, it was Sims's drugs or money that was supposedly taken. And the whole strategy was to show that he was the one that had suffered the loss, and he was the one that would have had more of a motive to carry out the murders than the other parties.
All right. Do you recall Mr. Sims testifying that he didn't actually find out that the victims had been stealing from him specifically until after the murders had happened?
And that I don't recall.
Okay. But his testimony would speak for itself on that issue?
Yes.
Okay. And in terms of requesting a jury instruction on accomplice corroboration, I believe your testimony was that you are familiar with that rule, but you just don't recall if you considered requesting that charge at this point? Okay. Do you recall if there were other charges you did request?
I'm almost sure there were charges I requested, but I can't say for sure now.
Okay, and Mr. Zell asked you if you considered Mr. Sims to be an accomplice, and your answer was that you don't know if you considered him an accomplice to anyone, or again, is that referring to at the time of trial? In terms of your mindset on that?
Yes, at the time of trial. As as memory starts to serve me, it seems that, as I said earlier, it seems that Sims was the one that had more motive to carry out the homicides than the other parties, because it was his drugs, apparently, that were taken, or his money that was taken.
All right. Do you recall who it was in terms of either any of the 4 defendants or Mr. Sims that allegedly discovered that drugs were missing?
Now that I don't recall.
Okay. Nothing further at this time.
All right, gentlemen, any objection to having the witness excused at this time?
I have a couple of follow-up questions, Your Honor.
Okay, go ahead, Mr. Zell.
Mr. Crowder asked you about, and he showed you that page of the transcript that I showed you as well. Do you remember if you were aware that the detective had tried to contact your client several times and he had not responded? And whether that, I mean, were you aware of that from the discovery? Was that in the discovery, if you recall?
That I don't recall.
Okay.
I don't recall. I don't recall how the detective came to suspect any of the co-defendants at this time.
Okay. And regarding going and to the accomplice part that you were asked about as well, the and whether or not, I know Mr. Crowder asked you about whether or not Mr. Sims found out about his testimony anyway, about whether or not his drugs were stolen after the murder or not, notwithstanding whether that's true or not. Do you recall, could Mr. Sims be an accomplice with someone other than with Mr. Lawson? Could he have been an accomplice with one of the other defendants who may have had drugs stolen from him? If you recall that?
I don't know if I considered Mr. Sims an accomplice at all, or whether or not whether my thinking was that he was lying on the others to take the suspicion away from him.
Okay. So that was earlier when I was asking you about whether or not your theory was that Mr. Sims was the guilty party or not. Is that what you're referring back to?
I guess that's what I'm referring back to. As I think about as a result of the examination this morning and the various things that have come forward, especially showing me the transcript, seems like my focus was more on seeing Mr. Sims as a perpetrator and who was lying to clear himself.
Would it be fair to say that the state at least believed that Mr. Lawson and some of the other co-defendants were accomplices?
Then that would follow from my theory that Sims was the perpetrator.
Okay. Would it also follow that Mr. Sims could have been the perpetrator along with one of the other defendants who had drugs stolen?
Yes, yes.
Okay. Okay, that's all I have.
Anything else, Mr. Crowder?
No, Your Honor.
All right, gentlemen, can we agree to excuse the witness?
Yes, Your Honor.
Yes, Your Honor.
Thank you, Mr. Oden. You're excused. Have a good day.
Thank you.
So how do we release him? All right, those are the only two witnesses. Mr. Zell, do you have any other evidence that you wish to
No,
offer?
we would rest others subject to, I guess, presenting the transcripts. I don't know what Mr. Crowder's intention with that is, and what we want to do as far as tendering the trial and appeal records of the case.
All right, Mr. Crowder, do you have exhibits you want to offer at this time?
I do, Your Honor. If they, there's at least 10 exhibits. If I can be allowed to share these again, I've got them all pulled up in PDF form as I did the other things.
Okay, that's fine.
All right, respondents exhibit 1 is the clerk's record that was prepared for the first appeal, which is the one that ended up being where the state appealed the grant of a motion for new trial and was reversed, which was reversed. So that's the clerk's record from that appeal.
No objection.
All right.
Respondents 2 is the clerk's record from the second appeal, which is obviously considerably smaller, since it's only things that happened after this case was sent back down by the Supreme Court.
No objection.
Exhibit 3A is volume 1 of the trial transcript.
No objection.
Exhibit 3B is volume 2 of the trial transcript.
No objection to any of the volumes of the transcript. I think there's 7 of them, I believe.
I'll just click on through. There's 3, which is exhibit 3C. Exhibit 3D is volume 4. Exhibit 3E is volume 5. Exhibit 3F is volume 6. And okay, now it's back. Exhibit 3G is volume 7.
No objection.
Okay, sorry. Exhibit 4 is the transcript of the motion for new trial hearing.
No objection.
Exhibit 5 is the appellant's brief.
No objection.
And again, that's from the second appeal. Exhibit 6 is the brief that our office filed in the appeal.
No objection.
And Exhibit 7 is the DA's office's brief in the appeal.
No objection.
And that's all the exhibits we have. And I don't know if anybody had mentioned this previously in terms of the citations on the 2 appeals. The first one is actually styled as State versus James, 292, Georgia 440. And that's the one where the state appealed to grant the motion for new trial and the case was reversed. And then the second appeal was Lawson versus State, 296, Georgia 1. And then if I can get out of the stop sharing again.
All right, all of these exhibits are admitted without objection. Is there anything else that needs to be addressed before we close the hearing?
No, Your Honor.
Okay, I have taken a quick look at the Supreme Court decision at 296 Georgia 1. Obviously, this accomplice issue was not raised in that appeal. You want to make a brief argument about that, Mr. Zell? I mean, how do you contend that Sims was an accomplice And we all know the rule about corroborating accomplice testimony, but I want to give you a brief idea of what your position is there.
Okay, Your Honor. Okay. Carrington Sims, the detective testified, Detective Cooper, he's the lead investigator, that Mr. Sims was a person of interest. They brought him in for questioning. When he was first brought in, he lied to the police, said he wasn't involved, he wasn't present. He said he wasn't even present, didn't know anything about this, which of course was not true, based on his second statement in his trial, excuse me, second testimony. So he lied to the police, so he certainly lied. He, certainly the state's theory would be that he's not an accomplice. No doubt about that, because if he was, there's no conviction. There was simply no other evidence. It was Mr. Sims or nothing, which is why that's such an important issue. They're going to, if they bring any charge against him or anything, that's it. There's nothing. They can't prosecute any of the other defendants. Now, Mr. Sims also was also impeached with a false statement to the police conviction from an unrelated case. So he had already been convicted of lying to the police before. He hung out with the other co-defendants and their families after this allegedly happened. The state made a big deal that, oh, poor Mr. Sims was a victim. Well, of course, I understand that. They don't want him to be an accomplice for obvious reasons. They made such a big deal out of him being, oh, he was poor, they pulled a gun on him. But that was solely, everything Mr. Sims testified to was solely based on his testimony. In other words, there were no witnesses who came in and said Mr. Sims was a victim. There were no witnesses who said any of the co-defendants took advantage of him. None of that. This was everything was based on Mr. Sims' testimony. So the question comes down to whether the jury, it's up to the jury. And I have several cases that say that's up to the jury to determine whether he was an accomplice. Now, Mr. Sims, he hung out with their family after this. If he's so threatened, why is he hanging out with the family? Why is he hanging out with the co-defendants? He never does anything. He never flees from them. He never stops hanging out with them. Mr. Sims' own testimony is that he was taken in by a drug dealer, and that drug dealer was found murdered. They couldn't find out who did it. So Mr. Sims then goes to a second drug dealer, that being the victim in this case, who also winds up murdered. So Mr. Sims has a history, and Mr. Sims lived with the victim. He was, by his own testimony, he was there during the entire time that the victims were, there were two victims in this case. They were boyfriend, girlfriend, and they were all of these people, the four or five co-defendants, the two victims, they were all, and Mr. Sims were all in the drug trade together. Mr. Sims testified that they were all stealing from each other. Mr. Crowder's right, that there were drugs that he testified that he didn't know about the drugs until after the trial. After the murder. But again, why I raised the self-serving is that normally self-serving statements aren't admissible against a defendant. They're admissible when it's just a witness, but remember, they are self-serving. Mr. Sims is avoiding a murder prosecution by everything he says, and he's already admittedly lied to the police in this case, lied to the police in another case in which he was actually convicted, and he was with them during the entire pendency of not only this, when the victims were I want to say kidnapped, where they were tied up, where they were taken to a different location, because this actually happened in DeKalb County, and the actual murder happened in Fulton County, and he was with them during this entire time. Then the person whose drugs were stolen was actually the co-defendant who was found not guilty in a separate trial. That was Mr. Roberts. He was actually found not guilty. It was Mr. Sims' testimony that this was the co-defendant whose drugs were stolen and that began the sequence of events. Now, he was with them the entire time. It was Mr. Roberts' car, which was I want to say his car. He borrowed it. He apparently traded it for drugs and used this rental car, which was later found burned. It was a separate case of arson. And Mr. Sims was also involved in that. He was present during that. When he went with all the defendants to this scene to burn the car because it was evidence. And then he left with all the defendants as he testified to. So he was part and parcel through this. Now, yes, the state wants to classify him as an accomplice, but the defense wants to classify him as the perpetrator, as at least as being involved in this. Certainly, Mr. Roberts was involved because they were his drugs that led to all this, where they went in and said, "You stole drugs. What's going on?" That would be part of a conspiracy. So there's no doubt Mr. Sims would have been an accomplice under this, or at least under the defense theory. And that is strictly, it's not a legal, it's not the state gets to decide who the accomplice is. The jury does. That's the case law. The jury is. The jury gets to decide whether or not Mr. Sims is an accomplice. And the reason that's important in this case is because there is no conviction without Mr. Sims. If he's an accomplice, there is no conviction. There were no other witnesses that testified as to what happened. I'm sure the state would say there was some other evidence, and there only has to be slight corroboration of accomplice testimony. But in this case, when we're talking slight, it's, again, that's a jury question. It's slight as can be. And there's no harm in arguing to the jury, as Mr. Odin did in his closing argument, blaming Mr. Sims. And also something the defense said during closing, good point that Sims sold drugs. He sold drug dealers, and he blamed Sims. That was on page 115 of the transcript. Let's see. He said, because Mr. Sims had said, this was another important part. Mr. Sims said, Mr. Crowder was arguing that he was a victim. The state was arguing he was a victim, that somebody had a gun, but he was in the car with somebody he said had no gun. He didn't see a gun. That was Mr. James. That was, and Mr. Odin picked up on that in closing. He said, well, no, I never saw them with a gun, which is the state's theory. Well, why is he being dragged out there? Because he's a victim, it's a gunpoint. He said, no, I didn't see anybody with a gun. I assumed he had a gun because all drug dealers have guns. Under that theory, as Mr. Odin argued, that means Mr. Sims would have had a gun too, because he said all drug dealers have guns. That's why he assumed that he had a gun and why he had to go with them. But that's obviously that's why Mr. Odin argued that in closing, because that would then suggest that Mr. Sims himself had a gun, according to Mr. Sims' own testimony. So there's nothing wrong with Mr. Sims or Mr. Odin arguing in closing. You know, he's an accomplice, at least with Mr. Roberts. It was Mr. Roberts' drugs that were stolen. You know, Mr. Roberts' drugs were stolen. They were not being tried together. They were all being tried separately. There's no harm to a co-defendant you're on trial with. That you may believe Mr. Sims a little bit. You may believe, but you've got to believe he was involved. He was involved in this case. He was there from the beginning. He was there during the middle. He was there at the end. He continued to hang out with these people. And if you have some belief that his testimony is true, you still can't base your conviction on that, because under Georgia law, there has to be corroboration. And even if you have some belief that Mr. Sims was telling the truth, that's not enough in Georgia. And there's absolutely nothing that would have stopped Mr. Odin from arguing that. It would not have prejudiced Mr. Lawson whatsoever to still argue Mr. Lawson was not involved in this. He's not an accomplice. That Mr. Sims was lying. Doesn't mean Mr. Sims wasn't an accomplice. But when the whole case rests on one person's testimony, who was a person of interest, who lied to the police multiple times, and who was present during the entire incident and after the incident, it's disingenuous to say the jury could not have found he was an accomplice. Now, Your Honor, want to hear from me about the other issue, involving where Mr. Odin was cross-examining the detective, and the detective said, I tried to get Mr. Sims to cooperate, and he refused to several times. I called him several times, and he refused to cooperate. That's also one of the old Mallory issues where a defendant, but it's not the law anymore. Admittedly, Mallory's, obviously not part of it. The Supreme Court's held that Mallory's no longer good law because it was decided under the old evidence code. But it's pretty clear that Mr. Odin didn't know that, at best, Mr. Odin didn't know the detective was going to say that. He did not know that Detective Cooper was going to say that. I see no harm in what he asked the detective. Hey, he was trying to show Mr. Sims, that he's not the one, that he was just there, that he wasn't just there, that this was just solely based on Sims, and it wasn't legitimate just to say, well, hey, somebody comes in and says, I'm not involved, so therefore I get to blame everybody else. So I get that, I understand that, but Cooper takes it a little bit too far. I mean, he could have said, there's other things he could have testified to, but to come up and specifically in a non-responsive answer say, hey, I gave your client a chance to say he wasn't involved, and he never did. He refused to cooperate. That's drawing the line. I mean, that's way going over the line. That's not even a little bit. That's way over the line. And in this case, when the only evidence is an admitted liar, it's a big deal. I mean, that's a big deal. It comes down to, do you believe Sims or not? This whole case is, do we believe Carrington Sims? That's it. And when a jury hears a defendant, refuses to cooperate, well, I mean, the natural inclination is why are you gonna, if you're not guilty, of course you're gonna cooperate. You're gonna tell them, I didn't have anything to do with this. I was at the movies that night, or I was at home that night, or I was with my girlfriend or my wife or so and so. It is a big deal, even if the jury's told, listen, they don't have they don't have the duty or any burden to testify. It's still a big deal. We know it is. Even when in just everyday life, if you ask your kids, did you do this? And your kids say, I'm not answering that. We know, we automatically assume because we're human. So this wasn't a strong case. This was a Carrington Sims case. That's it. One witness.
All right. I appreciate that, Mr. Zell. And Mr. Crowder, if you want to respond briefly, you can. You don't have to. Obviously, you both have the right to submit any argument in writing that you might want to. But if you'd like to briefly respond, go ahead.
I do think we would like to at least have some opportunity to do a written brief on this. But I can just do a brief synopsis on the accomplice issue, and reserve the right to delve further into it in a written brief. The law is that an accomplice is somebody who shares a common criminal intent with the actual perpetrator, and mere presence is not enough. And in terms of Mr. Sims, his testimony was that he lied to the police because he felt that if he told the initially, because he felt if he told the police the truth, he would be killed also by the 4 co-defendants or some combination of them. In terms of the gun issue, whether or not he saw somebody with a gun in the car, he also testified clearly that before they even went anywhere away from where the victims were tied up at this residence, that one of the defendants says something about there being a CD in the car. Sims gets up to go get the CD, and when he opens the door, Mr. Lawson points a gun at him and tells him not to leave. So he's already had a gun pointed at him before they even leave the scene and been threatened. So, obviously at some point later on, after he's given this first statement to the police where he admits he lied, he comes back and says, well, no, that's not what happened. And then we find out that's what the reason is. I don't have all the record citations in there, but I know he was questioned about why he lied to the police during trial. So is our position that there's no evidence that he had common criminal intent with the 4 co-defendants, and that it's not deficient performance to not request an instruction that's not authorized by the evidence. And I'll just reserve anything further for a written brief.
Okay. All right. That's fine. All right. Well, thank you, gentlemen. Any objection to closing the record at this time?
No, Your Honor. Oh, I do. If I could, I just want to make sure that see whether or not Mr. Lawson has anything else that he needs me to raise with me before we.
Mr. Lawson, anything you want to say at this time?
Georgia State Prison, can you please unmute?
Try and unmute him.
I cannot. No, they have to do it, Judge.
There's no one in the room with him, Mr. Zell.
Miss Ellis?
I think he's shaking his head no.
Okay.
But he just got up and left. So.
I think he's going to get Miss Ellis.
Okay.
Right. Okay.
All right, so he's up. I can hear him. Mr. Lawson, is there anything you want to say at this time?
Pretty much on the issues that we raised, I'm pretty satisfied with what my lawyer had said.
All right, then, if there's no objection, we'll close the hearing, gentlemen.
Okay. No, thank you.
All right.
Your Honor, in terms of timing on filing a written brief, can we have some time after the transcript's prepared for that?
Yeah, absolutely. I mean, you can, I don't know when it'll be prepared and filed, but I would say, what do you want, 30 days after that?
That should be fine.
Okay. All right, and then Mr. Zell, obviously you have time after that to respond.
Okay.
All right, thank you, gentlemen. We'll close it at this time.
All right, thank you.
You done?
Okay.
Right there.
What else have we done?
Got time more, Judge.
Can you just let them know we'll reconvene at 1 o'clock?
All right.
Latoya.
Yes, ma'am.
Hey, Tiffany, Latoya, and Cece's, she's still there. We're gonna go to lunch till what time, y'all? Till 1 o'clock?
Okay.
All right. Thank you.
All right.
Want me to just stay or log back in?
I can't hear you. What you said, Latoya?
You want me to log off and log back on at that time?
You can leave it up if you want to.
Okay.
You can leave everything up, but yes, we're done till 1 o'clock. Tiffany, did you hear that?
Are we doing my next case at 1 o'clock so I can notify the witness, or direction?
Are you sitting there ready to go right now?
Oh, I'm fine. We can take a break. I'm gonna be at my office. It's fine, Judge. I mean, I'll be around. But there's a witness who's this is a plea case, so it's a plea counsel. So I mean, I just told him I would text him when we're ready. He's not on the screen, but because I told him, we were doing these other cases first. But
all right. You just text him and tell him, can we do that one at 1? All right, we'll do that one at 1 o'clock.
Okay, thank you, Judge.
Mr. Atkinson, can you hear me? Mr. Atkinson? Can you hear me, sir? Mr. Atkinson, can you hear me? Send him a message.
Excuse me.
Yes.
Who's the next amendment we need?
Next one will be
Is that John Morey?
John Morey.
Okay. Thank you.
Thank you. He's at Rogers.
See, did Cece get back on?
I
Oh.
don't see her. Put my mask on. Okay, well, Mr. Atkinson is not responding. Maybe he's waiting to. You can hear him. Okay, so we've done Lawson. Next
He's
one.
already been continued. He's not gonna wanna see him, is he?
No, not the same last time. I don't think he will. Mr. Atkinson, can you hear me? Mr. Atkinson. Let me see if I can email him. What's going on? Let's see. Okay. Okay, that's fine.
I'm gonna go ahead and head out to Smith and wait on us to go ahead and do this training. So we can have our backup person for the next savings.
Oh, we can't live without you.
This is genius, right? This is genius right here.
Good to see you.
It's good to see you as well, okay?
All right,
I'll
take
see you
care.
next time.
All right. We'll see. Drive
Okay,
safely.
Let me know, I'm right down the street, on the phone call away.
All right. Drive safely. Let's see. At Trace Atkinson. Let me call him. He may just be waiting till 1 o'clock.
No hurry, we got 3 minutes.
Let me just. Yes, ma'am. Good afternoon. My name is Hector. I'm a law clerk with the Atlantic Circuit here in Georgia, and we're holding hearings via WebEx. We got Mr. Atkinson on, but for some reason I'm not him to respond. I was wondering if you can transfer me to him, or. Thank you. There you go. Mr. Atkinson, can you hear me?
I can. Good afternoon.
Good afternoon. Okay, we got you. Let me make sure that we got Mr. Zell. There we go.
I got a call from your clerk, I believe, Judge. I apologize. I heard 1 o'clock and I saw it was 12:59. I was going to try to get one more bite in.
Go ahead. Go ahead.
No, it's all right. I got it.
This one's a warrant. And I'll send that over from you.
Yeah, that's Lawson.
Yes,
Yes.
We're waiting on. I'm sorry, sir.
Waiting on Mr. Zell.
No, we got Mr. Zell. Can you say something so we can verify your microphone again, Mr. Zell?
I'm here.
Thank you.
I'm not seeing him come up on the screen, which is.
Can you say something again, Mr. Zell, so we can, you can come up on our screen?
Okay, I can hear myself, and I can hear you.
All right, we got you.
Okay. You look the same as you did an hour ago.
Rough and old and out of shape.
You said that, I didn't.
It's amazing how you view yourself as you get up there in years, you know.
All right, we'll go ahead and call this case number 2019 HC 55. The petitioner is John Erskine. The respondent is Linton Deloach. All parties are present. Mr. Zell representing the petitioner and Mr. Crowder representing the respondent. Gentlemen, are you ready to proceed?
Yes, we are.
Ready, Your Honor.
Mr. Zell, you have a witness?
Yes, Judge. Mr. Atkinson is here. He was plea counsel. And then being that this is a guilty plea, Mr. Martin's needs to testify as well.
All right, then Mr. Atkinson, please raise your right hand. Do you swear or affirm the evidence and testimony you give this afternoon will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, counsel, you may proceed.
Thank you, Your Honor. Good afternoon, Mr. Atkinson.
Hi, sir. How are you?
I'm doing all right, thank you. So the first thing we always ask is kind of tell us a little bit about your legal background.
I went to law school in 2000, graduated in 2003 from Catholic University in Washington, D.C. I was given a presidential appointment to the Department of Transportation from 2003 to 2005. And after that, I worked a variety of contract litigation cases, primarily in hormone therapy litigation for Pfizer and Wyeth, until around 2009, when my wife and I were married and decided that we did not want to live another minute in Washington, D.C., so we moved south and had a child, and I took and passed the bar and was sworn in September, I believe, of 2012.
Okay. So I get in 2012, is that when you began handling criminal defense?
I did.
2012?
I did. I had done some pro bono work in Maryland and D.C. prior, but it was just simply favors to friends and recommendations where there had been an indigent who someone knew who didn't have any representation in simple cases, DUIs, family violence, battery.
So is involving your position or your occupation, were you in private practice or did you go to a public defender's office?
I opened a practice in 2012, and when immediately and upon my passing of the bar, and then when the ACA hit, if I recall correctly, my family's insurance plan went from around $14,000 a year to $48,000 a year, and I didn't have it in my budget. So I was offered a position by Michael Parham, who was then the public defender here in the circuit, who I had a lot of respect for, and took the position in, I believe, January of 2015. Maybe 16. I believe it was 16. This is my 5th year. I just celebrated my 5th year here with the Public Defender's Office.
Okay. So this case would have been early of 2018. So at that point, would you have an idea of how many guilty plea hearings and felony trials you had conducted or been first counsel of at that time?
Pleas, I would say several hundred. Trials to the verdict, 5 or 6.
Okay.
Mostly large, what I consider to be large cases, child molestation cases.
Okay. And this was a trafficking case. So as far as trafficking goes, had you had some trafficking pleas or trials as well?
I had some smaller trafficking pleas. I had not tried a trafficking case to a jury.
Was this one of the bigger, when I say bigger, I mean amount-wise, weight-wise of the drugs, was this one of the bigger or the biggest trafficking case you had handled up to this point?
Yes, it was.
Okay. And do you recall the amount of drugs involved here?
There was approximately a kilogram of methamphetamine recovered and some incidental marijuana.
Okay. All right. So now at some point, did you develop any kind of defense for the case or strategy?
Well, the strategy was to get the stop suppressed. That would have been ideal, is to have the officers stop and any of the fruits of that stop suppressed by the judge, and that would have taken care of the case. However, Officer Tucker testified very well and I think very honestly, and despite my best efforts, the judge ruled against us and upheld the search as being constitutionally valid. And at that point, I told John or Mr. Morey that I'd be more than happy to try his cases. In fact, I'd much prefer to try a case than plea a case. And it was, and I'm not the attorney that tells my clients that if they go to trial that they're going to get a worse sentence from the judge. Now that can happen, but I think it's unfair. It's not been my experience that is the case, and I believe attorneys tell their clients that because they don't want to go to trial, and I wouldn't do anything to prejudice a client. However, making the state prove their case is his right, and it's my duty to assist him in making the state prove each and every element of each and every crime alleged. But Mr. Morey did not want to go to trial. I'm confident that I conveyed to him that I believed if we were to plea and not take up what ultimately would be weeks of court time, that the judge should go more lenient on him, but that wasn't anything I could promise.
Okay, let me back up a little bit, because there was something I wasn't quite clear on when you said that you're not the type of attorney that or in the cases where people do have a trial, they're punished harsher. I'm not sure if I heard you correctly. That's all. I'm just trying to see if you can clarify what you said regarding that.
I have heard personally, and I have seen on television, like we all have, where the attorney tells the client that if they go to trial and they're convicted, that the judge will throw the book at them and give them the maximum and run them consecutive. And that's just not my experience, and I think it's abusive towards the client. Now, if I have a judge that I know that would do that, I would be obligated to tell my client that I thought that the judge would do that. But I know the judges in the circuit pretty well. Excuse me. I know them pretty well, and my clients where we've lost at trial have not been punished in that manner. Now, they've been sentenced, of course, but they've not been punished for exercising their right to a trial.
Okay. Now, you obviously filed a motion to suppress, and a motion to suppress was conducted. Is that right?
Yes, it was.
Okay. So at least for part of the time during your representation, you and Mr. Morey were fighting these charges, right? You didn't just ultimately plead guilty right away or accept a plea bargain right away. The charges were contested for a period of time.
Yes, of course.
In your circuit or with this judge, is there any issue? Sometimes, or with the DA's office, they once you litigate an issue, a legal issue in which a witness is called, they kind of punish you a little bit more, or kind of take away any kind of favorable plea deal. Is that the situation here, or not really an issue?
I don't remember that being the issue here, but at the same time, I looked at my notes and I looked at the emails, and it's my recollection and my experience with this district attorney's office that if we don't take then they change their mind come plea day if we're going to go to trial, or let me take that back. They oftentimes change their mind and will offer pleas that they say they won't. If we insist on going to trial, they'll offer mid-trial pleas or last-minute pretrial pleas. But that being said, once we do start to defend the case, they at least threaten to take any good deals off the table.
Was there a plea offer to your recollection before the motion to suppress?
I don't believe so. I've checked, and I'll check again while we're talking here. I could not find a plea offer in my I couldn't find a plea offer in my file.
Now, with this kind of case being in trafficking more than 400 grams, the sentencing range is fairly limited. Is that fair to say?
Yes, that's my understanding of the statute.
I mean the minimum. What is do you call the minimum sentence that for the actual?
I believe it's 15 to 30 or 15 to 20. I don't have it.
Okay.
I don't have a case currently right now, and I haven't printed the statute in a while.
And
it's up to 30. I mean, let me rephrase. I know that the maximum is 30.
Pretty much every drug case is up to 30, isn't it, though? Possession, intent, and all that kind of, right? Is that right?
Yes. The minimum on this one, I can't recall if it's 15 or higher. Okay. I believe at the time, is my recollection, that it was higher.
Okay. Was there a plea offer after the motion to suppress?
No.
Okay. Was there? So when Mr. Morey pled guilty, was this non-negotiated or negotiated?
It was a non-negotiated plea. We just pled up in front of the judge.
Was it how soon after the motion to suppress? Immediately or sometime later? Do you recall?
It was sometime later. It was scheduled for a plea hearing.
It was scheduled for a plea hearing. Was it on a trial calendar or just scheduled for a plea hearing?
I'm looking at my notes, and from what I can tell by my notes, I've got a list of juror panels. So I'm confident that I would not have those in my file were it not the next case on the calendar.
Okay, so your belief is it was on a trial calendar when it pled guilty then?
I not only think that it was on the trial calendar, but I believe it was number one. We were going to trial, or we were going to plea.
Okay. Is just in your circuit? Tell us what circuit we are in.
It's the Appalachian Judicial Circuit, which comprises Pickens, Gilmer, and Fannin County, Georgia.
Okay, and in this particular circuit, or specifically this county, does the judge go straight down the calendar list, or does he skip around?
It's skipped around. Primarily jail cases go first.
Okay. And was Mr. Morey in jail?
Yes, he was. I was unable to grant him a bond, and I have an order from the judge after our bond hearing that denied him bond, citing him to be a significant flight risk.
Okay. And would this being first on the calendar and him being in jail, this was pretty certain? Was this a fairly certain case to be reached on this trial calendar?
Yes, this would have been number one. I'm under oath, and I state that in my place. Okay. But I don't see how it wouldn't have been number one.
Gotcha. Okay. But it's fair to say that basically up until I guess almost the day of trial, because he pled guilty and he was number one on the calendar, that this was not a case that was pleading guilty until the very last minute.
Yes, that's my recollection.
And Is it also fair to say pretty much that the only defense in this case was that whether or not this was a legal search or not?
I didn't see anything else, honestly. I didn't see anything else that the judge had determined that the stop was lawful. I think the failure to maintain lane statute is far too vague to be constitutionally valid, but other attorneys and jurists disagree with my analysis. I went into me and Officer Tucker went into quite the depth of cross-examination directed examination of Officer Tucker regarding failure to maintain lane, because it's not a tight enough statute, in my opinion. It allows a driver to ascertain whether or not it's safe to leave the lane, and if so, a driver can leave the lane without breaking the law. So how Officer Tucker discerned from his cruiser that Mr. Morey had not previously ascertained it's safe to move the lane defies logic. They need to rewrite the statute. That being said, it's known as good probable cause when a driver fails to maintain lane, especially multiple times, and it was Officer Tucker's testimony that Mr. Morey had not once, twice, but I believe thrice crossed the fog and center line before he made the stop.
And in this case, so prior to Mr. Morey pleading guilty, do you recall where you were when you went over with Mr. Morey and talked about whether or not to plead guilty or go to trial? There,
it would have been at the jail in visitation, I believe B. There's 3 rooms. There's visitation A, B, and C, and we've been quarantined from the jail for a year, so I've forgotten how they letter them.
Was this a situation which the trial start on a Monday, and unless you plead guilty? Would that
motions? Yes, motions are final motions and pleas are Friday, mostly in the county and all 3 of the counties, and then we strike jurors on Monday.
So did he plead guilty on the Friday before the Monday trial calendar?
I believe so. Or if that isn't the case, we agreed that we would set it for a plea, and they tried another case, and we pled it another day.
Okay. And was this something that you recall specifically going to the jail to talk to him, or was it done, or did you have the discussion at the courthouse?
We had multiple discussions at the jail, and we had several discussions here at the courthouse about this.
Specifically about whether to plead guilty or not, or go to trial?
What we were going to do if we went to trial, I still don't see it any other way. If the suppression motion was successful, it's one thing, but I could not fathom an excellent defense. I mean, I was going to make the state prove each and every element beyond a reasonable doubt, but at the same time, I did not feel very strongly about him being acquitted. He consented to the search after what was determined to be a lawful stop, and that boggles the mind that one would do so, but he did, and he never told me that he didn't.
So the whole issue would be the legality of the stop, or the legality of the stop on appeal, because you didn't think he would have a chance of being acquitted.
Could you rephrase that? I'm not following the question.
So any advice would be, trials of conviction, but you can raise this issue on appeal. We don't really have a legitimate jury trial issue. We have a legal issue that it's only for a judge to decide.
And I don't know that I explained that to him post, that would be available to him post, in the panoply of the entirety of his post plea remedies or post conviction remedies. I don't recall specifically pointing that out to him.
I mean, it would be fair to say you probably told him he had a right to a trial, a jury trial. Is that correct?
Yes, of course.
Did you at all talk to him about perhaps waiving his right to a jury trial and have a bench trial?
We discussed that, and ultimately there was evidence admitted. It wasn't a bench trial. but honestly, I can't recall whether or not we really went over that. I know that I advised him that he had the right to it, but I can't recall much substance of the conversation, because the same judge that had ruled on the suppression was the judge presiding at the bench trial.
Correct. Right. So I assume so. I know that's not the case in every circuit, but did you ever have a conversation with the prosecutor about waiving the jury trial or stipulating to the facts as contained in the motion suppress just to preserve an issue for appeal?
No, I don't recall doing that.
And I guess the follow-up would be did you have any of those discussions with Mr. Morey as well?
I don't believe so.
Have you done that in your career before, as when you've had when you have a legal issue or like specifically a motion suppress is where it really usually arises, where you just either waive your right to a jury trial or stipulate to the facts of a motion suppress just so you can appeal the issue of a motion suppress?
No, I have not had that opportunity.
Okay.
And in looking back at it, and in looking back at all of my trials, the ones that I've won and lost, it's much easier to look back in time and determine what you wish you had done and what you'll do in the future.
I guess we're always learning. Is that kind of what you're saying? We hope we're always learning something new.
Well, hopefully we are. It's painful to learn, and it can be painful for the clients as well.
When you just spoke with Mr. Morey about his options, it was more or less, we've got, I guess based on your testimonies, you don't really have a chance of being found not guilty by jury.
I thought it would be very irresponsible for me to tell him that I thought that there was any chance in hell that he was going to be found not guilty.
Prior to this conversation, or maybe even prior to the motion suppressed, did you inform him or did you explain to him that your best or only defense would have been, is this motion suppressed? Is whether or not the search was legal or not?
That's where we were hanging our hat. And I'd prefer to have lots of hat hooks, but Mr. Morey didn't give me a lot of hat hooks. He was driving through town smoking a joint. He had ground flour in his car. The officer testified that he could smell the marijuana before he even approached the car. And Mr. Morey had a kilogram of methamphetamine sitting on the passenger seat in a backpack, to which he gave consent to search. And what was most frustrating of the entirety of the case was that Mr. Morey had from what I understand from Pickens PD, that he had a relatively sophisticated secret compartment built into his car that he could have placed the methamphetamine. And had he been pulled over for smoking the weed, then he would have been charged with DUI and possession of marijuana less than an ounce. And if I had been his attorney, I would have been able to get him probably $1,000 fine, 60 hours of community service, and he could have bought that out and a year of probation. I mean, it would have been a non-event. It was gravely disappointing. I don't think my disappointment is anywhere near that of Mr. Morey's, but at the same time, had they found the methamphetamine in the secret compartment, it would have been another opportunity to attack whether or not they had the right to get in there and did it correctly. But ultimately, the methamphetamine was sitting on the passenger seat in a backpack, to which Mr. Morey gave consent to search.
So the whole case is a search issue, whether the search is whether the stop, not the search, rather the stop. Really, that was what your defense was. Mr. Moore's whole case rests on whether the stop was legal or illegal.
That's how I saw it. Yes.
And did you tell that to Mr. Morey?
Innumerable times.
Okay. All right. And once the judge denied it, then of course the follow-up would be, appealing this to a higher court. Did you talk about an interlocutory appeal with him, or requesting an interlocutory appeal, or?
I thought it would be meritless. I told him we could, but it was my opinion that it would have no merit.
That you would win on appeal, or?
Yes, that we would not win on appeal.
Okay.
It wasn't novel. It wasn't the kind of case that I thought that I didn't think the judge ruled wrongly, and it wasn't my thought. But at the same time, I read a lot of appellate cases, and I don't mind I don't mind filing the brief and setting it up for appeal. But at the same time, I didn't think this one had any merit whatsoever. I'm confident. Well, who knows who could have got it? I can't speak for what the appellate court would have done, but no, I did not.
I thought earlier you testified that you did not really go over appeal rights with Mr. Morey.
No. I believe that was in the context of post-conviction appeals to preserve this for the record for after a trial. In that context, I don't recall going over that with him.
Okay, so you talked about going to trial, losing, and then doing an appeal to the Court of Appeals?
Yes, sir.
Oh, okay, gotcha. All right. Now, did you have any conversation with him about the the collateral consequences of a guilty plea? Like, in other words, the parole consequences, where he would, what the guidelines state, what's he looking at minimum wise, or any mandatory minimums he might have to do under the parole system?
I use not only the grid, but I find the grid to be less reliable as the Department of Corrections length of stay report, which they issue every month. And he and I went over the length of stay report, and were able to look at, to the best of our abilities, what people were sentenced for this crime and how many years they did. But I always explain to my clients that they need to reconcile themselves to doing the maximum. That there's no promise that they're going to get out early.
Okay, and in this case, was the range limited to what Mr. Morey's sentence could be based on the trafficking charge?
The range of a sentence?
Yes.
At the time, my recollection, until you and I spoke the other day, but it had been a few years, my recollection was that there wasn't a range. But in my file, I had, excuse me, I had the statute printed out, and we went over it ad nauseum, and Mr. Morey, my superior Jeff Floyd, and the judge and counsel for the state went into one of the private rooms and went over the statute in depth. And then me and Mr. Floyd being my superior, went and spoke with Mr. Morey about this. So while I wasn't familiar with them off the top of my head when you and I spoke the other day, I was very familiar with them during the lead up to the plea hearing and the day of the plea hearing in colloquy.
Okay. Did you talk to him about the parole statute dealing with trafficking and what the minimum, generally how it works? Did you review that with him?
I don't recall. No. I don't know that I didn't, but I can't say that I did. I certainly wouldn't do so under oath.
Did you talk about whether or not or did you advise him, or did you tell him, talk to him about whether or not there was much of a difference whether he went to trial or pled as far as the sentencing goes on these charges?
I didn't see. I recommended that he do what he wanted to do, but at the same time, I also recall explaining to him that I thought that the judge would, as far as the sentence goes, that the judge would be more lenient if we didn't take trial time, and that it wouldn't be dramatic, but that at the same time, if we were showing good faith, it's like showing remorse in some respects. I don't know how else to describe it. That I thought the judge would take that into consideration, that we weren't taking up the court resources and county time and county money, things of that nature, to try a case that ultimately was going to, in my opinion, lead to a conviction. And I believe that by pleading to the case, pleading up, that the judge would show some leniency.
Which in this case, which he did not, right? Okay.
Which he did not, to my grave disappointment. I'm still truly disappointed and shocked that Judge Wooster didn't take that into consideration. Or perhaps the methamphetamine problem in this county is such that it didn't matter if we went to trial or not, that he was gonna load him up with with a long prison sentence.
Okay.
I don't know. I've not been able to have that candid conversation with the judge.
Did you talk to him about, now you actually pled guilty and without a plea bargain and tried to get the judge to go below the mandatory minimum, is that correct?
It's my recollection that we were looking at the deviation and that I did not think, and you and I spoke about this when we spoke just the other day, I didn't think that Mr. Morey qualified for the deviation due to his, while not lengthy, due to his criminal history. But that could just be my memory playing tricks on me.
Okay.
That I'm misremembering.
Okay.
I didn't believe, if you had asked me last Friday before we spoke whether or not Mr. Morey was qualified for the reduction, I would have said no due to his minor, but the fact that he had a criminal history.
Well, actually, they did not, there was no criminal history, was there, proved at the plea hearing? Is that right?
It wasn't, I don't know. We'd have to check the transcript. I have a copy of his rap sheet that the state provided me. So I don't know I can't recall if they entered it into evidence.
And I think lastly, I'm going to ask you, regarding this, the going below the minimum, have you ever been successful in that in your circuit or before this particular judge?
Often. Even when the amount is significantly over, we're able to oftentimes negotiate it to a lower tier, and by virtue of that, move the minimum down, the sentencing guidelines down.
You're talking about what the negotiated pleas?
Yes, not a deviation from the sentence, but a reduction of tier, which ultimately serves the purpose even better, especially with regards to how long the length of stay report indicates that the client would spend in jail.
That involves the consent of the DA. Is that correct, what you're talking about?
It does, and it takes some time, but yes, it does require the consent.
In the situation in which the DA does not consent, have you ever been successful doing that?
No, I have not.
All right. Okay.
I have been successful to the extent where I have been able to prevail upon the judges and help court, being Judge Wooster and the head of our drug court, to ignore, if you will, the wishes of the district attorney and permit someone into the drug court who otherwise would not qualify due to the amount of contraband or methamphetamine, heroin, etc. that they were found with. But that's a little bit different scenario.
Okay, that's all the questions I have. Thank you.
Thank you.
Hi, Mr. Crowder.
Thank you, Your Honor. Mr. Atkinson, I'm assuming that because of your working for the Public Defender's Office that you were appointed for Mr. Morey's case?
Yes, sir, I was.
And you've mentioned a few of these already, I think, but do you recall what all the charges were in Mr. Morey's case?
He had two cases. The first case was possession of methamphetamine, possession of drug-related object, possession of marijuana less than an ounce, failure to maintain lane, and there were a few other minor charges on that indictment. And then there was another indictment that he ended up with while he was in the county jail. And it's my guess that that's why the judge was harsh with him on the sentencing as he was.
All right. And what did you do to investigate the case?
Excuse me?
What did you do to investigate the case?
Read the police reports, had my investigator who's ex-law enforcement, interview the arresting officer and the two, if I'm not mistaken, the two training officers that were in the cruiser at the time of the arrest. We looked at the evidence. despite the nature of the charge and the gravity of the sentence, I didn't have a whole lot to investigate. Mr. Morey isn't from here. He didn't know anybody here. He wasn't able to. He didn't provide me with anybody who the name, for example, of somebody who had given him that backpack to travel with. So my investigation was somewhat small in scope, but it was as far as I could go, as far as I knew to go. I couldn't see anywhere else to take my investigation.
Okay, so when you say small in scope, it's not because of a lack of effort, but it's because of just the nature of this particular case.
I joke with my clients when I meet them at the jail for the first time, and I say, unless they've got you on camera naked doing the crime, holding up your ID, we've got a defense. And in Mr. Morey's case, he wasn't naked, but he satisfied a great deal of those points. I didn't see a defense. Again, I can't make up evidence with regards to whose methamphetamine it may have been or something to that effect. And I felt very limited in my representation with regards to my defense of Mr. Morey, and that the stop was sustained as a lawful stop, and then most infuriatingly, Mr. Morey consented to the search and didn't avail himself of his secret compartment. I went as far as I could go. I investigated everything my investigator, and my boss, and my associate could possibly think of to help Mr. Morey.
And did you feel that you had sufficient time to discuss the case with Mr. Morey?
I did. I've got unlimited access to my clients at the jail. That's changed with COVID, but I still have access to them via WebEx like we're doing now. So there was not a time when I would have not been able to speak with Mr. Morey, and he was able to tell the jailers if he needed to speak with me, and they'll send me emails so that I can get over there quickly and meet with clients, and would have with Mr. Morey. There was no lack of our meeting together.
All right, and did you review the discovery with Mr. Morey?
Yes, I did.
And you mentioned, I think, the 3 officers that were on scene. Were there any other state's witnesses that either you or the investigator spoke to?
There was the other case that the state was using to aggravate the sentencing. Mr. Morey was indicted for allegedly attempting to smuggle methamphetamine into the Pickens County Jail and using the telephone systems to do so with 2 other co-defendants. And that case is still outstanding.
And I'm assuming that, based on your answer before, that there were no defense witnesses identified for you to speak to?
No.
Did you conduct any legal research in the case?
I researched the statute. I did quite an exhaustive dive into search and seizure. I don't know if you've had an opportunity to read the transcript, but I believe my work with the arresting officer over the failure to maintain lane statute should be used to overturn the statute as being unconstitutionally vague. I didn't have nearly as much to work with. You get a case assigned to you that has a kilogram of methamphetamine, and it's larger than most of the cases I see. So it was definitely of great legal interest to me. And when it came down to it, there just wasn't a lot to dig into. Whatever he was involved in was not related to Pickens County, other than his arrest.
And aside from the motion to suppress, were there any other pretrial motions or hearings that you did prior to the guilty plea?
Not that I recall, other than in the middle of the plea, or I believe we had. Don't hold me to this, but this is my recollection. We had entered the plea, and before sentencing, the state went to introduce the evidence of the other other acts, and the new case that was coming forward with regards to the alleged meth dealing or meth smuggling into the Pickens County Jail. And during that, the drug task force officer who was on the stand indicated what I heard him to say was that he had had access to my emails to my clients. At the time, we were using an email system where we could email our clients. And of course, we were careful not to put any work product in there, but when I understood that the drug task force had access to my firm's emails with our clients at the jail, we withdrew the guilty plea before sentencing and basically said we'll see a trial. And at that point, all hell proverbially broke loose, and I was on my way to call the FBI and have that looked into. And then we realized that the drug task force agent had not quite explained himself clear enough, but the way it sounded on the record was that they had been reading our emails. So at that point, we got back, we did the plea again, and moved forward with sentencing.
All right, and I'll actually going to come back to that a little bit later too, in terms of the progression that you just covered. Did you discuss with Mr. Morey the weight of the evidence the state had against him?
I did.
And were you satisfied he understood that?
He's a smart man. He well understood it.
Okay. Early on in Mr. Zell's direct, I believe you stated that Mr. Morey did not want to go to trial. I'm assuming that you guys had discussed the possibility of going to trial in this case.
We had. It was his decision. I tell all my clients I'm perfectly happy to take anything to trial. It's not my case. Ultimately, it's their decision, and I try to advise them as to what I believe would be in their best interest, and I try not to let what they've heard, because even clients who've not been in trouble before have watched enough television to repeat that mantra that, well, I've heard that if I go to trial and we lose, I'll get the maximum, and I try to explain to them that that's just not my experience. But I don't try to push them towards trial. I try to help them make an informed decision as to whether or not they should go to trial.
Now, in terms of Mr. Morey taking the stance that he did not want to go to trial, is that something that he was expressing to you even before the motion to suppress was heard?
No. We hadn't even discussed trial. The motion to suppress, I like to keep things organized, and trial was, I can't recall exactly what I would have said, but I would have said it many times that if we're going to go to trial, we'll prepare for trial. But right now we're working on the motion to suppress, and if we win that, we don't have to worry about the trial.
Okay, and at that point, had you also told Mr. Morey that, as I believe you stated on direct, that really the case hinged on whether the search was valid or not?
Yes.
Yeah. Okay, so then after the motion to suppress was denied, is it at that point that he expressed that he did not want to go to trial?
It wasn't that it was just over. It was, we discussed the ramifications of that denial and determined that, and I went to the state and tried to get a better offer. And the second case that he had caught while he was at the Pickens County Jail was not assisting me with getting any sympathy from the state.
Okay, did Mr. Morey, so go ahead.
Well, I mean, as Miss Mackey, I think that was her last name at the time. That isn't her name now, but she may have been under her married name at the time, or her maiden name at the time. I remember trying to negotiate with her, and she said, "We have a stranger coming through the town with a kilogram of methamphetamine who is put in the Pickens County Jail, and he immediately starts conniving and plotting to bring more methamphetamine into the jail," or something to that effect. She was not sympathetic, and she was not willing to negotiate. And I think she thought her case was ironclad. She and I have negotiated hundreds of cases together. I would want to say 1,000, but I don't know if it's gotten that high. But hundreds and hundreds of cases she and I have negotiated together in good faith. And that being said, sometimes we disagree on how the other sees the case, of course. But with Mr. Morey, Miss Mackey was not interested in negotiating.
And did Mr. Morey express to you why he did not want to go to trial once the motion to suppress was over?
Well, after the motion to suppress was over, I would have told Mr. Morey that I thought our chances at trial were extremely poor, especially considering the 404B motion that the state had filed, and that it was my belief that if we went to trial, that he would be convicted. And while the judge wasn't going, in my opinion, to sentence him to the maximum for each of the counts that we were unable to gain an acquittal or not guilty verdict on, that there would be a higher penalty associated for going to trial. But I didn't use that to dissuade him from it. But I thought we had a very weak case, and I didn't hide that fact from him.
Again, you testified a minute ago that the prosecutor was not willing to negotiate, and I just want to understand, were there any plea offers actually made in this case?
I don't have any record of any plea offers made in this case. If they were oral, or my file is incomplete, but I've got a paper file, an electronic file, and the clerk's file, and oftentimes the plea offers are made a part of the record, and I have not run across it.
Okay, assuming that there had been, would you have communicated that to Mr. Morey?
Yes.
Okay. And ultimately, whose decision was it to enter the guilty plea?
Mr. Morey's.
And before the guilty plea hearing, did you explain to Mr. Morey the constitutional rights that he'd waived by pleading guilty?
I did, and then the judge did twice because of the double plea during the colloquy. But I would have gone over them personally with him, and I did go over them personally with him. And then the judge went over them once, and then we withdrew the guilty plea prior to sentencing. And then when we entered the plea again, the judge went over them a third time.
Okay, and that includes the right to a jury trial?
Yes, and to subpoena witnesses and to call them and not testify and to use the subpoena powers of the court. The full colloquy.
And to confront adverse witnesses?
Yes.
And to not incriminate himself?
Yes.
Okay. And were you satisfied that Mr. Morey understood that by pleading guilty he would waive those rights?
Yes, and he affirmed on the record that he did.
Okay, and you were also satisfied that he understood that he had those rights?
And there's no way that he didn't understand it unless he was perjuring himself, and I can't imagine that he was, because he stated under oath twice that he understood those rights, and that was irrespective of the times that I had gone over them with him.
Okay, and had you advised Mr. Morey of the range of sentences on the charges?
I had.
Okay. Mr. Zell asked you about whether you considered a bench trial. Is that something you and Mr. Morey discussed?
We discussed it, but shortly, as I believed that the bench trial was the judge that heard the suppression hearing was the judge that would preside over the bench trial, and the bench trial was going to be another recitation of the stop. I mean, that was our defense, and we were looking for some grace. I was looking for some grace from the court, and I nor my client received any from for not taking up even time for a bench trial.
And was there any discussion about pursuing something that could have opened the door to having a Court of Appeals look at the motion to suppress being denied, whether it was an interlocutory appeal or going on to some kind of trial?
No, I did not. I didn't think there was merit in. I did not think there was merit in an interlocutory appeal, and chose not to do so, and told John as much, or Mr. Morey as much. But I did not. I did not explain to him that if we went to a bench trial, that issue would be better preserved.
Did he express any desire to try to challenge the denial of the motion to suppress?
Not that I remember.
Okay. On the going back to the sentences, did you advise Mr. Morey about any mandatory minimums in the sentences for the charges, especially the methamphetamine trafficking?
I did, and the judge did. I say the judge did. I know the judge did because I've practiced in front of this judge long enough. In my very first plea in front of this judge, he asked my clients what the mandatory minimums and maximums were for each of the counts. And, well, he asked me if I had advised them, and I had, but we didn't recall them off the, I apologize for my phone. I couldn't get the WebEx to work on my computer, so I'm having to use my telephone, and my head's skewed sideways. So I apologize to the court and to you, Mr. Crowder. I know this judge, I don't believe he's done a plea and not made the defendant place on the record the plea himself. Or not the plea, but the mandatory minimums and maximums. Judge Wooster always does it for every one of the counts.
Did you express to Mr. Morey that given the way the sentencing scheme is, based on the high level of number of grams of methamphetamine, that it may be just as well to go on a trial because of the way the mandatory minimums were?
I did not.
And I think
there were other things in play. I mean, primarily the new case that he had been charged with, which carried some substantial penalties as well, and the state had indicated that they were willing to entertain running those concurrent with whatever the judge sentenced him to in the case we're speaking of today. And I believed globally it was best for Mr. Morey to plea up, and I advised him as much to let Judge Wooster leave it in Judge Wooster's hands. And ultimately, in retrospect, I'm really surprised that Judge Wooster sentenced him to what he did.
And did you explain to Mr. Morey what a non-negotiated plea entailed in terms of there not being an offer and that sentencing was totally up to the judge?
Yes, as did the judge.
Okay. Were you satisfied he understood what that meant?
I'm satisfied that he did, and this fact that he testified under oath twice that he did. And in my own personal conversations with him.
Yeah, going back to what you mentioned previously about withdrawing the plea in this case, how much of a gap was there between when you withdrew the plea after making the discovery during the hearing about the emails and then ultimately coming back and re-entering the plea? How much of a gap of time was there between those two things?
Mr. Crowder, if you could help me with the plea date, I think it was the same day, as a matter of fact. But I withdrew the guilty plea, and re-entered a plea of not guilty on April 17th, 2018.
Yeah, well, and I can just express the cover page on the plea transcript says April 17th and 18th.
Okay. 17th and 18th. That rings a bell that we would have come back and finished it up the next day.
Okay.
Because this was at the withdrawal of my guilty plea, or Mr. Maury's guilty plea was at 4:32 p.m. on April 17th.
Okay. During the interim period between those two things, did you, I'm assuming, discuss with Mr. Maury how he wanted to proceed, if he wanted to re-enter the plea or not?
Yes.
Yes. And at that point, did he give any indication about wanting to go to trial instead?
No. Well, we thought we had stumbled upon some incredible malfeasance on the part of the drug task force, and I believe if I had discovered that the drug task force had been reading our emails, I'm confident that Mr. Maury's and other of my clients' cases would have turned out quite differently, and not to the benefit of Pickens County and its reputation, but that wasn't the case. So we were able to get to the bottom of what the detective was testifying to in terms of what he explained and what was actually happening with our emails over there.
And did you explain all that to Mr. Maury after you figured out what was going on?
This was done on the record. This should have been done. No, this was done on the record. I can't say that 100% of it was, but the sheriff ended up jetting over the court. I mean, this is the allegation that I was making under what I had heard testified from the bench or from the witness box was of such a nature that half of the Pickens County Sheriff's Department seemed to be filling up that courtroom to figure out what the heck was going on. And I had, I'm blanking on his name was Pete, and I'm forgetting his name. There were twins who worked for the drug task force, and I forget which one of the two was on the stand. But I kept him as a witness on the stand to go over how this works. I believe Heather Wofford, who works at the jail, she's a lieutenant or was a sergeant at the time and was managing the emails, came over. I believe she testified. So Mr. Maury would not have been precluded from that.
Okay, but once you determined what was really going on, you felt comfortable with going ahead and having Mr. Maury enter a guilty plea?
Yeah, I thought we had we had something to work with, and then I realized that we didn't.
Okay. And Mr. Maury never used that as a reason to say, no, I want to go on to trial.
Well, there was nothing to go on. There was a misunderstanding ultimately. What had occurred was the way the detective testified sounded a certain way to everybody because he spoke poorly, I suppose. But when we figured out what was actually happening, they weren't reading our emails. They didn't have access to our emails. And there was no malfeasance on the part of the Sheriff's Department or the Drug Task Force with regards to our communications with our clients. So at that point, we were back in the position we were when we had started the plea. We hadn't gained any additional defense.
Okay. In terms of the deviation issue in the sentencing statute, do you recall making a presentation on that and going through all the factors in the statute that you need to show at the initial plea hearing?
Honestly, I can't recall. It was my recollection, I believe I testified earlier, that it was my memory that Mr. Maury would not have qualified for the deviation. I've since read the statute, and I would have read it at the time because it's here in my file, and I would have gone over it with John because he sat right beside me during the hearing. But I did not think that Mr. Maury would have satisfied the requirements for the deviation. When I look at it now, I think the judge could have deviated, but the judge chose not to. I think primarily because of the new case that he had caught while he was incarcerated here in Pickens County.
And I believe your testimony on direct was that you did not think you would have qualified because of his criminal history.
That was my memory. Again, that was my memory. That is my memory, but I can't state for certainty what it was at the time. It would have been an informed. It would have been an informed advice that I was giving him.
Okay, but the transcript would speak for itself on what happened with regard to that.
Yes, it should. Everything was taken down.
Okay.
I say everything was taken down. Everything should have been taken down. If it wasn't, then we have an issue there.
All right. Do you recall making an argument that Mr. Maury had no prior felonies in that context?
I don't recall making that on the record, no.
Okay.
That doesn't mean that I didn't. At the same time, I don't recall doing that.
Prior to, well, let me start over with that question. Would you have advised Mr. Maury about your intention to argue for a deviation and what you would have to show for him to qualify for such a deviation prior to the hearing?
Yes, and it's my recollection that we went over that in depth, and I don't recall the facts and circumstances of the deviation, but I remember that being a big issue because the deviation is quite substantial, or can be quite substantial.
And you would agree with me that there are 5 different factors that you would have to show to get the deviation, and it's an and situation and not an or situation where you've got to show all 5 of them.
That was my understanding. I did not think Mr. Maury was a candidate for the deviation. I didn't think he satisfied the statute. And I can't sit right here and tell you why exactly I didn't, but I remember at the time thinking that it's kind of the Boy Scout deviation, that you more or less have to catch a huge criminal felony and have been all but a Boy Scout up until that time. So I don't know who would actually qualify for the deviation.
Okay.
Does that make sense? I mean, the way it's written is that in order to qualify for it, most people who are going to be charged with such a high-level crime aren't going to satisfy this. It's going to be a very rare person who satisfies for the deviation.
That's all I have at this time, Your Honor.
All right, any follow-up, Zell?
I want to try and clarify something regarding the interlocutory appeal. I think are you testifying that, or did you testify that you didn't think you have your chance of getting granted an interlocutory appeal so that you would have a direct appeal was high, or just your appeal in total, just your total results of the appeal?
I didn't think it would be a good use of. I just didn't think it would be meritorious.
Does that mean the judge granting you the right to an interlocutory appeal, or just the appeal itself, or just the actual substance of the appeal?
The substance of the appeal.
Does that mean that when you filed the motion to suppress, you did not think it was not a meritorious motion? You thought it was a loser?
No, not at all. I think if we can read, if we want to read the failure to maintain lane statute, it's all of us who were in this meeting who went to law school, none of us can with a straight face say that it would pass the standard of not being constitutionally so vague as to it's not enforceable, but officers use it every day to pull people over and to search their cars and to escalate escalate their policing, where the statute in itself allows the driver to ascertain whether or not it's safe to leave the lane.
So when you filed it, you believed it had some merit?
I was hoping it had a lot of merit. I was looking forward to being the attorney who had his name on the case that overturned or made them rewrite the failure to maintain lane statute.
If you believed it had merit when you filed it, does that not mean that you believed it would have had merit if you appealed it based on the same legal reasoning?
No, because ultimately my hopes and dreams in court are belied by the lengthy Westlaw and Nexus case notes that that the Court of Appeals and the Supreme Court, pardon my language, well, I don't need to curse. It's nothing that they're interested in overturning.
Was this not known to you before you filed the motion to suppress?
It was, but if you'll recall, Mr. Zell, I had nothing else.
Okay.
I mean, when I say nothing else, I had nothing else to defend Mr. Morey with.
Okay, and you also referenced in response to Mr. Crowder that something of a new charge that Mr. Morey was faced after he was arrested.
Yes, that's still outstanding.
Okay. So that was not something that you included as part. It was not included as part of the plea bargain for a concurrent sentence.
No, it had not been indicted.
Okay.
And
or an explanation of prosecution either, that the state would not seek an indictment or not prosecute it based on a plea of guilty.
No, she was. We had discussed, and I have an email to the effect that she was true to her word that that she would plead this concurrent, the new case concurrent. But by the time she got it, Miss Mackey got it indicted, Mr. Morey had made allegations of ineffective assistance of counsel, so I had removed myself from his representation.
But it was never made part of the record at the plea hearing or in writing that somewhere that this would not be, if you pled guilty, that this charge would not be consecutive or
I don't recall that the new case was included in the record. However, what part of it would have been was the drug task force testifying to the facts of the new case. That's how the email issue came up.
And you also testified regarding wanting to get some goodwill based on not having either a bench trial or a jury trial. Is that?
I mean, I might not be using the best of terms. I mean, but there is, I believe there is goodwill in court, and attorneys in civil matters and in personal matters, they understand how I don't even rephrase. Plenty of attorneys tell their clients that they're going to get just hammered if they go to court and if they take up the court's time. That's not my understanding, and it's not my experience, and it's not my habit to tell my clients. At the same time, trials are expensive. Bench trials less so, but at the same time, they're expensive and time consuming, and it just makes sense to me, and it's always made sense, and I've always had positive results where the court understands clearly that the reason we're pleading up, for example, is that we are looking for some goodwill, that we're acknowledging guilt, and we're stipulating the factual bases and things of that nature that would take up time. And not that the court shouldn't take time. The court should take all the time in the world it needs to properly convict someone. But when you've got a case like this, where there is a possibility of a deviation, this would, I was truly hoping that Mr. Morey would, or that the judge would find a way to reduce his sentence. Part of the reason, because I was also pretty sure that in this particular case, had we gone to trial, having what I consider to be no defense, that the judge would have, I don't think he would have maxed him out, but I think he would have sentenced him a little bit harder. And in fact, what we found was, I don't think the judge could have sentenced him that much harder had we gone to trial. So that's the burr under my saddle to this day with this case, is that Judge Wooster gave us no no benefit for our acquiescence.
And you did, it wasn't just a simple guilty plea, right? I mean, you did try for the deviation, correct?
I didn't think he qualified for it, but there was much talk of it.
Okay. But you did try. I mean, right? I mean, you'd argue for it in the plea court, in the plea hearing.
I believe so. I would. If I didn't, then I was remiss.
And the police officer, I mean, he went through a lengthy testimony during the hearing about whether or not to whether or not Mr. Morey satisfied these factors, these 5 factors for the deviation.
The police officer?
Yes.
I don't.
The reason I'm asking is because there's not how much difference would there have been from a trial, for instance, and the officer testifying anyways to what happened.
I see. I understand what you're saying. I don't recall. It turned into quite a mess when I thought that the drug task force for our circuit in North Georgia had been reading jail emails. It tainted that day, and my recollection is not as pure as it is with some of my other cases.
And because right now you're testifying that you did not think he qualified for the deviation, but you did try for it.
What do you mean by try for it? I know I'm confident that I asked for it.
You tried to present evidence and you made argument to the judge.
Yes, I would have asked for it.
Okay. And in that regard, it would seem fair to say that you likely told Mr. Morey that he might qualify for a deviation.
I don't think I told him he qualified for a deviation because it's my recollection that I didn't think he did.
Okay, so was he unaware that you were going to make this argument or present any evidence at the plea hearing about this?
I'm looking back at the rap sheet and I recall him having. Again, I apologize that I can't remember it as well as we would all like me to remember, but I remember that he was he had been charged in Tennessee with let's see. There was a felony aggravated assault from some time back. I wasn't sure the disposition of that.
Well, needless to say, that if the plea hearing says that he had no prior felonies, you would defer to the plea hearing?
Yes.
Okay, so if the prosecutor made that representation and you make that representation, it's probably pretty fair to say that this was
yes.
Okay. So, but
if that's on the record, but I don't think I'm confusing this with another case. This case was unique. I have it in my mind that he didn't satisfy the elements to get the reduction. That I couldn't shoehorn him in there. That I wasn't able to offer evidence.
Do you recall that the officer, what was his name, Atkinson, testified for probably a few hours at least?
No, I'm Atkinson.
During the plea hearing? Oh, I'm sorry. That's right. You are Trace Atkinson.
You can help me out by telling me which of the officers it was, because I'm just unable. They left under less than perfect circumstances. The Delatore brothers. Yeah. It would have been one of the Delatores.
I'm going to let's see here. Delatore. Right, that's who it is. Yeah, he testified for a pretty long time during the plea here. I mean, it was a long direct and cross-examination. Do you recall that or not really?
I mean, I recall it, but yet again, I want to remind you that during the cross-examination, we withdrew Mr. Morey's guilty plea, and that was not an insignificant or a low adrenaline thing to do when I had thought that the Sheriff's Department and the Drug Task Force had been sneakily reading our correspondence with our clients for some time. So I don't remember how long it was or how long he was on the stand. I just don't recall.
I'm just talking specifically about the actual facts of the case and not anything else.
And I don't have access to the transcript, so I'm at somewhat of a disadvantage. I can agree to you. I will agree that anything that's in the transcript would have been stated.
So just back to do you recall whether or not this was something you discussed with Mr. Morey, that you would, that this was going to happen in the court regarding this moving for a deviation? I mean, are you saying he didn't know at all, that you were just going to go into court and ask the judge that he knew what the mandatory minimums were, but he wasn't aware that you were going to try and ask for less than that?
I know he knew I was going to ask for it, but I told him that I didn't think that there was any chance that he was going to get it.
When you told him this, do you recall if it was at what point during his decision to plead guilty it was? Was it before he decided, or was it something that was just all together? You know,
It would have been. I remember one time at the jail. I remember one time after we lost the suppression hearing. I remember another time at the jail when we talked about it. There were several times. I mean, every time we met, we would have discussed it.
I'm talking specifically about the request for deviation.
That's exactly,
okay.
That's what I'm talking about.
So ongoing during your representation, you talked about that with Mr. Morey?
Yes.
Okay, gotcha. So
and
you
may
did
have
that several
predated.
times?
And I know that there were at least 3 times after the suppression hearing, and we may have discussed it prior.
Okay.
But I can't recall. It's just when I've got a suppression hearing, let's win the suppression hearing, and then we're done. Like, we don't need to worry about it. So ultimately, I like to run my cases and try to. I don't see any point in preparing for a sentence deviation if we've got a suppression hearing scheduled the next week.
Okay. But it sounds like your testimony, if I'm characterizing correctly, that your discussions with Mr. Morey were ongoing regarding plea issues, and that includes the request for deviation, and that wasn't just something that came up at the last minute.
Yes, it did not come up at the last minute. It was something that he had a copy of the statute. I made him a copy of the statute. If I don't want to. I'm pretty sure, because I do it with all of my clients, is or most of my clients, is I not only print them the statute, but I print them the case notes so that they can. Gives them something to do. There's not a whole lot to do at the jail, and oftentimes they'll point out something that I haven't seen a certain way, so they're assisting with their defense.
Okay. And the last thing I want to ask you, and I know you touched on this earlier, but you mentioned these records that you had a printout of, I think, regarding parole and how these how trafficking is the parole, I guess I want to say numbers, data regarding parole on trafficking. You had a printout of it?
It's incredibly difficult to find, and I'm not quite sure why that is, but it's on the Georgia Department of Corrections website. It's called the Length of Stay Report, and if you, I could show you how to navigate it. You may get lucky your first time on there, but it's a lengthy document. They update it every month, and it tells you by year going back as far as the statute has been around, every criminal statute, so that if you've got a client pleading to a controlling case of possession of marijuana or aggravated assault, what
and
the...
You would have given it to Mr. Morey?
Yes.
Did you give him a copy of it as well?
I'm not sure if I did or not. I keep it on my MacBook, and I keep it on my phone, and I always have it updated.
And just when you gave it to him, or when you went over it with him, to talk to him about it, what was the conclusion, or what was the, hey, Mr. Morey, I'm giving you this printout. It shows that based on this, you're going to do X amount of years, or you're likely to, or this is how much most people do for this kind of charge?
That's what I say, is that that a client needs to understand that if they're sentenced to 20 years, they as I told you, I'll tell the court that I tell the client that if it's 20 years, they need to multiply 20 by 365 and then add 4 for the leap years. No, actually, they'd add 5 days for the leap years, and that's how they need to determine how long they're going to do, and have it in their mind that if they want to plea, that they need to be willing to accept the maximum time in prison. That I can't promise them that they're going to get out early, regardless of what the length of stay report says, or the grid and the severity, and whether or not they had a job when they went into it, or whether or not they had a previous drug conviction. How the grid does, the length of stay is much more accurate, but we don't know which of those people are being released. We just know how many got convicted in 1985, and how many people, and what the average sentence length was, and then how many people were released each year subsequent to that, and the average sentence served.
Was the purpose of it to show, based on the charge Mr. Maury was facing, what similarly situated people were serving?
To the best of my ability, I don't have any. I don't know that they're similarly situated. I just simply can tell him or tell a client that these people, this is how many people in the state of Georgia were sentenced under this statute. This was their average sentence, and this was the average length that they served, or that not they served necessarily, but people being paroled served by year. So you can't match up the person. You can just look at the aggregate data.
And was it differentiated between tiers of trafficking, being that there are 3 tiers of trafficking?
If I recall, it is, yes.
I'm sorry, what was your answer?
I believe it is, yes.
Okay.
Because it wouldn't make any. It would be like putting aggravated assault and assault together. So I'm confident that it is tiered out.
So going over with Mr. Maury, you went over similarly situated 3rd tier trafficking and how long they had, or similarly situated people on the 3rd tiers had served.
If I recall, it was about 22 years, but it's been a while since I've looked at that.
Okay. Is that the sentence imposed or parole?
No, that was the parole time.
22 years.
Don't hold me to that, but that's what I recall. But that doesn't take into consideration, because I don't know whether or not any of those people had 6 other felonies with it. I just know that's the controlling charge that they went in with.
Okay. All right.
It'd be nice if the DOC gave us more data, but they don't.
Okay. All right. That's all I have.
Okay. Thank you, Mr. Zell.
Thank you, Mr. Atkinson.
All right, Mr. Crowder, anything?
Just a couple things quickly. Mr. Atkinson, just covering what you were just discussing with Mr. Zell about the 22-year issue. It's my understanding that this is from some DOC data that you pulled for similarly situated people, and that you showed this data to Mr. Maury just to give him an idea about what happened in other similar cases.
They're similar only to the point to that it's how many people were convicted of a certain crime, under a certain statute, and what the average sentence length was, and then by year. Not only does it say that, but it also lists how many people were released who were sentenced under those statutes.
All right, and when you discussed this data with him, did you explain to him that this is just a benchmark, and as I believe you said earlier, that you couldn't give him any guarantee that he would actually get out early?
Yes, very fair.
All right. In terms of the deviation statute, if you recall, one of the 5 prongs is that the defendant have no prior felony conviction.
Yes.
Did you?
I'm not ignoring you, Mr. Crowder. I'm actually just looking at I'm trying to look up something here.
When you discussed the possibility of arguing for deviation with Mr. Maury, did you explain to him that that was one of the things that you would have to show?
Yes, definitely. We had the statute. He had a printed copy of the statute, which includes the way it will deviate. And actually, the year he was sentenced, or the prior year, there had been 1 person released, and the average sentence was 31.57 years, and the average years served were 10.87.
All right. And in terms of the prong in the deviation statute about having to show no prior felony conviction, did you also explain to Mr. Maury that to show that prong, you might have to introduce his criminal history to establish that he had no prior felonies?
I believe so. I mean, it makes sense. I don't know how else would have done it, other than having it stipulated by the state.
Do you recall if the state did stipulate on that prong?
I don't, and I don't have the transcript. I didn't order this transcript after the plea. I don't make it a habit to order every single transcript for every plea. In in retrospect, or in the future when there's a habeas action, I think I'll go ahead and order the transcript up.
Lastly, after the guilty plea was entered for the second time and then sentence was actually imposed, and everything was wrapped up, did Mr. Maury give any indication to you that he wanted to try to withdraw the plea again or to appeal it?
No, he did not.
That's all, Your Honor.
All right, gentlemen, can we excuse the witness?
Yes.
Actually, I would prefer him to stay until we're done with evidence, Your Honor.
I'll stick around, Judge. It was easy. I've been here all day. I don't mind whatsoever if I could, sir.
That's fine. That's fine. We'll let you stay. Mr. Zell, how much more do you have to present?
Mr. Maury has to testify, and that's it.
Okay. Well,
I don't expect that to be as lengthy, but I don't know.
I would hope not, but we've been going an hour and a half. We'll take 10 minutes and then we'll come back and resume the hearing.
Thank you.
Thanks. Okay. Sure didn't expect this to go that long. All right, Mr. Zell, please call your next witness.
Mr. Crowder's not back yet, Your Honor.
Okay, all right.
There he is. Okay. Mr. Morey, John Morey. Can you hear me? Can you speak? Can you have somebody turn on your microphone?
It's on.
Oh, okay. I'm sorry. All right. Could you raise your right hand?
I'll swear it.
Okay.
Do you swear or affirm the evidence and testimony you give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
All right.
Would you state your name?
John Morey.
And Mr. Morey, you have pled guilty to a trafficking charge?
Yes, sir.
Okay. And Mr. Atkinson, was he your attorney?
Yes, sir.
Was he appointed or retained?
Yes, sir.
Which one? Was he appointed or retained?
Appointed.
Okay, all right. And just going into it, do you recall talking with Mr. Atkinson about any possible defenses you may have had?
Yes, sir. And as he stated, we didn't have no defense.
Okay. Did he talk to you about the motion to suppress?
Somewhat, yes.
And do you recall what told you about the motion to suppress and how that related to your case?
He's just going to try to get the stop, thrown out to where everything else underneath it would be thrown out.
Okay. And did you understand what that meant?
Somewhat, yes, sir.
Do you recall going to the hearing in which the officer testified about the reasons why he stopped you and pulled you over?
Yes, sir.
Okay. And before that hearing, had Mr. Atkinson talked to you about how the hearing would work?
Somewhat, yes, sir.
Did you know what would happen if you won the motion to suppress hearing?
No, sir.
You didn't know?
No, sir.
Did you know what would happen if you lost?
No, sir.
In your own words, what did you think the purpose of the motion to suppress hearing was?
Only what Mr. Atkinson had stated that, if we got the stop suppressed, then, everything else that happened after that, was null and void, and I'd be released.
Okay. So if you won, does that kind of answer your question yourself? What would happen if you won the motion to suppress?
Yes, sir.
And what would that be?
That I would, everything else that happened after the stop would be thrown out and I would be released.
Okay. Now, at some point, you recall you did not win the motion to suppress, is that right?
Correct.
Now, at some point, did Mr. Atkinson talk to you about going to trial or pleading guilty?
Yes, sir. It was more so pleading guilty than going to trial because, he constantly stated he didn't have anything to defend me on, so there was really no sense in going to trial.
Okay.
So it was more about the plea.
I know you're probably a little ways away from the microphone, so you maybe need to speak up a little bit to make sure we can all hear you. Is that okay?
Okay.
Okay. So going back to that, was it your understanding then that the motion to suppress was the only thing you had in your case that could help you?
Yes, sir.
Now, you said he talked to you mostly just about pleading guilty and not going to trial.
Correct.
Do you recall talking about what possible sentences possible sentence you would be facing was?
No, sir. He never gave me no, like you said, he gave me a printout of the statute. I never got a printout of the statute, but I did get a printout of the length of sentence.
Of the what?
Of the length of sentence.
Okay. Are you referring to the printout from the Department of Corrections that Mr. Atkinson testified to?
Yes, sir.
And do you recall what Mr. Atkinson told you about that printout?
Basically, it said, it went from 2008 to 2018, and it had how many people have been arrested, and how many got paroled, and you know, the average length of sentence was about 6 years until you got up to 2017 or 2018. You know, it's about 10 years, and you know, he was just, you know, to me, that said, you know, here's what you're going to do. Here's how many years you're going to do in prison.
Did Mr. Atkinson go over this sheet with you and specifically get into the number of years that he thought you would do?
Yes, sir.
Okay. Did he ever promise how much you would do, or did he just tell you what it looked like?
He didn't promise anything. He just told me what it looked like.
Okay. And again, that was based on that Department of Corrections printout?
Yes, sir.
And what was that he, what was his belief, or what did he tell you that he believed that you were looking at if you, how much time you would serve before being paroled?
You know, he didn't state anything, you know, factual basis, but he said it'd probably be somewhere between 6 and 10 years.
Okay. Now, did this have any factor in your decision to plead guilty or and waive your right to a trial?
No, sir.
It did not, and why is that?
I just figured, you know, if I'm going to go to trial, you know, let's go. If not, you know, let's plead guilty. And you know, I was pushed that way because, you know, they didn't want to go to trial, you know, because of the amount of money that they would spend. So, you know, I took the plea thinking, you know, that judge would be lenient. And of course, he gave me the max on every charge.
When you say they didn't want to go to trial, who are you referring to?
My plea counsel.
Okay. And I think you also testified that was based on money. What do you mean by that?
Just the amount of money it costs to, you know, send a trafficking case to trial.
Okay. Is this in line with how Mr. Atkinson testified that the court might go more lenient on you because of the expense of a trial? Is that what you're referring to?
Yes, sir.
Now, did you know whether or not there was much potential difference in your sentence if you pled guilty or went to trial?
No, sir.
Okay. Now, did you ever talk with Mr. Atkinson about, you know, going to trial perhaps, or having a jury trial or a bench trial and appealing any decision from the trial court? No, sir.
What vague remembrance I have of the suppress is he appealed it at the end of, you know, when the judge ruled on the suppression. He said, I'd like to appeal it, and my recollection, the judge denied the appeal. So, you know, after they said so much about the plea agreement, we were going to trial. We picked a panel of juries, and then they went back into chambers, and that's when he come out with the blind plea and said that the judge would be lenient. And of course, that's the way I went.
Okay. Did you base your decision to plea based on your belief that the judge would be lenient because you pled guilty?
Yes, sir.
What about this deviation? Did Mr. Atkinson talk to you about whether or not the court could, when I say deviate, give you a lower sentence than the mandatory minimum?
He did say that about the deviations. He said he would try it, and I don't know that my previous record was ever, brought up in the deviation because I didn't have any prior felony.
Okay. Was any of your decision to plead guilty based on Mr. Atkinson trying to get you a deviation from the sentencing?
No, sir.
It didn't play any part in it at all?
No, sir.
What were you hoping to get out of pleading guilty as opposed to going to trial? What did Mr. Atkinson discuss with you would be the optimal outcome by pleading guilty?
He didn't discuss an outcome. He just said that the judge would be more lenient on me if I entered this blind plea.
Now, at some point after you went to prison, did you learn anything about trafficking and parole?
Yes, sir, I learned, everything I know about it now and the statute and the length of sentence.
Did you learn that there was something that you believe that you were told incorrectly about trafficking?
It just, that I never was told the length of sentence on it, and I never was given, any kind of plea deal or anything to that nature.
I'm not referring to the plea deal. I'm talking about parole. You said Mr. Atkinson gave you this printout from the Department of Corrections and discussed parole with you, right?
Yes. Yes.
Okay. And did you learn anything about trafficking and the effect of a plea on what you were pleading to would have any effect on your parole status, whether you pled guilty or went to trial?
No, sir.
Okay. What about the length of traffic? Do you know what the sentencing range is for trafficking, for your level of trafficking is?
Yes, sir. It was a minimum of 25 and a maximum of 30.
Okay. Now, are you saying you did not know that when you pled guilty?
No, sir.
But you know it now?
Oh, most definitely.
Now, did you learn anything about parole, whether or not 25 years, 30 years has any effect on parole, what you're sentenced to for trafficking?
No, sir. Sure, I didn't.
I'm sorry, I didn't hear that. What?
No, sir, I didn't.
You did not learn, or you did not know any, or I didn't quite understand you.
I didn't know anything. I didn't know about the parole.
Okay. I'm talking about since you've been to prison. Have you learned anything about parole and trafficking since you've been to prison?
No, sir. I mean, you look my name up on the internet, and it's still got a maximum release date of 2052 in there. So I haven't, I mean, the GDC book reads it's parolable after 7 years. And then the grid says 65. 30 years, 10%. That's 10 years. So that's basically all I've learned.
Okay. Do you believe that you were not told something before you pled guilty that is now not true?
Yes, sir.
And what is that?
That the judge will be lenient on.
Did your attorney talk to you about going to trial and then appealing it? And I know you testified that you thought he already appealed it, but I'm talking about to a different court, appealing to a higher court. Do you recall any discussions about that?
No, sir.
Okay. What about anything about waiving a bench trial to avoid taking up a lot of court time? Do you recall talking about anything like that?
No, sir, because Mr. Atkinson and the other counsel constantly was saying you can't go to trial. We don't have no defense.
Did he tell you that? Did he ever, kind of go over with you? Hey, you got nothing to lose by going to trial. Your sentence is going to be about the same no matter what.
No, sir.
What about parole? Did he tell you that no matter what you do, your parole is going to be the same?
No, sir.
If you believe that your sentence would be about the same regardless of whether or not you pled guilty or went to trial, do you think you still would have pled guilty?
No, sir. I would have went to trial.
Why would you have pled guilty?
I wouldn't have given up my rights. I'd have took it to trial and just, if I'd known I was going to get the maximum on every charge, why not go to trial and try to beat it?
Okay. What about waiving your right to your appeal? Did you know that if you would have known that you could have kind of, preserved your right to appeal your motion to suppress, do you think you still would have pled guilty?
No, sir.
What would you have done instead?
I would have went to trial.
Okay. Did you, at any time tell me that you learned once before, that once you got to prison, that your parole is the same regardless of what your sentence would have been based on this charge?
Objection leading.
I'm asking if he remembers telling me that. I don't know if that's a leading. If he remembers telling me that or not. So yes or no?
I'll overrule the objection. Go ahead.
Yes, sir, I do remember telling you that.
And why did you tell me that?
Because, you know, I just thought my parole might have come sooner than later.
All right, that's all the questions I have.
Crowder?
Just a couple things. Mr. Moore, you testified that you did not know about trafficking being 25 years to 30 years. Is that correct?
Yes, sir.
Well, isn't it true that at the plea hearing, the trial court asked you about the sentences and you said 25 to 30 on trafficking, 1 to 4 on cell phones, and 12 months on the misdemeanor?
Possibly, yes, sir. I don't remember.
And isn't it true that the trial court asked, is there a mandatory minimum or parole restriction on this case? And you said in response, 25 years?
Possibly.
But now you're telling us you didn't know this at the time?
Possibly, yes, sir.
Now, did Mr. Atkinson explain to you when you went to the plea that it was not negotiated and that the trial court could impose anything up to the maximum on all the charges?
No, sir.
Okay, so he's just not telling what he said earlier was not correct. Is that what you're saying?
Yes, sir.
All right, that's all, Your Honor.
All right, thank you. Mr. Zell, do you have any other evidence?
Judge, the only thing I'm going to tender are just documents, and the reason I have documents is because I doubt the Attorney General I doubt Mr. Crowder has the motion suppressed because I ordered that. It was not prepared until fairly recently. But that would be the only document I would tender would be the motion suppress hearing.
Can you go ahead and produce it and see if counsel for the respondent has any objection?
Yes, I'm going to make a duplicate so I don't use this same one. Okay, can you, let's see. Share. See that, Mr. Crowder?
I can.
Okay, it's a 81-page transcript. There's the very last certification page.
Okay.
But I don't have a problem if you get a copy and you think if you think I changed it, you have a right to object to it if you believe so. I don't have any problem with that once you get a copy of it. But this is the original motion suppressed from the court reporter.
That's fine. We did not get a copy of that. No objection.
All right, it's submitted without objection. Any other documents from the petitioner?
No, Mr. Crowder, you're going to tender the other documents, the plea transcript, and all the other documents you typically tender?
Yes.
Okay, then that would be it for the petitioner. We'll rest and let the Attorney General tender their documents. Let me stop my share. Okay, there we go. Okay.
All right, Mr. Crowder, you have documents.
I do, and I want to briefly recall Mr. Atkinson for 2 questions.
Okay.
Here, Judge. Mr. Crowder.
Just a couple things. Your testimony regarding the hope of leniency for the guilty plea, did you tell Mr. Maury that the trial court would be more lenient if he pled guilty?
No, but I explained why I believed they should be and why it was my experience that the courts had been in the past and why they had an incentive to be so.
Okay, and did you explain to him that he could get, I'm sorry, go ahead and finish here.
And I could go through my reasonings for the would, should, and could if the court would like me to do that. But in a nutshell, the trying of cases, even if they're slam dunk cases according to the state, or the state truly does have a slam dunk case, it's still expensive to maintain a trial. And judges are very, very cognizant of the costs of calling in jurors and paying them their per diems. And Superior Court judges are elected, and if they get stuck here doing voir dire for 4 days with me, it doesn't make them happy. So the judge knows that the defense does have some ability to aggravate their reelection chances and ultimately slow the process down, and to give Mr. Maury or give a client a lot of time in court, more than just their day. And I would have explained that, and did explain that to John, to Mr. Maury, why I believed that the judge should give him a better deal than were we to go to trial, especially considering that we didn't have much of any defense if we were to go. But I never told him that he would get less. In fact, we totaled it up. I know we totaled it up because that's what I do with all of my clients, is they have to assume they're going to get the max, and they have to also assume that they're going to do every single day that they're sentenced to. I would never tell a client that, well, you're going to get 30, but you'll be out in 5. I hope they'll be out in 5, depending. But ultimately, if you're sentenced to 30 years, I believe it's only fair for the attorney to explain to the client that there's the real possibility that the Department of Corrections can keep them for that amount of time.
Okay, and did you also explain to him that with a non-negotiated plea, the trial court could sentence him up to the max on all the charges and run them consecutive if it wanted to?
I did, as well as did the court.
Okay, that's all.
Okay.
All right, thank you. All right, now, Mr. Crowder, you have documents that you'll introduce?
I do, Your Honor. I think it looks like I've got the share feature here.
And can Mr. Atkinson be excused if we're...
Yes, absolutely. Mr. Atkinson, thank you very
Judge,
much.
thank you, Judge. Mr. Zell, Mr. Crowder, y'all have a great day. Court staff, y'all have a nice week. Thank you so much.
Thank you, sir.
Mr. Maury, good luck to you.
And I'm pulling these up now. Respondents 1 is the indictment and the waiver of rights in the sentence.
No objection.
I'll just quickly scroll down through these. It's not very long.
I have the same. That's
And Exhibit 2 is the plea hearing transcript.
of course no objection.
All right.
And those are all the documentary exhibits I have.
All right, the documents are admitted without objection. Gentlemen, any objection in closing the hearing at this time?
The only thing I need to know, Judge, is how to get this. Do I upload my exhibit here, or do I email it later?
I'll have to defer to my staff attorney on that.
Okay.
Oh, we'll reach out with an email address
Okay.
where it should be sent to.
Gotcha. Thanks.
All right, that'll close the hearing on John Maury. Mr. Zell, do you have any other cases with us today?
I have 2, but I moved to continue the other 2. I thought 3 was enough for one day. I don't think you could take me anymore.
I won't comment on that, Mr. Zell, but thank you for offering. We'll simply close the hearing and wish you well. Enjoy the rest of the day.
Thank you, Your Honor.
All right.
So we have
Any other attorney cases?
We have no attorneys. The next one is pro se. We have a witness who's been since this morning.
Let's go to that case.
Let's go to that case, I would say.
Yeah.
Okay.
Which one would that be?
That one is item number 9. Mark Highsmith from Rogers. That's Miss Tiffany, can we have Mark Highsmith, please?
Yes, sir. He's right here.
And who?
I'll be Ms. Vernick from the AG's office.
Chris Bishop. Mr. Bishop, can we do a mic and video check with you?
Yes, can you hear me?
We can, sir.
Judge, we have Senator Highsmith right here, sir.
All right, I'll go ahead and get started in this matter. This is case number 2020 HC4. The style of the case is Mark Gary Highsmith, who is the petitioner, versus Linton DeLoach, the warden. I believe Mr. Bernick is here representing the respondent. Mr. Highsmith, you represent yourself, is that correct?
Yes, sir.
All right, are you ready to proceed this afternoon?
I think so.
All right, sir, I'm going to have to take that as a yes. We also have a witness here. This looks like a petition regarding a guilty plea conviction out of Cherokee County in 2018. And Mr. Chris Bishop is here. I assume he was plea counsel.
That's correct.
Yes, sir.
All right, Mr. Highsmith, what we would normally do is have plea counsel give testimony, and then you would have a right to ask him any questions that are relevant to your petition. Do you have any objection to that?
No, sir.
All right, then, Mr. Bernick, you may proceed with the testimony from Mr. Bishop.
You want me to just go ahead straight to testimony, Your Honor?
Yes. Mr. Bishop, raise your right hand, please. Do you swear or affirm the testimony you give to the court will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Good afternoon, Mr. Bishop. Could you please state your name and current business address for the record?
Christopher Lee Bishop. I'm a criminal defense attorney in Cherokee County, Georgia.
And what year were you admitted to the Georgia Bar?
I was admitted 2005.
And since becoming a member of the bar, how have you been employed?
Always been a criminal defense attorney. Worked for my father most of the time. I did some assistant prosecution for night court in the city of Holly Springs. Also take indigent cases out of Cherokee County because we were one of the counties that opted out of the public defender system. And I'm also the public defender for the municipal court of City of Canton.
Okay. And about how many trials have you handled, would you estimate?
Oh, 5 to 6 a year for the last 16 years.
Okay. And about how many felony jury trials?
Felony jury trials, probably about 10, I'd approximate, give or take.
And when you represented, and about how many guilty pleas have you handled?
Numerous guilty pleas. There's, I mean, I probably keep a 75 to 100 count caseload a year.
And do you recall representing Mr. Highsmith back in 2018?
I do. I came to represent Mr. Highsmith. I was appointed to his case in March, I believe, the end of March 2018. I was the second attorney appointed to his case.
Okay. And do you recall what point in the proceedings? You said you were a second attorney. Do you recall about when that was in the proceedings?
It was obviously before arraignment or indictment, because we actually did the plea on an accusation that was filed the day of the plea. I want to say that the original attorney, Jeff Heller, was appointed in late summer, early fall of 2017. I don't remember exactly when, but he represented all the way up until the end of March and then withdrew. But as I recall, the motion didn't specify as to why the withdrawal was done. I think Mr. Highsmith just requested a different appointed attorney.
Okay. Do you recall the nature of the charges against Mr. Highsmith?
Yes, they were smash and grab burglary charges, second-degree burglary charges for entering into retail establishments and businesses after hours. And although we did not plead to them, and they were not brought forward by the DA's office as part of our plea negotiations, there were some misdemeanors and other felony obstruction, fleeing and attempting to elude charges.
Okay. And do you recall how did you prepare and investigate this case?
So I was appointed the case in March, filed my entry of appearance and discovery like I always do. Usually I'm out there within the 3 days, the 72 hours out to talk to the client at the jail. I believe I did that. In this case, I think I knew that there was a second attorney. I think I actually had a conversation with Mr. Highsmith saying, I don't care why the attorney was out. I don't need to know what that issue was, that I would take the case and move forward. Original thing that I always do in every case in which I don't believe the individual can make bond is I turn around and file a motion for probable cause hearing and get that set down in front of our magistrate judge. It gives me an opportunity to try to get some early discovery, more of a fishing expedition to kind of see what they have, because we're not entitled to discovery yet at the time. I made contact with the DA's office in filing those motions. Here in Cherokee County, we have somewhat of a practice where the DAs will reach back out to you once you filed that probable cause motion and suggest that if they provide you with pre-indictment discovery, would you be willing to remove that motion for probable cause so that they would not have to have a lengthy hearing with an officer or investigator. The practice here is generally, and what I generally do is I agree to that unless there's some emergency circumstance, and take the DA at their word that they will provide the pre-indictment discovery so that I can get a better idea of everything that's going on in the case. I can get all the reports, get pictures, try to get videos, if at all possible, that I would not be able to have for that hearing. Basically, going into a hearing blind is very difficult. You can ask a bunch of questions as to how a case normally kind of goes as to your best experience, but I'd rather have the written discovery if at all possible, so that's what we did in this case. They provided it to me, I think, in one big packet and then a couple of supplemental packets, for which I was able to kind of go over and piecemeal, and then kind of walk through with Mr. Highsmith as I was able to get it in. But in regards to the investigation in the case, basically going out to the scene, looking at the scene, matching up some of the pictures that we're taking, looking at the back of the area of where the video camera surveillance was, it indicated that they had, where they had taken a picture of the suspect truck and the suspect individual. Talked with a couple of the witnesses on the phone, including family members from Mr. Highsmith, to try to get a better understanding of where the case was shaping up.
Okay. And you said there were video surveillance. Did you review those videos?
Yeah, so most of the stores actually just had cameras that were not functioning. So I say video surveillance. There was one camera from an outside that was able to get a picture. It was not a very clear picture. You could tell that it was a white Chevy older model, smaller model truck. The individual appeared to be a male in his 30s to 40s, bald white male. I think there was some debate as to whether or not the person indicated he walked with a limp. Through some of the surveillance, I don't think you could really tell that. But there was not really any good inside the store video surveillance.
Okay. And you said you met with Mr. Highsmith initially whenever you filed your entry appearance, and then you met with him as you got discovered. Do you know about how much extensive contact you had? Could you estimate how many times you met with him?
We probably met at the jail 4 to 5 times. A couple times, one of the more lengthy ones was when I was out there, showed him a couple of the pictures, went over some of the more of the documents. We talked on the phone a couple of times. Other times he wrote letters for which I looked into information that he wanted me to look into regarding possible sentencing issues, for which I went over that with him later at times too. I did not keep an actual account of how many times I went out there, but I would say 4 to 5 lengthy conversations at the jail, including one at the courthouse itself before we went in front of the judge.
Okay. And during your investigation, were you able to formulate any viable defenses or theories of the case?
My opinion, essentially the only trial or defense of the case would have been identity. Basically, to go forward at trial would have been to establish that the state couldn't meet its burden as to that Mr. Highsmith was the actual perpetrator of the event. Again, no video surveillance from really inside because of the time of night. There was really no witness identification as to who actually did it. The best they had really was that one video surveillance of catching the white older model S10, I think it was Chevy pickup, and again the older white male individual, bald, 30s to 40s, and they started their investigation from there. So really the defense would have been it wasn't us, it was somebody else.
Okay. Did you discuss the weight of the evidence against Mr. Highsmith with him?
Yeah, I think we talked in length about that. The couple of the issues that were going to compound the issues and make our case harder would have been any similars that they could have filed to try to bring in 404 evidence of, lack of mistake, maybe possibly bent of mind, depending on how they try to get it in. We didn't get to that point as far as the state actually filing those motions, but Mr. Highsmith did have a record of previous burglaries, including a burglary out of Cherokee County. So I know that they would have been seeking to introduce that evidence at trial had we gone forward to trial. The other thing that complicated matters was they did a witness tip. Woodstock investigators, if I recall correctly, put a picture of the suspect individual in his truck out to the media and went out to the public, and a gentleman from Mr. Highsmith's neighborhood contacted Woodstock, said, "Hey, I think I know this guy. I think I may know the person that you're looking for." I don't recall that gentleman's name off the top of my head, but investigators went out and talked to him, and he said, "Well, I'm not really positive if it's him or not. Looks like the car or the truck that he drives. You might want to at least follow up on it." That's what investigators from Woodstock began to do as far as doing surveillance of the house that the witness said that the individual lived at. Basically, after that, Woodstock was able to determine that they did locate and did surveil what they believed to be the truck. They took some pictures of the truck, compared them to what they thought were pictures of the truck from, again, the the very fuzzy picture that they had from the camera, believed it was enough to move forward with an investigation. Did a research on the tag that came back on the truck, came back to Mr. Highsmith's dad. In that regard, they followed up with trying to, and actually did, Mr. Highsmith, Mr. Mark Highsmith wasn't there. Mr. Gary Highsmith, I believe was his dad's name, was there. They did an interview with him, said that they had warrants or search warrants that they wanted to try to search the truck based on the investigation that they had done at that time. Showed Mr. Highsmith Sr. or Gary, the father, a picture of the truck, and the Gary, the father, actually identified the truck in the photo that they showed him, which was again this photo that was taken from the video surveillance cameras as being his truck. Pointed out, according to the investigator, pointed out 2 or 3 things that yes, that was his truck, and that he had lent that truck to his son.
Okay. And you said, and do you recall any plea offers made?
Yeah, so originally when I first got in the case, Mr. Highsmith, I think indicated right out of the gate when I first met with him that he was not interested in any deals. Was looking at trying the case essentially under the identity issues. They weren't going to be able to prove that it was him. I told him that was fine. I would not try to talk him into any plea offers, but I did indicate to him, as I do everybody, that if I'm made a plea offer, I'm ethically obligated to relay that plea offer to the individual. Mr. Fickett was the ADA on the case. He did make a couple of multiple offers that we communicated to Mr. Highsmith. I don't know that he really paid attention to a couple of them because I think they were, if I recall, Mr. Fickett in the ADA's office was every offer that was made previous to the one that we actually took was going to include recidivist or going under the recidivist statute.
Okay. And so do you recall specifically how the final plea offer, the one that was accepted, came about?
Yeah, so we got into discussions about, so while he was in custody in Cherokee County, Holds came down from Gwinnett County, for which he was facing possible prison sentence and time out of Gwinnett. Per my meetings with the assistant district attorney in Cherokee County, I'd indicated to him that I understood that warrants and holds of some kind were now coming out of Gwinnett, but I didn't represent him out of Gwinnett, but that any kind of offers that we would be seeking to even consider would be non-recidivist offers and any kind of possibility or hope that the ADA in Gwinnett was going to run something concurrent instead of consecutive with Cherokee County. We also were facing a small probation revocation out of Cherokee County. I don't think there was much left on it, 2 or 3 years. On his original burglary from 2011 or 12, somewhere around there. They may have been a little bit later than that. We finally got to the point where the ADA in Cherokee made an offer and said this was the offer prior to going forward to a grand jury, that if he was going to go forward to grand jury, he was going to go forward with getting all the basically all the paperwork necessary to indict it under the recidivist charges and move forward in that regard. Then any of those offers at that point would be essentially off the table, and we'd be in a situation of either pleading non-negotiated or going to trial. After discussion, all the obstruction charges and the felony fleeing, attempting to elude, and all those things were agreed essentially by myself and the ADA that he would not pursue those. He was drawing it up for some smash and grab charges and burglary in the seconds, for which he finally made the offer of essentially 30 to do 20 and go forward in front of the judge on a negotiated plea. At the very last minute, he I think was trying to include a couple of additional counts that we had problems with. So on the original accusation that was presented to me on the day of court that was not yet filed, I talked to Mr. Highsmith about that. We debated that. We debated a couple of those counts. I went back to the ADA essentially that day in court. The ADA removed those counts, prepared a new accusation, and filed the only accusation that was ever filed in the case. This is the one that we pled to with the 9 counts.
Okay. And before pleading, did you review that accusation?
Yes.
And do you find it sufficient as to the counts as alleged?
Yes.
Okay. Okay. And then and with the plea, did the court follow the state's recommendation?
It did.
Okay. And prior to the plea hearing, did you inform and explain to the petitioner all of his constitutional rights that he'd be waiving by entering a guilty plea?
Yeah. In Cherokee, we have numerous forms. The petition to enter plea of guilty form it's been since changed since we did this plea, but has over 40 questions on it, including all the constitutional rights to counsel, right to trial, right to produce witnesses, right to confront, right to call, obviously to testify, right to subpoena powers, goes through all of it. I checked and went over all those boxes with Mr. Highsmith on his signature, and he signed the back of that, or the second page of that petition, indicating that he understands all his rights.
Okay. And this is from what we tend to enter as Response Exhibit 1, which is the clerk's record. But I'm going to show you a copy of what I think you just...
Yeah, that's the petition to enter plea of guilty, yep.
Okay. And you said you explained that to him?
Yes.
And did he understand the rights as on this form as you explained to him?
Yes, Mr. Highsmith is very intelligent. He asked very good questions throughout the entire course of the case and representation. Was very knowledgeable, and I believe that he understood everything that he was doing.
And he agreed to waive those rights?
He did.
And do you have any questions about? Did he have the opportunity to ask you any questions about his rights that he was waiving? Excuse me.
Oh yes.
Okay. And did he have any questions about those?
No, he did not.
Okay. And then prior to the plea hearing, did he have an opportunity to ask you any questions about the case before he entered his guilty plea?
Yes, we went over multiple things. Again, like I said, I mean, the first thing that we went over was the case being basically an identity case. I know that at one point in time, we talked about, or he asked me about introducing possible character evidence. I explained to him because of his history, character would not be a situation in this case. And in fact, because we didn't have any alibi evidence that I was made aware of, that we would be in a situation of most likely, if we got to the point of trial, remaining silent and him not taking the stand based upon his prior history and the lack of essentially character and relying upon him to remain silent during the trial and basically making the state prove their case.
Mm-hmm. And then at the guilty plea hearing, was Mr. Highsmith advised of all of his constitutional rights, including the right to jury trial, right to confront witnesses, and the right not to self-incriminate?
Yes.
Okay. And at the time of the plea hearing, were you satisfied that Mr. Highsmith entered his plea knowingly and voluntarily?
Yes.
And were you satisfied that he knew and understood what he was doing?
Yes.
And were you satisfied that he knew and understand the consequences of what he was doing by entering the guilty plea?
Yes, I believe he did.
And then following the guilty plea, did he ever inform you that he wanted to withdraw his guilty plea?
No.
That's all the questions I have. Thank you.
All right, Mr. Highsmith, at this point, you do have a right to ask questions of counsel that are petitions, so you may proceed.
Counsel being Mr. Bishop you're talking about, sir?
Yes, sir.
Okay, hello, Mr. Bishop. Good to see you again, sir.
Good afternoon. Good to see you. Hope you're doing well.
Thank you, sir. Under circumstances, fine. Our original deal that we had with the DA was a 30, serve 12, sir, if you remember that. Well, you just said you didn't remember that, but I'm reminding you, does that refresh your memory? Does that sound correct?
That may be correct. I mean, if you say that was the original offer under recidivist, then that may have been the original offer.
No, sir, it wasn't under recidivist. It was a 30, serve 12. And 20 minutes before we went into the courtroom, you called me into a side room at the courthouse, and that's when you advised me or informed me that he had raised 4 of the second-degree burglaries to smash and grab burglaries, and he wanted a 30 serve 20.
No, I never would have done that. There is a side room where is the holding room where you're brought over, but that is not what I remember. No.
You don't remember telling me that we had a deal for a 30 serve 12?
In looking at my notes regarding the plea recommendation, the last plea recommendation that I have from the DA in my file is a 20 years to serve, with the 10 years being on probation. So it's the 30 to 20.
Well, you called me into that side room that day and told me that he had a new deal for me, and he'd raised those charges to the 30, serve 20. Why would he say, I don't understand why you would say that, sir.
Again, I don't understand the question. I've answered that that's not correct.
Okay. So the number 12 never comes into play into your records?
No, I don't disagree with you that there probably was a 12-year offer at some point. But as I testified to earlier, there was a couple of offers that I know that were made that would have included going forward and going under the recidivist charge.
Okay. Well, we had already took the recidivist off the table.
Well, I will disagree with you on that, sir. There was no recidivist. There was nothing off the table at that point because you hadn't even it hadn't been indicted yet. Case hadn't even been presented to grand jury. So there was actually no official charges other than the warrants and the charges that were under the warrants at the time.
Okay. Thank you. Just to clarify about the first lawyer, he excused himself.
Okay.
Yes, sir. Just to clarify that. In that side room, the day that you told me about the renegotiated deal that the DA offered, you did not inform me of banishment from Cherokee County. I did not hear that until we got into the courtroom, or else I might not have. That's one of the reasons I might not have accepted that deal. Do you remember not telling me that, sir?
I don't recall. I know that every time that the discussions that I'd had with the DA had involved banishment. I believe we discussed that at the jail before, because I believe you said that your dad resided in Cherokee County, and that you might want to be able to visit your dad. My recollection of those discussions were that if you were later on probation after abandonment, that if you did well in prison, made parole early, really that kind of the only reason that they wanted the additional probation on the back end was for the restitution. That if that would be satisfied and that you'd done well as far as parole, that a motion could be filed at that point to modify the probation, so to basically allow you to come in and visit your dad in Cherokee County. That's my recollection of some of the discussions we had at the jail.
Wow. I'm sorry, I don't remember that discussion about basically any of that, sir. I'm sorry if it may have slipped my mind. They say they identified my truck and me as being the assailant. How, in any footage you have, can you tell how the assailant was dressed?
Again, I told you, I testified, and we talked about it. The case would be identity. It comes down to, it was a white, older model. They say it's S10, looked like an S10 Chevy pickup with a older white male, again 30s to 40s, over 200 pounds or over. We talked about the picture. It was not a good picture. It would come down to identity. We talked about the problem. The identity problem was that your dad lent you the truck that you were driving, maxed up the truck and said, "That's my truck. Now I lent it to my son."
Yeah. Yeah, I know it's identity. It's just that in the footage you showed me, the assailant looked like they had a mask on. So I'm just wondering how they got to the assumption that the assailant was a bald white man. I'm just wondering how they got to that assumption, sir. That's not a question.
Again, that's the picture they put out. I didn't start the investigation. I'm not the one that worked for the Woodstock PD's office. I didn't have any of that information, and I don't know how to start an investigation. They're the ones that put out the picture to the media. That's when they received the tip. That's when they talked to the first witness, which led them to your I guess your dad's address, if I'm remembering right, for which they discovered the truck and led their investigation down that path.
So basically you're saying that, and I think you just said in the previous questioning from the gentleman that just questioned you, that you basically took the DA's word from their transcripts and whatever they told you as to that was the extent of your investigation, sir?
No, I talked to your mom and I talked to your dad, and he said that that's what he told him. He told me that he told the detective that was his truck and that he had lent it to you. He didn't say that was you in the picture. But he just said that, you're only a small petty criminal and don't go after him. I think don't go after him crazy or something. I don't remember exactly what he said. I think he was trying to get them to calm down. I think they were probably upset when they were looking for you.
Yeah. Okay. Thank you. So you're saying that you questioned my family, but you did not question any of the victims of these alleged burglaries?
Well, there's no reason to question the alleged victims of the burglaries because they're not witnesses to the event. They would have been witnesses as to the restitution or the damage, which we chose to accept the restitution and the damage amounts. But they were not there at the time, nor was there any evidence as far as the cameras that needed to come in at that point, as far as the investigation for me at that point was concerned. If somebody had been in the location or had been a night watchman or had been working late, then yes, I agree that person would have been worth talking to, but none of them were present at the time.
Okay, thank you, sir. I'm reading from an officer's report right here. It's saying that a detective, Hughes, conducted his initial investigation and he allowed the officer inside to review his security footage. On the security footage, he says, one suspect fully dressed and wearing gloves and a mask was seen breaking the front glass. Do I need to repeat that, or did everybody hear that?
Yeah, I think we were able to hear it, yeah.
Okay. Okay, I'm sorry, I didn't know because I had my head down, I didn't know if y'all could hear me or not. That's where my concerns about where did they originally come up with the bald white male thing?
Right, again, that was from that was from the picture from the outside of the building.
Okay. Okay. I'm just looking at my notes here. I have one more that I'm trying to find right now that might be of interest. Okay, I believe it's the taste, the doors are open. I believe it was the Taste of Italy. Mr. Sciano?
Yeah, the manager for Taste of Italy, yeah.
Yes, sir. He said there appeared to be nothing missing from his door and it didn't look like any damage other than the glass door.
Correct.
Yes, sir. So does it sound like that's really a burglary? That sounds more like criminal damage to property.
Well, I don't think you're reading the entire report there. The manager, as I recall, said that there appeared to be nothing missing other than the damage to the door and the cash register drawer being open. Therefore, there's some direct evidence of a damage and a cash drawer being open with circumstantial evidence that surrounding the entire case regarding the investigation that possibly could have been you, which would have allowed them, in my opinion, to get to a jury on the charge. Whether or not a jury convicts, completely up to a jury, but I believe that they had sufficient evidence to get there.
Okay, all right. Well, maybe I am only reading the one, reading that, and maybe I am reading the part where it says the drawer was open with only checks in it, so.
Correct.
I mean, I see that, but it's, I guess, kind of misleading to me because I'm not totally literate of the law. So thank you for that, sir. You had gave me a form with the severity levels of crimes on it. Do you remember giving me that?
Yep.
Can I hold it up to the camera so that it can refresh your memory and so everybody can see it?
Sure.
Is that visible?
Yeah, I mean, I can see it. It looks like the 2006 crime severity level forms indicating.
Yes, sir.
Yeah.
Yes, sir. You said my crime was a level 4 severity level, and under that, you gave me this, I think, prior to any deal we've taken, but in that room that day when we renegotiated a deal that you don't remember, we renegotiated from the 30-12 to the 30-20. I can't remember every word that you said. I can only guess and hope that I get close to what you said. I'm not trying to blame you for anything or make you look bad, sir, but you informed me that I would probably only do, I'm pretty sure, I think you said that I would probably only do approximately the same amount of time on this deal as I would do if I was to have taken the other deal. Do you remember telling me anything close to that or that?
Any comments that I ever make regarding the severity levels or as to paroles and guidelines, I mean, is obviously a guess. I would have started with that because that's the way I start every conversation when anybody ever asked me as to time regarding how much time somebody would do in regards to one count or another. It is hard for me to say. I'm not going to say that I didn't say that because if I gave you the grid form, which is what I do when people request, or the severity level sheet when they ask that I try to provide, I think it has a very wide range. I do not recall the amount of months on there, but based upon the amount of months and then the Pardons and Paroles Board would then do an evaluation of whether or not you're low risk, medium risk, or high risk. That affects where that monthly parole issue falls in. Also, any previous sentences that you might go in on. Obviously, somebody going in that might have a previous armed robbery would obviously grid out and is going to be higher on that risk factor than anybody else. I don't know how they would necessarily treat you, but if I said that, I was probably referring to amount of time that you might be considered for parole after and above whatever number they gave you. So my best guess to explain that, I guess, a little bit better in my answer would be whatever the max is on whatever monthly possible parole I would have said is that you would probably been facing that same maximum monthly parole board review as the best answer I can give you.
Okay, thank you. And if I may remind all parties, I'm not a lawyer and I'm not totally literate.
Mr. Highsmith, I understand that. I hear from pro se litigants all the time. If you'll just ask your questions, it'll go a lot better.
Yes, sir. Thank you, sir.
Sir.
The Attorney General sent me a letter saying that they had no proof that I had filed for any previous relief or any previous motions. I do have a copy of some of those letters where they sent back a history of the motions that I sent. Would you like to see them, sir?
All right, sir, is this a question you have for your guilty plea counsel?
You're right, it is not. No, sir, it is not.
All right, I need you to finish your questions of Mr. Bishop, and then we'll go on to any other matters you want to bring up to the court.
Yes, sir. Okay, Mr. Bishop, the original 30-12 offer we had, why was that taken off of the table? 20 minutes before I went into the courtroom. We discussed this at the court, at the jail, and that's why I came to court, I think, the day or two later.
I would agree that I was probably out at the jail and met with you regarding going forward and going to court, talking about the plea paperwork. But again, I know we set it down for a plea. I know that I have in my notes the plea recommendation as to what I have in my notes and what we presented to the court, which was what it was accepted and negotiated. So I can't answer your question.
No further questions. Thank you, sir.
All right, Mr. Burdick, do you have any further questions of Mr. Bishop?
Just one final question, just to follow up on the parole. I just want to make sure for the record, when you review parole with your clients, do you make any guarantees as to when they'll parole out, or you reviewed?
No, we never make any guarantees. It's always stated, and I always start with, this is the grid sheet, this is the severity levels, this is all, I'm not in control of pardons and paroles. I can't say what they're gonna do. They can release you early, they could go make you do the entire time. And in fact, I think our petition to enter plea of guilty specifically goes over that anything that we talk about regarding pardons and paroles is not a factor in the plea of the case.
Okay, thank you. Nothing further.
All right, well, Mr. Bishop, first of all, I appreciate your patience. Looking at your office, I'll have to comment that you and I share a connection to our state university, so go Dogs and have a great afternoon.
Go Dogs, thank you. Have a good rest of the day. Good luck to you, Mr. Highsmith.
Thank you, sir.
All right, Mr. Highsmith, at this point, I'm going to ask you to raise your right hand. You swear or affirm the evidence, the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
All right, at this point, you're allowed to testify, introduce evidence. You may proceed, sir.
Thank you, sir. I guess I'll start by what I just tried to introduce. I'm sorry about that. I got a little confused. I've got a letter from, I believe it was the Attorney General, saying that they had no proof that I had filed for any previous relief or any previous sentence modification or anything like that. I have a letter that might clarify that. As the letter has like a history of everything that I had filed throughout my proceedings, or I guess you'd call it, or throughout the time I've been incarcerated.
Mr. Burdick, do you know what he might be referring to?
I don't exactly, but it might be Mr. Highsmith filed a motion for sentence modification in the Cherokee Superior Court. The court denied that. He did two appeals on it, and they were both dismissed. I think he didn't file a brief in that. One of them timely, and the other one was dismissed for being duplicative of that first one.
Would you agree none of that would be relevant to this habeas petition? Would it?
I don't think it is. And for the record, we do have the record from Cherokee County. I did look at it, and they did have the motion, the order denying, and actually the orders from the Court of Appeals in that record also. So,
and are those records a part of the exhibits that you intended?
It would be part of the exhibits that we intend to enter. It's just, and they're certified from the Cherokee County, and that's just to look at. That's from the Court of Appeals for one of the appeals.
Mr. Highsmith, so you'll understand, Mr. Burnick is going to introduce certified copies of proceedings that took place in Cherokee County regarding your entry of a guilty plea, the transcript of the guilty plea, probably some other records that are contained in that in those filings. So you're going to see copies of those, and they'll be a part of the record in this case.
Yes, sir. Thank you.
All right, so is there anything else you want to testify about, or any other evidence you wish to introduce at this time?
Yes, sir. right. This is from it says Georgia Department of Law on the return envelope. Superior Court, Tattnall County, I'm guessing at the top. So I'm guessing this is from the Tattnall County Court. It's the grounds. It's a return answer.
Okay, that's a response to your petition. That's a part of the record.
Right, sir. Yes, sir.
I have your petition, and your petition sets forth that you believe that counsel was ineffective. You believe that your plea was not knowingly and voluntarily made, and that
yes, sir.
And all of that's part of the record. I have that. And then they've denied that in their return and answer. So that's just a part of the record. They're denying your petition. That's why we're having a hearing.
Okay. Should I argue any of these points, or is there any way that I can?
Sir, your argument is a part of the record. You filed a petition, and you've set forth all of that in the petition, and you've made reference to it in your questions of plea counsel. I'm giving you a chance at this point to introduce evidence, testimony, so you don't have to introduce exhibits or pleadings that are already in the record.
Yes, sir. How did the state, I don't understand how the state proved the smash and grab burglary. It's because the original charges were second-degree burglary, and as my lawyer reported or just informed y'all, that 4 of the charges were up to smash and grab burglaries. I don't understand why, sir. And it says they couldn't prove it.
Mr. Highsmith, I can't answer your questions. You either have to testify or produce evidence. Then I'll make a decision as to whether your grounds are valid.
Yes, sir. I'm not professional at this. Okay.
I mean, if you don't have any evidence and if you don't have any testimony to offer, I will consider what's been presented by way of your petition and the testimony that's been offered by Mr. Bishop.
Yes, sir. I have the police report here where I was charged with, the original charges were all second-degree burglaries, and that's all I have, I guess. And when I went to downward to court, I have the paperwork here where they upped 4 of them to smash and grab burglaries for no apparent reason. That's all I have, I guess.
All right, Mr. Burnick, do you have any questions of Mr. Highsmith at this point?
No, Your Honor.
No clarification regarding grounds or anything of that nature?
No, I think, I think they're pretty straightforward.
All right, sir, then do you have exhibits to offer at this point?
Me, sir?
Yes, Your Honor.
Oh.
I'm asking Mr. Burnick.
Sir.
We have.
Go ahead.
Response 1 and 2. Response 1 is a certified copy of the clerk's record from Cherokee County. Appeals down here.
I see it. If you could briefly explain for the petitioner what that
Yeah.
encompasses.
That encompasses, there's actually two main parts of it. There's the indictment, plea, and sentence from the court, and actually copies of the warrants. And then the other part is also the copy of the record sent to the Court of Appeals when he appealed his motion for his denial of motion to modify his sentence.
All right.
And
are those all the exhibits?
And then we have R2, Respondent 2, which is a copy of the guilty plea transcript.
All right, and that was the transcript of the proceeding before Judge Harris, is that correct?
Yes, Judge Harris. Mm-hmm.
All right.
And we'll remove all the sticky notes before we enter them.
All right. Any other exhibits?
That's it, Your Honor.
All right, and Mr. Highsmith, do you understand what he's offering? These are certified records from your case when they occurred before Judge Harris in Cherokee County.
Yes, sir.
And you're going to receive a copy of these as exhibits as a part of the transcript of this hearing. So what we'll do is the court reporter will provide, she'll transcribe everything that took place today, everything that's been said, all of the testimony that's been offered, and copies of all the exhibits. You'll receive a copy of that probably a few months from now, and then the court will review the record and render a decision. Do you understand?
I do, sir.
All right, then the court's going to close the hearing at this point.
Okay, before you do that, may I make one more statement, sir?
Yes, sir, go ahead.
It's regarding the testimony I made to my lawyer, or the question I asked my lawyer, about our original deal, and he's saying he doesn't have notes of that. The only evidence I have of that is my verbal evidence, sir. And is that admissible?
Yes, sir.
Okay, where I verbally said that our original deal was a 30-12 and 20 minutes before we went in the courtroom. He offered me a 30-20 and explained that I would do the same amount as he showed me on that grid sheet that I held up in front of the camera. That's the only evidence I guess I could physically submit.
All right, so that's testimony. That's fine.
Thank you, sir.
All right, so that is a part of the record. The court will consider that.
Thank you.
All right, the hearing is closed. Have a good day, sir.
Yes, sir. Thank y'all for your time.
Thank you.
How many more do we have?
We have 1, 2, 3 that
Are they all at one prison, or are they?
No, they're one's a Smith, one is a GSP, and one the other Rogers. Item 15, there was a witness. The witness left long ago. Arthur Lee Fudger. So
I don't. Judge Fudger.
Arthur Lee. I don't know who.
We have
Robert
Roger
Bell.
Bell and Smith.
That's
Roger Bell.
Robert Bell.
Roger Bell.
Yeah, we can go to that one.
yeah.
We'll go to
Okay.
that one.
We'll proceed with Mr. Bell.
Is that the one with Fudger?
Fudger.
But it's the witness.
No, the witness is gone.
Well, and how are we going to proceed with that?
Well, no. I mean, that's what I'm saying. We cannot. We've just got to continue it. And
All right, let me see, Mr. Bill.
6.
It can't be item 6. See,
item 15.
Page 6.
oh, page 6.
Item 15.
There's
Are you Mr. Bill? All right, Mr. Bill, there was a witness here earlier in the day, and that's Mr. Fudger, and he is no longer available. Was he counsel for Mr. Bill?
Don't know. He just listed, on Rachel's note, listed as a witness. I'm not sure who.
Mr. Burnick, do you have any information regarding a Mr. Fudger who may have been subpoenaed in this case?
Your Honor, I've got that. He was the plea attorney.
He was a plea attorney? All right.
If you want me to try to get him on the phone, we can move on to something else, or I'm not sure what.
Okay. I'll tell you what, we're going to take 5 minutes and see if we can get in touch with Mr. Fudger.
Yes, sir.
And we'll see if we can proceed in Mr. Bill.
Excuse me, Judge.
Yes, sir.
I was already in process of asking of a continuing. So, because my attorney is not here today. I talked to him yesterday and he said he won't be here today, but if you need any questions to speak with him at 12 o'clock Friday.
Who is your attorney?
Mr. Mark Urich.
There's no, we've checked, Judge, there's no entry of appearance.
Okay, we don't have, I'm going to grant your motion to continue the case.
Yes, sir.
So it'll be continued for a few months, probably until June.
Yes, sir.
You need to get back in touch with that lawyer because there's nothing in the record that shows he actually represents you. I know you may have talked to him, but he hasn't.
Yes, sir.
He hasn't filed anything in court. So,
understandable.
So
okay.
this will give you time to do that.
Yes, sir.
All right.
Thank you, sir.
All right, your case is postponed. It's continued.
All right. Thank you, sir.
Thank you.
Your Honor, my system cut out on me, so I missed everything Mr. Bell said, but I'm surmising that he's asked for a continuance because he's looking into getting an attorney.
Yeah, he says he's consulted with somebody, but whoever it is has not filed an entry of appearance. And we've also lost the witness that you apparently subpoenaed, who I think was his plea counsel. So.
Yeah, I noticed that earlier that he was not here anymore.
Okay, well, I don't blame him. We've been here all day. So we'll continue that case and it'll be reset in the next couple of months.
Okay.
Oh. Next one, Miss Ellis, can we have Omari Smith, please?
Yes, sir. 1 second.
Is there a, there's no more witnesses? No more witnesses? Okay.
Amari Smith. Sir, oh.
Yes.
This is Amari Smith.
Okay, we're taking a break for a couple of minutes, but we'll be back.
Okay.
It was nice to have a witness like Mr. Bill. All right, at this time, the court calls case number 2020 HC 35. Omari Smith is the petitioner versus Alonzo Bobbitt, the warden. This is filed in the Superior Court of Tattnall County. Mr. Smith is before the court remotely. He is pro se. Mr. Smith, are you ready to proceed in your case this afternoon?
Sir?
Are you ready to proceed with your case?
I would like to ask for a continuance, but if not, yes, sir, I'm ready to proceed.
All right, well, tell me, is this the first time this case has been set for a hearing?
Yes, sir, this is the first time. I just did the petition, and prior to then, this is the first hearing that I've actually received.
All right, sir, well, I'll grant your continuance. This is the first time it's been set. It would be reset in about 4 months. You understand? You understand?
Yes, sir. Yes, sir.
All right, this is the first time it's been set for hearing. The court will grant the continuance. Any objection from?
No objection, Your Honor, just for the record.
Okay, there's no objection. So, Mr. Smith, we'll see you in a few months.
Thank you, sir.
All right.
All right.
We have William Jackson and Rogers. Georgia State Prison, you can disconnect.
Jacob, okay.
Yes.
Okay. I missed that one somehow.
All right, so yeah, Mr. Jackson.
Yes, sir.
All right, I'm going to go ahead and call the case. This is case number 2020 HC 37 in the Superior Court of Tattnall County. William R. Jackson, petitioner versus Brian Chambers, warden. Mr. Jackson is present remotely from Rogers State Prison. And Mr. Jackson, you represent yourself. I see that from the record. And are you ready to proceed this afternoon?
Yes, sir.
All right, and is the respondent ready, Mr. Crowder?
We're ready, Your Honor.
All right, there are no witnesses subpoenaed in this case, is that correct?
That's correct, at least from our side.
All right, then Mr. Jackson, raise your right hand, please. You swear or affirm the evidence you give before the court will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
All right, Mr. Jackson, I have your written petition, and I have all of the documents that are in the file. You have an original petition, and then you've amended your petition with additional grounds. So I do have all of that in the record. You don't have to read any of that to me, but I will give you an opportunity at this time to either offer testimony or evidence in support of your petition. So you may proceed.
Okay, Your Honor, if you can probably pull out the, my reply, petitioner reply to respondent's answer.
All right. I have that, sir. What do you want to tell me about it?
Okay, and the grounds and, will be in 2, that where I allege all of my grounds. And I just want to know, because I don't know, would that be automatically in the record in case of appeal?
Yes, sir. Everything you filed is in the record.
Okay, cause see, I don't, I guess I heard that if you don't mention everything in the record, that it wouldn't be on the record. And
all of the written pleadings are a part of the record.
yes, sir. Okay, so, one thing I would like to stress first is that I was, convicted and sentenced on an aggravated driving on revoked license in Illinois. Okay, I was on parole since granted parole 2010. The incident, and I was convicted and sentenced October the 7th, 2019 for driving on revoked license. Okay, after service of the 6 months, which was the month once I was released, was eligible to have my license, to get my license back. But upon leaving the institution, they tell me that the sheriff was coming and pick me up. And so I'm like, for what? They say you got a warrant for Georgia. And I'm like, for what? So, okay, they say I'll find out. As I wait, the sheriff informed them that he would not pick me up because of COVID-19. Hours later, I'm dressed to go out, go home, and an unmarked van picked me up. And I'm asking them, well, where's I'm going? I ain't seen a judge. I haven't had no type of extradition hearing. I have not waived extradition. So, and then, well, okay, I would need a chance to get me an attorney to see what's going on here. But then they tell me, well, you'll see a judge once you get to Georgia. And so now they done throw me in the van. And I think the only thing missing was a sackcloth over my head. I get down here, they put me straight in prison, and I haven't seen an authoritative person since then, and you are the only authoritative person I have seen for 11 months since I was released from a Illinois detention center for driving on revoked license. I've been revocated for parole. I haven't had no hearing. I haven't seen a parole agent. I haven't seen nobody except this court. And this is probably the only thing that I'm happy about since then, to be in front of a judge to hear my case. And I have alleged, I don't know, it's so much of writing and stuff that I'm so confused at what's going on. but I haven't had an extradition hearing, pre-extradition hearing. I got all the laws. I see that it favors me. Then when I get down here, no parole hearing. And I just get a letter today, them denying me until 2003 for parole. So, I mean, if I can continue, first, before I even do that, Your Honor, is I would like to ask the Attorney General, is that Mr. Crowder?
Yes, sir, but you can't ask him questions. He represents the warden in this case.
Okay, let me try it another way here. The questions that I have, it's about 5 or 6 of them, and they all have to do with documents. They all have to do with documents that has to show me, did I get any notices? Did I sign any waivers of any type of documents to give Georgia the authority to extradite me and the authority to just throw me in prison without a parole hearing?
You can't just come to court and just ask what they have. I will ask Mr. Crowder, are there any documents in the case that you intend to introduce?
There are.
Okay, and maybe it would be helpful if we allowed Mr. Crowder to go ahead and offer those documents. Maybe that would help you.
Yes, sir.
Mr. Jackson, so I'll let Mr. Crowder do that.
Yes, sir.
All right, because I do intend to cross-examine Mr. Jackson about some of the things in these documents as well.
How do you propose to proceed?
I can go ahead and introduce these now.
Okay.
And I'll bring them up on the screen. All right. Respondents 1 is the parole revocation order here in Georgia and the sentence from Illinois for the driving while license revoked charge that Mr. Jackson referenced earlier. Respondents 2 is extradition paperwork that includes an application for interstate compact transfer that Mr. Jackson executed apparently July 16th, 2014, in connection with a request to transfer his supervision to Illinois. Respondents 3 is the original sentence in Georgia for armed robbery in Gwinnett County that was imposed October 11th, 1988, as well as the indictment, or what looks, the indictment. Respondents 4 is the DOC sentence computation report that was created on January 9th, 2020. And respondents 5 is some additional paperwork on the extradition, including the warrant from Georgia that Mr. Jackson apparently was referencing earlier as well. So we would offer those at this time.
All right, and that's 1 through 5, is that correct?
Yes, Your Honor.
All right, Mr. Jackson, were you able to see those documents on the screen?
I seen them, but I mean, far as everything is said, no. But I think I can proceed.
All right, Mr. Jackson, you have a right to object to those documents. I'm going to admit them and make them a part of the record in this case. You're going to get copies of all those documents, but if you have any objection, let me hear it now.
Okay, well, I mean, I'll object to the 88 robbery because this is the only, what I supposed to be revocated for was supposed to be traffic. So when I paroled out 2010, 2000.
All right, sir, I'm going to let you testify in a minute. But I'm going to note that you have an objection. I'm going to overrule the objection, admit those exhibits. So they're in the record, but I'll let you go ahead and testify about them. You may proceed.
Okay, okay, in 2010, 2011, I was paroled, granted parole. Okay, and I mean, there's nothing violent about me. Once I did my time, that was it. So, but my thing is when they had the warrant out, what was the warrant for? Shouldn't the warrant had been for my violation for driving, or is the warrant for something else?
Sir, I can't answer that. It's part of the record. The document speaks for itself. I'm not allowed to explain it to you. I'm not here as your legal advisor. I have to decide the case. So I can't answer questions for you.
Yeah, I was just, what I was saying is, I overheard when they didn't want to set me in the maximum prison, they took me to Butts County Jail. And when I'm asked what I'm in there for, the guy said armed robbery. I'm like, huh? I ain't committing no armed robbery. So that's why I was asking about the warrant. If that was used, that would be null and void. Because I haven't committed an armed robbery.
Okay, again, sir, I can't answer that. That's your testimony, and I'm accepting your testimony.
Okay. The next thing I wanted to go with is that I had never received an out-of-state waiver of a preliminary and retaken an agreement to return. I never waived my right to that. And the only thing, and the father, as I think I listed as one of my grounds, the violation of the Extradition Act, which this act was enacted in the Georgia laws and has been accepted by the administrative rules with the parole board and Department of Corrections. And it states, the United States Supreme Court held that when a state requests an inmate through the interstate agreement on detainers, the inmate has the right to a judicial hearing in which the inmate can bring a limited challenge to a receiving state custody request. And then it goes on to say that the attached forms should be completed and notarized to ensure that the subject is aware of his right to challenge his return to the requesting state. None of this was done for me, Your Honor. Then I have you should have it as an exhibit, the out-of-state waiver and preliminary retaken hearing and the form. And that was to find out was there any cause to believe that I have violated any conditions of my parole. And then were there any documents presented as the basis for retaking properly issued? And does the Senate state officials have the authority to retake? None of this I never received. No notice, no hearing, which I alleged that as the 5th and 14th Amendment, my due process. And both of these, if you, I can give the numbers of the forms. One of them was Roman numeral 3, B07-0001, attachment 3. And the other one, Roman numeral 2, CO6-0001, which that's the interstate agreement on the China. I wasn't able to get a copy of that. So either of these forms, the board or the extradition officer, all they know about these forms, and none of this I never was notified or had a hearing on. The next thing, in Brown versus Grime, when the affidavit supporting the request for extradition shows no crime was committed, the affidavit is insufficient to sustain an extradition warrant. Now, from what I understand, under the Traffic Violation Bureau, that driving is really not a crime. Yeah, I guess, and it's to my understanding, a general violation or technical violation. I served 6 months. The Georgia come snatch me up. I've been in 11 months without a hearing to give the reason why they didn't have no understanding of them explaining. I didn't have nothing to say how they when they revoked my parole. And of course, in using Morrissey versus Brewer, that was the reason why it came out in 72. A written notice of the claim violations of parole. I didn't get that. B, disclosure to the parolee of the evidence against him. None of this I had. Of course, the opportunity to be heard in person and to present witnesses and documentary evidence, didn't get that. But I had a bunch of family members would have wanted to be there to explain because they know what happened. And D, the right to confront and cross-examine adverse witnesses. E, a neutral and detached hearing body. A written statement by the fact finders as to the evidence relied on and reasons for revoking parole. None of this I had not received. But according to Duncan versus Rickett, 232 Georgia 89, we had a parole board and traffic violations. In head note, I don't know if that means HN2, rather it mean head note 2, but it deals with entry pleas and guilty pleas of the parole board, which is a Georgia Code Annex Section 77-519, which provides in part that as soon as practicable after the arrest of person charged with the violation of the terms and conditions of his parole or conditional release, such parolee or conditional releasee shall appear before the State Board of Pardons and Paroles in person, and a hearing shall be had. But then it goes on to the second part where it discusses a conditional parolee or conditional release if he's convicted of any crime, whether felony or misdemeanor, pleaded guilty or whatever. But in the Georgia Supreme Court, in head note 3, private vehicles, traffic regulation, the Georgia Code Annex Section 24-312A and B in parentheses recites that any traffic violation under the jurisdiction of the Traffic Violation Bureau shall be characterized as a traffic violation and shall not be considered as a misdemeanor. Clearly then, it cannot be construed to be a felony. And the procedural due process, scope of protection, same court, Georgia Supreme Court, in the head note 4, the admission of guilt to a traffic offense under the jurisdiction of the Traffic Violations Bureau follows that the failure to hold such a hearing is a denial of due process of law. And the remand of the appellant to the custody of the respondent was error, since the conviction of traffic offenses under the jurisdiction of the Traffic Violations Bureau Act does not authorize parole revocation without a hearing as provided by the Georgia Code or the Parole Board's 77-519. And that case was heard again by the Georgia Supreme Court in 2003, and the court said the same thing, which was Gins versus State in 2003. So, Your Honor, what I'm saying is that it is that, let me find that right quick. Your Honor, as the amendment under the 14th Amendment, it is required under the U.S. Constitution Amendment 14 as due process require notice and a hearing before an administrative agency before any action may be taken to revoke. I haven't been, and so that's the issue that I'm having is that I was never heard through extradition. I have never been notified for all of the documents that Mr. Crowder has submitted. Why didn't I get any of them? I never got any of them, and it was months before. This was October when I got my habeas corpus filed.
All right, sir, I think I understand your position. You have put it in writing, and now you've told me verbally what your position is as to why you believe there was a denial of due process. I'll consider all of those claims. Is there anything else you want to tell me? I am going to let the Assistant Attorney General ask you some questions. But do you have anything else you want to testify about?
Well, it was one more thing, Your Honor, and I just found this today while I was waiting for my turn. And it's Plunkett versus Miller, old case.
You don't need to read me any law. I mean, all of the laws. The court is required to consider the law.
Okay.
And I've given you some latitude and allowed you to do that because I understand
Yes, sir.
you want to make your point. You've made that point, but you don't need to read me any more law. But if you want to testify to any other facts or evidence, I'll be glad to hear it.
Yes, well, the as far as everything that I have said, like I said, I allege kidnapping, false imprisonment, because all the things that has happened, and there is, I mean, in this country here, I mean, how can all of this be done without notice and a hearing? And they went as far as I find out today, I have a denial of parole and never was notified, had a hearing, or anything. And according to the Georgia Supreme Court, it's very clear. And so in my in my head, if I was not there, and you have a hearing to revoke, then that hearing or revocation should be null and void. And that's it, Jan.
All right, well, thank you, sir. Mr. Crowder, you have questions of the petitioner?
Just briefly, Mr. Jackson, you recall applying to have your parole transferred to Illinois in 2014?
Yes.
Do you recall signing a document to apply for that?
Really, I mean, I really don't remember it, but I dealt with the parole officer, and if she said sign something, I signed it. Okay.
All right. Did you read that document before you signed it?
I can't recall.
All right. That's all, Your Honor.
Okay, and does the warden have any evidence to introduce other than the previous exhibits are admitted and made a part of the record?
No, Your Honor, just those documents that are already admitted.
Okay. All right, well, Mr. Jackson, what will happen at this point is the court reporter will prepare a transcript of everything that took place today, all of your testimony, the exhibits, everything that has taken place in this courtroom and on this remote video will be made a part of a record. You'll receive a copy of that transcript. It will probably take a couple of months before you receive it. And once that happens, the court will review everything in its entirety and you will receive a copy of the court's decision. Do you understand?
Yes, sir.
All right, that'll close the hearing.
I think those are all, Your Honor.
Those are all the hearings?
I think so.
Yes, Your Honor.
Okay, well, we squeezed
Sir,
today.
I still have, I'm sorry. I still have Martavius Henry.
Chavis Henry.
We'll take a look and see.
His attorney, Stephen Rivas, submitted.
His attorney requested a continuance, and the case has already been continued until June.
Okay, and Tony Jacobs.
Same thing. Continue.
Same thing, another continuance.
Okay, thank you, sir. Y'all have a good evening.
You too. All right, Mr. Burnick, Mr. Crowder, I think that's it. Thank you, gentlemen. Have a good evening.
Thank you.
Your Honor, in terms of submitting the exhibits, I think it was mentioned with one of Mr. Zell's hearings about an email that would be coming out. Do you want us to just handle that the same way in terms of submitting our exhibits to the court reporter, or how do we need to do that?
I'll email you, Mr. Crowder. I'll send you the email address.
Our staff attorney is going to send you an email.
Okay.
All right.
All right. Thank you, gentlemen. Have a good evening.
You too.